South Central online.
I'm gonna pin them all for you.
All right.
Once I get everybody good.
I see him off to the side there. All right, so Highlands, can you hear me? You're muted.
Yes, Your Honor, I can hear you.
All right, Hardy, can you hear me?
Yes, Your Honor.
All right, thank you. South County, can you hear me?
Yes, sir, we can hear you.
And Central, can you hear me?
Yes, sir, we can hear you.
All right, I'm gonna read the colloquy all at one time to everybody. Everyone listen up, this is your first appearance hearing. First appearance hearings have 4 purposes and 4 purposes only. First of all, I'll tell you the charges that have been filed against you. Second, I'm going to talk to you about whether you're going to hire a lawyer or whether you want to see if you qualify for a court-appointed lawyer such as the public defender. If you want to hire your own lawyer and you want to continue the hearing so you can have the lawyer present, I'll be glad to do that for you. You could also choose to go forward with the hearing and bring the lawyer in later at a different date. If you want to see if you qualify for the public defender's office, I have to determine if you're eligible by asking some questions about your financial circumstances. If you want to hire a lawyer, it's your responsibility for contacting your lawyer and making sure they know of your court date. No one else will do that. You do have a right to have an attorney present before and during any questioning. Third purpose of this hearing is to determine probable cause to decide if there's probable cause for your arrest. And the last purpose is to review your bond and other pretrial release conditions to determine if any changes are necessary. Be aware if the court places you on pretrial release today, regardless of whether it is straight pretrial release or has conditions that are announced in court, those conditions go into effect today, regardless if you're still in custody, meaning even though you haven't bonded out yet, the conditions are immediately in place. Throughout this entire process, you have a constitutional right to remain silent. If you choose not to remain silent, anything you say can be used against you. Everything that is being said where I am located, as well as where all of you are located, is being recorded. There is also an assistant state attorney present listening to everything being said. Do not say anything about the crime itself. Keep these rights in mind as we go through this process. I also want to swear everybody in at this time if they haven't been sworn in. Everybody raise your right hand.
Everybody stand up. All rise. Stand up, raise your right hand.
Everybody, that includes Hardy as well. Do you swear or affirm to tell the whole truth and nothing but the truth? Answer by saying I do.
So you may be
All right,
seated.
great.
Don't see her.
All right.
Yeah, Aniston.
Yes, anybody say something?
Hardy's one case requires the assistance of the interpreter, Your Honor.
All right. We'll do the interpreter now. We got Hardy online. Let's do it.
Good morning, Your Honor.
Let's see, who's the Hardy County case? Jose
Jimenez.
Davila.
Señor, adelante.
Hold on, I can find it.
What's his name? I don't know. I got, it says Jose Davila.
No, Your Honor. For today, we have Jimenez Roman Guadalupe.
You're the only one in Hardy.
I believe
right?
that was yesterday.
This is all yesterday's paperwork. Okay. So I need,
I'll go get it.
no, okay. Yeah, I don't have it. Okay, hold on. We got to track down the paperwork.
Yes, Your Honor.
I don't know where he did. I don't know what he did with it.
I have it to your left, Your Honor.
Okay, we got it. We can do it. All right, let's see. This is Guadalupe Jimenez Roman,
Guadalupe Jiménez Román, pase adelante, por favor.
charged with operating a motor vehicle without a driver's license.
Se le acusa, señor, de manejar un vehículo sin licencia de conducir.
You are entitled to a lawyer.
Usted tiene derecho a tener un abogado.
Are you going to hire a lawyer, or do you want to see if you qualify for a court-appointed lawyer?
¿Va a contratar usted a un abogado privado o quiere ver si usted llena los requisitos para que el juez le nombre un abogado de oficio? Public defender.
Do you have any source of income?
Señor, ¿usted tiene fuente de ingreso? ¿Trabaja?
Sí,
Yes.
How much do you bring home per week?
¿Cuánto gana usted a la semana?
700,
700.
Do you have any minor children you support?
¿Tiene usted niños menores de edad que usted mantenga?
yes,
How many?
¿Cuántos?
3,
3.
Appoint the public defender.
Le nombro entonces un abogado de oficio.
Find probable cause.
Encuentro motivo fundado.
Can't tell if he has a bond or not.
No veo no puedo ver si tiene una fianza o no tiene. Algo así, ¿usted sabe?
Well, the docket says $250.
Okay, yeah, I just don't have it. All right, bond set at 250, leave it as set.
La fianza ya está fijada en 250. ¿La dejamos así?
Thank you.
Gracias, señor. Ya terminó.
All right, that's it for Hardy.
gracias.
Thank you.
All right, let's go to Highland. Well, does anybody in Highlands need, let me just get Highlands out of the way, Madam Interpreter, because there's only 4 of them there.
That's fine, Your Honor.
No
All
one
right.
needs an interpreter, Your Honor.
No one does? All right. Let's see. All right. Highlands, I need Jaden Duffy. Charged with battery by strangulation. You have a right to a lawyer. You're gonna hire a lawyer. You want to see if you qualify for a court-appointed lawyer.
Public defender.
Do you have any source of income?
Yes, sir.
How much do you bring home per week?
Probably like 600 every 2 weeks.
Appoint the public defender.
They are not on the list.
Find probable cause. Looks like he's probably held without bond. State, you want to be heard?
Here, the state would ask for a $5,000 bond and no weapons and no contact as conditions.
Madam Public Defender.
I would ask that he be allowed to go back one time to the residence to get his personal belongings.
All right, $5,000 bond. If he bonds, he's on pretrial release. No contact with the victim, no weapons or firearms. Can return to the property one time with the assistance of law enforcement to gather his personal belongings.
And Your Honor, he does have an open case, CF 25-845.
All right, based on Parker v. State, revoke the bonds in that case number. Hold him no bond.
Your Honor, what was that case number again?
I've got CF 25-845.
I would ask for our office to be appointed unless he already has an attorney on that case.
All right. Well, we're going to appoint the public defender on that case unless somebody already represents them.
He's got Derek Christian.
He's got what?
Derek Christian. Okay.
Okay, already.
Mr. Christian, public defender?
Yes.
Yeah.
No, I didn't know that. Okay. All right. Okay, thank you. Moving on. Let's see. Who's next? Robert Michael Gaffney. All right, he's got a battery. It's like domestic violence. He's filled out the paperwork requesting a public defender. Here's to be eligible, appoint the public defender. Find probable cause. He's currently held without bond as well. State.
On the new charge, we would ask for $5,000 bond and no weapons and no contact as conditions. He does have an open case, MM 2635. Looks like he was out on bond on that one. So it was a first appearance back in January.
Revoke the bonds in that case, the misdemeanor case pursuant to Parker v. State. In this matter, set bond at $5,000. He bonds out, he's on pretrial release, no contact with the victim, no weapons or firearms, cannot return to the property except with the assistance of law enforcement on one occasion to gather his personal belongings. Thank you. Trinity Madrugo.
Is that Sharita Stout?
Oh, okay, thank you, I forgot.
All right, Ms. Madrugo's here. She's charged with battery, domestic violence. Looks like she's requested the public defender, filled out an application, appears to be eligible. Appoint the public defender. Find probable cause. She's currently held without bond. State, you want to be heard?
If the state would ask for $5,000 bond and no weapons and no contact as pretrial release conditions.
All right. Ms. Smith, you want to ask, you want the same about the...
I defer the court and be able to go back one time for bond petition.
All right. $5,000 bond, no contact with the victim, no weapons or firearms, can return to the property one time with the assistance of law enforcement to get her personal belongings. Ladies, Selena Rivera. Looks like she's here, contempt of court, violation of an injunction, possession of a weapon. I can't tell exactly what these are. It's all looks to be like violations of injunctions. Is this a weapons charge as well? Looks like it. I don't know.
Yes, sir, it looks like possession of weapon after an injunction.
Stalking, possession of firearm. I got you. All right, so that's, okay. All right, so you have a right to a lawyer. She filled out an application for criminal indigent status, seeking the public defender. She appears to qualify. Appoint the public defender. Find probable cause. Doesn't appear to have a bond. State, you want to be heard?
The state would ask for $5,000 per count and no weapons and no contact as conditions. She's got 3 open cases, but I can't tell if, it looks like she may have been out on bond on MM 26294, but I can't tell for sure.
All right, defense, you want to be heard?
I would just point out that she's over 80 years old. I would just ask for reasonable bonds on these charges.
$5,000 each count. Thank you. All right, that looks like it for Highlands.
Your Honor, you want to set any conditions for her or no?
She no firearms, no weapons. Must adhere to the terms of the injunction. No contact with the person that's in the injunction who she's prohibited from having contact with. Those are all pretrial release conditions in addition to the injunction.
Your Honor, it looks like the 3 open cases are all summons cases from what I can tell.
All right, thank you. All right, thank you, Highlands. Have a good day.
Thank you, Your Honor.
All right, I guess let's figure out where were the interpreter cases? Central or south?
Central.
All right. All right, let's do the interpreter cases. I guess they're all in Central. Deputy, you'll have to let us know who they are if you can.
Yes, sir. The first one we have is Diaz Domenici.
Bueno, ya me toman, pasa al frente.
Dominici Diaz, or Luis Diaz Dominici. All right, he's charged with resisting an officer without violence, domestic violence, battery. It looks like a child support DRD pickup as well.
El señor Díaz, Dominici, Luis Ángel, tiene 3 cargos: resistirse a un oficial sin violencia, tiene un cargo de violencia intrafamiliar, agresión física, toque o golpe, y tiene un DRD, que es un caso de pagar manutención de menores.
You're entitled to a lawyer,
Señor, tiene derecho a tener un abogado,
only on the new criminal offenses.
únicamente en los nuevos delitos penales que usted tiene.
You're gonna hire a lawyer, or you want to see if you qualify for the public defender?
¿Va a contratar usted un abogado privado o quiere ver que el juez le asigne un abogado de oficio?
Un abogado de oficio.
El public defender.
Do you have any source of income?
Señor, ¿tiene usted fuentes de ingresos a trabajo?
No.
No.
Point the public defender.
Voy a asignarle entonces un abogado de oficio.
Find probable cause.
Encuentro motivo fundado.
Bond set on count 1 at 1,000, leave as set.
La fianza ya está fijada en el cargo número 1 como $1,000. La dejo igual, $1,000.
Count 2 currently set at no bond.
El cargo número 2 en este momento no tiene fianza.
State, you want to be heard.
Fiscal, ¿desea ser escuchada?
And the state would ask for a $5,000 bond with no weapons and no contact as pretrial release conditions. And then I think on the DRD, there's a $1,000 purge.
Yeah, I can't see the DRD.
La fiscalía solicitaría una fianza de $5,000 y una estipulación de no tener armas ni tener ningún contacto como condición de libertad previa a juicio. Creo que en el DRD tiene una purga de $1,000. No veo el DRD.
Actually, now I can see the DRD.
Ahora sí puedo ver el DRD.
There is a $1,000 purge.
Hay una purga de $1,000.
Leave that in place.
Vamos a dejarla igual.
On count 2, set bond at 5,000.
En el cargo número 2, fijo la fianza en $5,000.
If he bonds out,
Si el señor sale bajo fianza,
you still have no contact with the victim,
no puede tener ningún tipo de contacto y comunicación con la víctima,
no weapons or firearms.
no estar en posesión de armas de fuego, armas en general.
He can go back to the property one time with law enforcement to get his personal belongings.
Y puede regresar una sola vez a la casa, a la propiedad donde vivía, acompañado de un oficial de la ley para recoger sus efectos personales.
Thank you.
Gracias.
All right, who else do we have?
Next is Chavez Mendez.
All I heard was Mendez. What is the last name?
Chavez
Chavez.
Mendez.
Chavez.
Gregorio Chavez Mendez.
Thank you.
Looks like he's got a no valid driver's license.
Parece que él tiene un cargo de no tener licencia válida de conducir.
You have a right to a lawyer.
Tiene derecho a tener un abogado, señor.
You're gonna hire a lawyer, or you want to see if you qualify for the public defender?
¿Va a contratar usted un abogado privado o quiere que el juez le asigne un abogado de oficio?
Abogado de oficio.
Public defender.
Do you have any source of income?
¿Tiene usted trabajo, fuente de ingresos?
Sí.
Yes.
How much do you bring home per week?
¿Cuánto gana usted a la semana?
750.
750.
Do you have any minor children you support?
¿Tiene usted niños menores de edad que usted mantenga?
Sí.
Yes.
How many?
¿Cuántos?
4.
4.
Appoint the public defender.
Voy a nombrarle entonces un abogado de oficio.
Find probable cause.
Encuentro motivo fundado.
Currently held without bond, not sure why.
En este momento se le retiene sin fianza, no estoy seguro por qué.
It's probably immigration status. The state would ask for $1,000 bond at this point right now.
Probablemente es por su estatus o situación migratoria. La fiscalía solicitaría una fianza de $1,000 en este momento.
Set bond at 1,000.
Fijo la fianza en $1,000.
Okay.
Doesn't
Yes.
show an ICE, doesn't show an ICE. There is-
Aquí no aparece ninguna orden de retención de ICE.
I don't see anything up front, so.
¿Puedo hacer una pregunta?
So I'm
Can
not
I
gonna
ask-
address that.
Y yo no veo nada tampoco. Can I ask a question?
Yes.
Sí.
Necesito un número de sacar de mi teléfono para poder hablar, porque no tengo con nadie hablar de aquí.
I would need like a number or a telephone because I don't know. I cannot speak to anybody here.
I can't help you with that, sir. You need to have your family post a bond if you want to get out.
Señor, yo no puedo ayudarle a usted con eso. Sería necesario que su familia depositara la fianza si usted quiere salir.
Okay.
All right, thank you.
Ok, gracias.
Next is Lee Daniel.
Lee, Daniel.
You can do it. You can do it. Except the signature keeps coming out different. All right, let's see, this person looks like they got a warrant out of North Carolina, fugitive warrant.
Creo que para este señor hay una orden de arresto dictada desde Carolina del Norte como fugitivo.
You're entitled to a lawyer.
Usted tiene derecho a un abogado.
You want to hire a lawyer, you want to see if you qualify for the public defender's office.
Señor, ¿va a contratar usted un abogado privado o quiere ver si el juez le puede asignar un abogado de oficio?
Un abogado de oficio.
El public defender.
All right, he's not going anywhere, so appoint the public defender. He'll lose whatever job he has if he has one.
Él no va a ir a ninguna parte ahora, de manera que le voy a nombrar un abogado de oficio. Él va a perder su trabajo si él tiene uno.
Can't do anything except move him over to June 8th and see if what's going on with North Carolina, picking him up.
Muy bien, no puedo hacer nada más con el caso de él, simplemente voy a programarlo para el 8 de junio para ver qué es lo que está ocurriendo con Carolina del Norte, si van a venir a recogerle.
Okay.
Thank you.
Ok.
Next is Sepulveda.
Jose Sepulveda,
Yes.
charged with possession of drug paraphernalia, possession of methamphetamine.
Señor, se le acusa de dos cargos, un cargo de posesión de parafernalia para la droga y otro cargo de posesión de metanfetamina.
You have the right to a lawyer.
Usted tiene derecho a tener un abogado.
You're going to hire a lawyer, you want to see if you qualify for a court-appointed lawyer.
¿Va usted a contratar un abogado privado o quiere ver si el juez puede asignarle un abogado de oficio en su caso?
Abogado de oficio, por favor.
Please, a public defender.
Do you have any source of income?
¿Usted tiene alguna fuente de ingreso, trabajo?
En estos momentos no.
Not right now.
Appoint the public defender.
Voy entonces a nombrarle un abogado de oficio.
Find probable cause.
Encuentro motivo fundado.
Bonds are set 1,000 count 1, 5,000 count 2.
La fianza se fijan $1,000 para el cargo número 1, $5,000 para el cargo número 2.
Leave those as set.
Vamos a dejarla como están fijadas ya.
Thank you.
Gracias, señor.
Our last one is Velez Arias.
All right, Geraldine Velez Arias,
Geraldine Vélez Arias.
charged with domestic violence battery.
Se le acusa de violencia intrafamiliar, agresión física.
You have the right to a lawyer.
Usted tiene derecho a tener un abogado.
Are you going to hire a lawyer, or do you want to see if you qualify for the public defender?
¿Va a contratar usted a un abogado privado o quiere ver si el juez puede nombrarle un abogado de oficio?
Abogado de oficio.
El public defender.
Do you have any source of income?
¿Tiene usted trabajo, una fuente de ingresos?
Esporádicamente hago Uber cuando puedo porque tengo un niño chiquito.
Okay, un momento. I work now and then. I do Uber because I have small kid.
Point the public defender.
Voy a asignarle un abogado de
¿Puedo
oficio.
agregar algo?
May I add something?
No, ma'am.
No, señora.
Find probable cause.
Encuentro motivo fundado para el cargo.
Currently held without bond.
En este momento está usted sin fianza.
State, you want to be heard.
Fiscal, ¿quiere ser escuchada?
And the state would ask for $5,000 bond and no weapons and no contact as conditions.
La fiscalía solicitaría que se le fije una fianza de $5,000 y también que se estipule que no puede portar armas ni tener contacto.
Ms. Smith, you want to be heard.
Señora Smith, ¿quiere ser escuchada?
I defer to the court regarding the bond, but would ask that she be allowed to go back one time with law enforcement to get her stuff out of the house.
Entonces lo dejo a discreción del juez en relación a la fianza, pero solicitaría que se le dé permiso de regresar una vez a la residencia acompañada de un policía para recoger y sacar sus cosas personales de la casa.
Set bond at $5,000.
Fijo la fianza en $5,000.
If she bonds out, she's to have no contact with the victim.
Si ella sale bajo fianza, no puede tener ningún tipo de contacto y comunicación con la víctima.
No weapons or firearms.
No puede portar armas en general, armas de fuego.
Can return to if they share the same residence, can return there one time with the assistance of law enforcement to get her personal belongings.
Y si ella comparte la residencia con la víctima, ella puede regresar una sola vez a la residencia acompañada de un policía para recoger sus efectos personales.
Thank you.
Gracias.
All right, before I go over to South, Ms. Schilling, did you have something?
Yes, Judge, it's a little bit more complicated. It's a case from yesterday that was pushed over to today, but it didn't make the docket for some reason, and we can't find the order from yesterday. I did have her brought, if you were.
Sorry.
Yeah, no problem.
I found the order from yesterday and I amended it to today's information. So
Okay.
you have the order.
All right, so who is this person that we're
This
talking?
one, Judge.
The first name is Yoseline, Youseline, last name Aniston, Anastin.
All right, we were going to bring her to that today because she needed a Creole interpreter and did not have one available.
Oh, is that why she was brought back?
That's what happened. Remember that.
Well, I'll go ahead and waive her appearance then so that she can get, unless we have a Creole interpreter on the line.
Madam Interpreter, did we get a Creole interpreter for today?
He's scheduled, Mr. Moise is scheduled to appear today, but I don't see him online yet. But he said he was going to be.
He usually logs in about 9 o'clock or so.
Yeah, he usually logs in at 9.
You want to wait?
Yeah, I'll wait around.
Okay, because we did a co-defendant on her yesterday, I remember as well.
Yep, if you remember the case, then I don't mind proceeding without her and waiving her appearance. It's up to you, Judge.
Fletcher, I gave the information to Rivera.
Let's just wait.
Oh, no problem.
Okay, we didn't have a location for her, so I don't know that she's been called yet.
Yeah, I got Charlie 14, I'm looking for her.
All right, we'll pass on her. All right, let's go to South.
Your Honor, may the interpreter, Spanish interpreter be excused?
Yes, ma'am. Thank you, Madam Interpreter.
You're welcome, Your Honor. Have a nice day.
You too.
First went South, last name Acosta, first name Lionel.
Sandra Smith, Flood Defender's Office. I do want to waive the reading of his 3 third-degree felony charges.
All right, Mr. Acosta, you know what you're charged with?
Yes,
You gonna hire a lawyer, or you want to see if you qualify for a court-appointed lawyer?
appointed lawyer.
Do you have any source of income?
Well, while I'm here, no. But I
Well,
work,
while you're not here, do you have a source of income?
I work.
How much do you bring home per week?
Every 2 weeks, I bring home like 800.
Point the public defender. This is an arrest warrant, find probable cause, currently held without bond. State, you want to be heard.
The state would ask for $7,500 per count, and then the pretrial release conditions are on the warrant of no weapons and GPS monitoring.
All right, Vince?
I would ask for a presumptive bonds of $5,000 per charge, and I would note that the judge already signed an arrest warrant with a couple conditions.
All right. Set bond 7,500 per count. If he bonds, he's on pretrial release, must be on a GPS monitor, cannot have any firearms, weapons, or ammunition. All right, thank you.
Adder Holt, first name Kane.
All right, looks like you're charged domestic violence, aggravated assault. You're entitled to a lawyer. You're gonna hire a lawyer. You wanna see if you qualify for a court-appointed lawyer.
I'll hire one, Your Honor.
You want to continue this hearing so you can hire your lawyer, or you want to go ahead and deal with it today and bring the lawyer in later?
I'll hire them later.
Okay. Let's see. Finding probable cause, currently held without bond. State, you want to be heard?
And the state would ask for a $5,000 bond and no weapons and no contact as conditions.
Pretty serious. I'm going to set bond at $10,000. If he bonds out, he's to have no contact with the victim, can have no weapons or firearms. I don't know if they reside together. I'm not really sure. Doesn't.
They have the same address.
Do they? All right. They reside in the same household. You can go back one time with the assistance of law enforcement to get personal belongings only. Thank you.
Last name Adorno, first name Noel.
All right, charged with DUI, refusal to submit to a breathalyzer. You have a right to a lawyer. You're gonna hire a lawyer? You wanna see if you qualify for a court-appointed lawyer?
Court-appointed lawyer?
You have any source of income?
No, sir.
Appoint public defender. It's like actual physical control case. Find probable cause. Bonds are set at 1,000 per count. Too low. Count one, raise the bond to 5,000. Counts two, leave as set. If he bonds out, he's prohibited from possessing alcohol, going to any bars or liquor stores. No driving without a valid driver's license. Thank you.
Last name Ben, first name Tavis.
Charged with misdemeanor possession of cannabis, possession of paraphernalia, possession of methamphetamine. You have a right to a lawyer. You're going to hire a lawyer? You want to see if you qualify for a court-appointed lawyer?
Court-appointed lawyer?
Do you have any source of income?
No, sir.
Appoint the public defender.
No.
Find probable cause. Bonds are set already. 1,000 count one, 1,000 count two, 5,000 count three. Leave as set. Thank you.
Last name Boynton, first name Marcus.
Consent to go, is in jail.
Charged with domestic violence battery. You have a right to a lawyer. You're going to hire a lawyer? You want to see if you qualify for a court-appointed lawyer?
Court-appointed?
Do you have any source of income?
Yes, sir.
How much do you bring home per week?
Around 300.
Appoint the public defender. Find probable cause. Currently held without bond. State, you want to be heard?
The state would ask for $5,000 bond and no weapons and no contact as conditions.
Set bond at 5,000. No weapons or firearms, no contact with the victim. Looks like they reside together. He can go back one time with the assistance of law enforcement to get his personal belongings. Thank you.
You can do one? Yeah. Thanks.
Last name David, first name Brian.
Charged with petty theft, burglary, and burglary of an occupied structure. You have a right to a lawyer. You're going to hire a lawyer? You want to see if you qualify for a court-appointed lawyer?
Public defender.
You have any source of income?
No, I'm trying to get into a rehab treatment center at the point.
Appoint the public defender's office. Find probable cause. Currently, let's see, there's a bond set of $250 on count one. Leave that as set. It's got no bond on the burglary. Any reason why? State.
I think It's an F2, so there's no bond until first appearances, but the state would ask for a $10,000 bond at this point.
Ms. Smith?
I defer to the court.
10,000 on count 2. Thank you.
Next one, last name Cruz, first name Darren.
Charged with leaving the scene of a crash involving property damage, DUI, driving license suspended, refusal to submit to a breathalyzer. You have a right to a lawyer. You gonna hire a lawyer, or you wanna see if you qualify for a court-appointed lawyer?
I'm gonna hire a lawyer.
You want me to continue this so you can have your lawyer present? You wanna go ahead and deal with this today and you can get the lawyer involved later?
I'll continue and get the lawyer involved later, Your Honor. Thank you.
All right, sounds like he wants to do it today, bring the lawyer in later. All right, let's see what we got. This looks like an actual control case. Yeah. All right. All right, finding probable cause. These bonds are too low. Set bond 5,000 on each count. If he bonds out, he's on pretrial release. No alcohol, no bars, cannot drive, period. No, don't care whether he gets a permit or not. This is a third, cannot drive. Thank you.
Last name Gilroy, first name Daniel.
All right, burglary with assault or battery, resisting without violence. You have a right to a lawyer. Gonna hire a lawyer? You want to see if you qualify for a court-appointed lawyer?
Gonna hire a lawyer and I will continue here today, sir.
You want to go forward today, bring the lawyer in later. Is that what you're telling me?
Yes, Your Honor.
All right. Yeah, I signed the warrant on that. All right, finding probable cause, currently held without bond on count 1, 1,000 on count 2, leave 1,000 on count 2 set. Count 1, state, you want to be heard?
Yes, sir. It's currently charged as an F1 punishable by life, so the state would ask for that to remain at no bond at this point.
Sandra Smith with the Public Defender's Office. I would ask that a bond be set. This is involving a vehicle, involving an officer who's in a vehicle. And
Yeah, I'm familiar with it. I saw this last night.
I think it's a vehicle, it's, that a bond should be set in this.
This is a strange scenario. I wasn't really clear what was going on with it.
It's alleged that he pushed some paperwork into the vehicle.
Right, but it doesn't say that he's an authorized process server or anything like that. He said he's supposedly trying to serve him with lawsuit paperwork. Yeah, something strange. I'll set bond 25,000. Thank you.
Last name Howard, first name Clarence.
Clarence Howard, failure to appear, camping restrictions, the capias. Is this a ordinance?
Yes, municipal ordinance.
All right, you're entitled to a lawyer. You can't have the public defender, but they have lawyers in private practice to contract for this work. You want a lawyer, we'll talk about appointing you a lawyer. The other option is you could enter a plea of guilty at this time for a $108 fine. And then
I would enter a plea of guilty, Your Honor.
All right, when you enter a plea, you're gonna give up the right to a trial. Do you understand that?
Yes, Your Honor.
All right. Accept this plea of guilty, sentence him to $108 fine.
Does that mean I'm released from custody, Your Honor?
Sorry, say it again, sir.
Does that mean I'll be released from custody today, Your Honor?
You'll be released today. I'm gonna give you 60 days to pay your fine.
Thank you, Your Honor.
All right, thank you.
Last name Jones, first name Shamari.
That's okay. All right, Shamari Jones, charged with, got a warrant out of Volusia County, and then as resisting without violence, domestic violence, tampering with a felony, third degree, domestic violence, simple assault, resisting with violence. You have a right to a lawyer. You gonna hire a lawyer, or you wanna see if you qualify for a court-appointed lawyer?
Court-appointed lawyer, sir.
Do you have any source of income?
Yes, sir. I'm a Amazon driver.
How much do you bring home per week?
Like 750.
Do you have any minor children you support?
Yes, sir.
How many?
2.
Appoint the public defender.
Okay, none of the always wrongs in the land of Martinez. He's charged with a felony DWI, but, this is all that makes sense. And then he charges him, which is a simple one.
Finding probable cause, currently held without bond, can't help you on the violation warrant out of Volusia. That stays as a no bond hold, waiting for Volusia.
Yes, sir. Can I say
Hold on,
something?
don't talk.
Yes.
Stay if you want to be heard on these bonds.
So on the BOP, we would ask for that to remain no bond. On the resisting, we'd ask for $1,000. On the battery, we'd ask for 5,000. Tampering, we'd ask for 5,000. The assault, we would ask for 1,000, and the resisting with violence, we'd ask for 5,000, and then no weapons and no contact as pretrial release conditions.
All right, set bond 1,000 count 2, 5,000 count 3, 5,000 count 4, setting bond 5,000 count 5, this is count 6, $10,000. If he bonds out, he's to have no contact with the victim, no weapons or firearms, cannot return to any shared residence with the victim except with law enforcement one time to get his personal belongings. Thank you.
Yes, sir. Can I say something, Your Honor?
No, sir, not a good idea to talk at this point in time.
Yes, sir. Thank you.
Thank you.
Last name is Marez.
Marks.
First name Justin, M-A-R-E-C-Z.
Justin Marez, petty theft. Let's see, you have a right to lawyer. Are you gonna hire a lawyer? You wanna see if you qualify for a court lawyer?
Public defender, please.
You have any source of income?
No, sir.
Appoint the public defender. Find probable cause. Bond set at 5,000, leave it as set. Thank you.
Last name Santiago, first name Julius.
Sanders Smith, Defender's Office, Your Honor, I have a stipulation with the state regarding one of his charges that there's no probable cause and he should be released on his own recognizance on one of the 2 resisting without violence charges.
All right, are these add-on charges?
Yes,
Is the public defender already on the case?
I don't know, Your Honor, I apologize. He's in jail on a VOP, I believe. I don't know if we represent him on that or not.
Your Honor,
You have a lawyer representing you, sir?
No, I do not. I have a public defender for my my violation of probation, but I'm confused on how did I get resisting violence? How did I get a charge of resisting violence?
Sounds like the public defender's already on the case, so we'll show the public defender representing him. Let's take a look at the PC affidavit. All right, there's probable cause for one by agreement. There is not probable cause on the other. So we'll ROR him on the second one. And on count 1, we'll set bond. What statement have you heard?
Your Honor, we would ask for the $1,000 bond is fine, because I think he's no bond on the BOP that he's already in custody on.
Set it as 1,000.
Can my lawyer come see? Can my public defender come see me as soon as possible, please?
I'm sure you're on the schedule. They'll see you as soon as they can. Thank you.
Thank you. Have a blessed day.
Last name Spencer, first name Theodore.
All right, Mr. Spencer's here, charged with false identification of law enforcement, possession of drug paraphernalia, possession of cocaine, failure of career offender to register. That's what it says on the sheet, but is it on the PC affidavit?
I
That
think
is an
that was
arrest
the
warrant.
warrant. He was the bring back from yesterday because he hadn't been served with the warrant yet.
All right, so there's a warrant for the failure to appear. All right, you gonna hire a lawyer? You want to see if you qualify for a court-appointed lawyer?
I need a lawyer, sir.
All right, do you have any source of income?
Just Social Security right now.
Point to public defender.
Okay, thank you, sir.
Find a probable cause.
Yes, sir.
All right, it's currently held without bond. Any reason why, state?
I think it was because that warrant was outstanding and it was no bond until first appearances on the warrant. So for the 2 misdemeanor charges, the state would ask for $1,000 per count, and then the 2 felonies, we'd ask for $5,000 per count.
1,000 count 1, 1,000 count 2, 5,000 on 3, 5,000 on 4. This warrant has pretrial release conditions. Defendant cannot possess any firearms, weapons, ammunition, or knives. Can only be released on a GPS monitor. Thank you.
Okay.
Last name Villa, first name Jose.
Morning, Your Honor.
Good morning, sir. You're charged with, these are add-ons, no, what the heck is this?
It's,
Says aggravated assault, deadly weapon, trespass. There are capiouses out on these. Must have an existing case.
yes, sir, I think it was the amended charges on the information.
All right. Are you represented by a lawyer or the public defender's office, sir?
Public defenders.
The public defender's already on the case. Believe that. Point them on this matter or these charges as well. And let's see, since there's a capious, we'll find probable cause. Currently held without bond. State, you want to be heard?
Yeah, the state would ask for $5,000 on the aggravated assault and $1,000 on the trespass, and then we ask for no contact and no weapons as conditioned.
All right, let's see, 5,000 on domestic violence, aggravated assault, 1,000 on the trespass. If he bonds out, no contact with the victim, not return to the property except with the assistance of law enforcement to obtain any personal property, can possess no weapons or firearms whatsoever. All right, thank you.
Thank you for your time.
That's all we have in South County.
All right, thanks, Deputy. Have a good day.
And the Creole interpreter is on, and they have that lady up.
All right, so let's go to Ms. Schilling's case. That was the lady who needed the Creole interpreter, Yuseline Aniston.
Yuseline Alistel.
All right, ma'am, you're charged with littering on private property over 500 pounds.
Monsieur, madame plutôt, yo accusé ou que vous avez jeté détritus dans une propriété privée plus que 700 livres.
Ms. Schilling, you're going to be representing her.
Vous avez un avocat qui peut le représenter.
Yes, Judge.
Oui, juge.
All right. Saw this affidavit yesterday and found probable cause for the co-defendant. Let me take a look at it today.
Moi, j'ai regardé affidavit hier, moi, je joins que gagné bon genre accusation pour accuser.
Finding probable cause.
Moi, je joins que gagné cause probable.
Currently held without bond.
Qu'on y a là aucun bien sans bon.
We set bond on the co-defendant yesterday.
Nous te mettons bon pour l'autre accusé hier.
You have any idea what we did?
We did 5,000 because it's an F3, yes.
Yeah. All right. You want to be heard, Ms. Schilling?
No, Judge.
Set bond at 5,000 on this defendant as well.
Nous mettons bon les cautions $5,000 sur accusé, ça a tout.
Thank you.
Thank you so much.
Have a good day, Ms. Schilling.
Denby, thank you so much.
All right, let's go to the females.
Your Honor, I apologize. This is the Creole interpreter. Are there any other cases?
No, sir, I think that was all we needed. Thank you for appearing.
Thank you, Your Honor. You have a good day.
You too. All right, let's see who's up first.
Your Honor, are you wanting us over at Central to call them?
If you don't mind, it's easier for us.
Cerullo?
Sorry.
Sanderson.
Cerullo.
I have a stipulation with the state on the second charge on the docket, the possession of controlled substance without a prescription is a duplicate charge. That on that one charge, there is no probable cause, and she should be releasing her own recognizance on that case, on that one charge. And that was only stipulation.
That's correct, Your Honor, as to that charge.
It's the felony possession of controlled substance.
All right, so ma'am, you're charged with possession of drug paraphernalia, possession of drug or controlled substance without a prescription, possession of oxycodone, possession of midazolam, possession of MDMA, possession of fentanyl, and a second charge with possession of prescription drug without a prescription. You have a right to a lawyer. You're gonna hire a lawyer, or you wanna see if you qualify for a court-appointed lawyer?
I'll probably hire a lawyer.
You want me to deal with this today, or you want me to continue it so your lawyer can be present?
Just deal with it today.
All right, based on the stipulation, we'll show the second count of possession of prescription drug, no probable cause and ROR on that. Let me take a look at the rest of it. All right, finding probable cause, currently held without bond. Any idea why?
I think it's based on prior history. I didn't see anything that was open. The state would ask for, on the misdemeanors, we'd ask for $1,000 per count, and then on the felonies, we'd ask for $5,000 per count.
All right. $1,000 on count one. We already ordered on count two. Count 3, 5,000. Count 4, 5,000. Count 5, 5,000. Count 6, 5,000. Count 7, 1,000. Thank you.
Chapman?
Pamela Chapman, charged with domestic violence. You have a right to a lawyer. You gonna hire a lawyer? You want to see if you qualify for a court-appointed lawyer?
I'm a disabled veteran. I need a public defender, Your Honor.
Do you have any source of income?
I do not.
Appoint the public defender. Find probable cause. Currently held without bond. State, you want to be heard?
The state would ask for a $15,000 bond and no weapons and no contact, given the nature of the charge. There is a prior DV battery that was dropped.
Is it the same victim?
This is Kristen Fruity. Yes, sir, same victim.
All right. Defense, you want to be heard?
It's alleged that she threw an ashtray at the alleged victim that hit his feet and it cut his feet, I believe. I would just ask for a reasonable bond on this, around $10,000 or less.
Yeah, I'm gonna set bond at $7,500. If she bonds out, she's to have no contact with the victim, no weapons or firearms, cannot drink, no package stores, no liquor, no bars. Subject to random testing at her expense. Thank you.
I would ask that she be allowed one time to go back and get her stuff. They have the same address.
She can go back one time with law enforcement to get her personal belongings. Thank you.
Risky Amanda.
Yeah, I've got a fugitive warrant out in North Carolina. You can have a lawyer if you want one. You can hire one. You can see if you qualify for the public defender. What do you want to do?
Public defender, please.
Do you have any source of income?
Not at the moment.
Appoint the public defender. Can't do much because there's a warrant. There's a review date of June 8th. We'll hold you without bond and see what North Carolina wants to do. Thank you.
Thank you.
All right. What's this lady's name?
Tasha Cruz.
It's Tasha Cruz? Okay.
Yes.
All right. You're charged possession of methamphetamine, possession of drug paraphernalia, and driving license suspended as habitual offender. You have a right to a lawyer. Are you going to hire a lawyer? Or you want to see if you qualify for a court-appointed lawyer?
See if I qualify.
Do you have any source of income?
No, sir.
Appoint the public defender. Find probable cause. Currently held without bond. Looks like Y has an open case.
Yes, sir, she has an open case, CF 264773, which is also a drug-related case.
Revoke bond in that case pursuant to Parker v. State, holder with no bond. In this case, set bond at 5,000 count one, 5,000 count two, 5,000 count three.
And then I don't know if public defenders appointed on their case, but if not, I would ask for our office to be appointed.
If the public defender is not already representing her on the other case, appoint them as well. Thank you.
Done.
I'm so sorry, Rachel.
That's all right. Rachel Dunn. All right, you have possession of drug paraphernalia, possession of methamphetamine, driving a license suspended. You have a right to a lawyer. Are you going to hire a lawyer? Or you want to see if you qualify for a court-appointed lawyer?
I'd like to see if I qualify.
Do you have any source of income?
Yes, sir.
How much do you bring home per week?
500.
Appoint the public defender. Find probable cause. She's currently held without bond. Why is that?
There is a prior case, but there was no bill last month, and I don't see anything else open. She does have a little bit of prior history.
Looks like this is, they were sent, I think that, can I go back to PCF and David? It looks like 3 priors. Okay, all right. Set bond, count 1, 1,000, count 2, 5,000, count 3, 5,000. Thank you.
Sorry, Judge, I have one question.
Yes, ma'am.
Going back to Tasha Cruz, I had her case number again. I got 44773, but when I looked it up, nothing came up.
4773.
4773, thank you.
All right. All right, go ahead, Deputy. Who else?
Eisenberg.
Eisenberg, Teresa Eisenberg, possession of drug paraphernalia, possession of cocaine. You have a right to a lawyer. Are you gonna hire a lawyer? You want to see if you qualify for a court-appointed lawyer?
Public defender, Your Honor.
Do you have any source of income?
Yes, Your Honor.
How much do you bring home per week?
I'm on SSA, $740 a month.
Appoint the public defender.
Thank you, Your Honor.
Find probable cause. Bonds are set at 1,000, count 1, 5,000, count 2, leave as set. Thank you.
Thank you, Your Honor.
Cruz is ready, you can do Cruz. Okay.
Gil Stephanie.
All right, Stephanie Gill, charged with domestic violence, resisting an officer with violence. You have a right to a lawyer. Are you going to hire a lawyer? You want to see if you qualify for a court-appointed lawyer?
See if I qualify for one.
Do you have any source of income?
I do.
How much do you make per week?
I got like 1,200 every 2 weeks.
Appoint the public defender. Find probable cause. Currently no bond on count one. State, what have you heard?
State would ask for $5,000 bond and no weapons and no contact as conditions.
Yeah, set bond at 5,000 on count one. Count two, the bond's too low, raise it to 10,000. If she bonds out, she's to have no contact with the victim, no weapons or firearms, can return to the property one time with the assistance of law enforcement to get her personal belongings. Thank you.
Harvey, Selena,
Let's see, got a lot of charges here. Resisting without violence, false information to law enforcement, possession of drug paraphernalia, possession of intent to sell or deliver, 2 counts, possession of cannabis with intent, driving license suspended, and 1, 2, 3, 4 violations of probation. Looks like those are all warrants.
There's 6 violations.
The other 2, right, 2 more, so 6 total violations of probation. All right, do you have a right to a lawyer? Are you going to hire a lawyer? You want to see if you qualify for a court-appointed lawyer?
For now, the public defender.
Do you have any source of income?
No, sir.
Appoint the public defender. All right, finding probable cause. Currently held without bond. The violations of probation, set those as no bonds. State, going to be heard on the other counts for
Yes,
bond.
sir. The state would ask for, on misdemeanor counts, we'd ask for $1,000 per count. On the drug-related offenses, we'd ask for $10,000 per count.
All right, so count 1, 1,000, count 2, 1,000, count 3, 1,000, count 4, 10,000, count 5, 10,000, count 6, 10,000. Count 7, 1,000. Thank you. All right, that's it. You're done, ma'am.
Holstein,
No, Hensley.
Darla Hensley,
All right, Carrie Hensley, got 3 violations of probation. Looks like there was a warrant. You have a right to a lawyer. You're gonna hire a lawyer, you wanna see if you qualify for a court-appointed lawyer.
Public defender.
You have any source of income?
No.
Appoint the public defender, find probable cause, currently held without bond pursuant to the warrant, leave as no bond. Thank you.
now Holstein,
All right, Holstein charged with burglary, petty theft, criminal mischief. You have a right to a lawyer. You're gonna hire a lawyer, you wanna see if you qualify for a court-appointed lawyer.
Public defender.
You have any source of income?
Yes.
How much do you bring home per week?
About 600.
Appoint the public defender. Find probable cause, currently held without bond on count 1. State, you want to be heard.
The state would ask for a $10,000 bond on count 1.
Smith, you want to be heard.
That's for, this is involving, I believe, a vehicle for 5,000.
Set bond at 5,000, count one. 250, count two. Is if they were already, leave it as set. Count three, 1,000. If she bonds out, she's to have no contact with the victim whatsoever. Thank you. Well, do you live at that property, ma'am? McClellan Road?
Oh, no, sir.
All right, thank you.
Jackson?
Charge the DUI, damage to property, DUI. You gonna hire a lawyer, or you wanna see if you qualify for a court-appointed lawyer?
Court opponent, lawyers, Your Honor.
Do you have any source of income?
Yes, sir.
How much did you bring home per week?
I'm on disability.
How much did you bring home per month then?
Probably 6,000, 5,000,
5 to 6,000, is that what you said?
5,000. Yes,
Do
sir.
you have any minor children you support?
No, sir.
Not gonna qualify, you'd have to hire your own lawyer. You want me to go ahead and deal with this today so you can hire a lawyer and get them involved later?
Yes.
All right. All right, we'll find probable cause. Bonds are set at 1,000 each count, leave as set. Thank you.
Jones?
Judge Shanice Jones, you got a violation of probation. You have a right to a lawyer. You're gonna hire a lawyer, you wanna see if you qualify for a court-appointed lawyer.
Court, public defender.
Do you have any source of income?
No, sir.
Appoint the public defender. This was a warrant, find probable cause. Looks like Judge Stamey set a bond, 2,500. Leave it as set.
Okay.
Thank you.
Madden?
Jennifer Madden. As domestic violence, you have a right to a lawyer. You're gonna hire a lawyer, you wanna see if you qualify for a court-appointed lawyer.
Court appointed, sir.
Do you have any source of income?
Yes,
How much do you bring home per week?
about 400.
Appoint the public defender.
Excuse me? Okay.
Appoint the public defender. On probable cause, currently held without bond. State, you want to be heard?
State would ask for a $5,000 bond and then no weapons and no contact as conditions.
5,000, no weapons or firearms, can't return to the residence except with the assistance of law enforcement to get your personal belongings. Thank you.
Mangram was combative and not brought up today.
All right, pass her to Lamar, we'll see how she feels.
Neveja?
What's this lady's name?
Neveja Randolin?
Nevaeh. Possession of drug paraphernalia, possession of methamphetamine. You have a right to a lawyer. You're gonna hire a lawyer, you wanna see if you qualify for a court-appointed lawyer.
Court appointed.
Do you have any source of income?
No, sir.
Appoint the public defender. Find probable cause. Bond set at 1,000, count one, 5,000, count two, leave as set. Thank you.
Palacios?
Palacios.
Palacios, charged with battery. You have a right to a lawyer. You're gonna hire a lawyer, you wanna see if you qualify for a court-appointed lawyer.
See if I qualify.
Do you have any source of income?
I do Uber Eats, so
Now, what are you bringing home per month?
like 800, 700.
Appoint the public defender. Find probable cause. All right, looks like bond set at 1,000. It's probably, this looks like a family dispute.
Yeah.
State, do you want to be heard?
Or the state would have no objection to it remaining at 1,000, and we just ask for no weapons and no contact at this point.
All right, leave it at 1,000. No weapons or firearms. Cannot return to the property unless she goes to assistance of law enforcement one time and get her personal belongings. Thank you. Alexis Peterson, charged with domestic violence battery. You have a right to a lawyer. You're gonna hire a lawyer. You want to see if you qualify for a court-appointed lawyer.
Public defender.
You have any source of income?
Yes, sir.
How much do you bring home per week?
500 a week.
Point to public defender. Find probable cause. Currently held without bond. State going to be heard.
The state would ask for a $5,000 bond and no weapons and no contact as conditions.
All right, 5,000 bond, no weapons or firearms. I'm not sure if they reside together. If they do, she can go back one time with the assistance of law enforcement to get her personal belongings. Thank you.
Can you come back?
Good. Thank you.
Done. Yes, ma'am.
Next, LaQuinda.
Wanda Smith, charged with aggravated battery on a pregnant person, breach of the peace. You have a right to a lawyer. You're going to hire a lawyer. You want to see if you qualify for a court-appointed lawyer.
Court appointed.
You have any source of income?
I do.
How much do you bring home per week?
600.
Point the public defender. All right, find probable cause. Currently held without bond on count one. State, you want to be heard?
The state would ask for 10,000 on count one and then no weapons and no contact as pretrial release conditions.
Then F2.
Yes, sir.
Set bond at 10,000, count one, leave count two at 250. If she bonds out, she's to have no contact with the victim, no weapons or firearms. They weren't connected, so it doesn't look like there's any reason for them to go back to that property. All right, thank you.
Thank you. Towels in front.
Yeah, okay. Caitlin Townsend in front. Tough one to say 5 times fast. All right. Charge of disorderly intoxication. You have a right to a lawyer. You're going to hire a lawyer. You want to see if you qualify for a court-appointed lawyer.
Your Honor, I would like to represent myself pro se and request release on my own recognizance.
All right. Show her waiving the right to a lawyer. Find a probable cause. Bond set at 250. Leave as set. Thank you.
Thank you.
Williams.
Sweeta Williams, charged with possession of drug paraphernalia, possession of cocaine. You have a right to a lawyer. You're going to hire a lawyer. You want to see if you qualify for a court-appointed lawyer.
Let's see if I qualify.
You have any source of income?
Yes,
How much do you bring home per week?
500.
Point the public defender. Find a probable cause. Bonds are set at 1,000 count one, 5,000 count two. Leave as set. Thank you.
Thank you.
Right?
All right, this is Billie Jean Wright, charged with possession of cannabis, looks like misdemeanor amount, resisting without, possession of drug paraphernalia. You have a right to a lawyer. You're gonna hire a lawyer, you want to see if you qualify for a court appointment.
Public defender.
You have any source of income?
I do odd jobs to make a little bit of money here and there, so no like legit job.
Point the public defender.
Hear your name, line up.
Find probable cause, currently held without bond. Why is that?
She has an open case, but I think it's a summons case.
It's a summons case.
All right, set bond, count 1, 5,000, count 2, 5,000, count 3, 1,000. Thank you.
First one for the mail is Bodie Matthew.
All right, on to the men, Matthew Bodie, possession of drug paraphernalia, possession of methamphetamine.
Davis
You have a-
Ernie.
You have a right to a lawyer. You're gonna hire a lawyer, you wanna see if you qualify for a court-appointed lawyer.
Public defender.
You have any source of income?
Yes, sir.
How much do you bring home per week?
375.
Point to public defender. Find probable cause. Bond set 1,000, count 1, 5,000, count 2. Leave as set. Thank you.
And we skipped a Bellamy, is he not here?
Oh, he purged.
All right, Bellamy's, he's not on the list, so he must have purged out and bonded whatever he had.
Okay, thank you.
All right, what's this gentleman's name?
Regular Adam.
No.
Adam Bregler, charged with resisting without violence, disorderly conduct. You have a right to a lawyer. You're gonna hire a lawyer, you wanna see if you qualify for a court-appointed lawyer.
Can I see if I qualify?
Do you have a source of income?
Not right now, sir.
Point to public defender. Find probable cause. It's only charged with resisting and disorderly right now. Okay. All right. Bond set 1,000, count 1, count 2, 250. Leave as set. Thank you.
I was speaking myself.
Okay, thank you.
Brown Williams.
Sandra Smith, Public Defender's Office. I have a stipulation with the state regarding the use of false name adversely affecting another. The stipulation with the state is there's probable cause for a lesser charge, a first-degree misdemeanor, giving false name to law enforcement instead of the third-degree felony he's currently charged with. And that's the only stipulation.
All right. So you're charged with possession of fentanyl, possession of drug paraphernalia, destroying or tampering with physical or with, I can't tell what that charge is. Hold on. They got it says destroy, tamper with physical evidence. Use of this, you have a charge of use of false name, displaying an ID card of another, criminal use of personal identification. Looks like on count 3, is that the one you were talking about, Ms. Smith? Or no, you were talking about count 4.
Use of false name adversely.
So it looks like stipulation with the state on that, it's a lesser offense of giving false information to a law enforcement officer.
Yes, sir.
So that's an M1. All right. All right, finding probable cause. Looks like bonds are set. Count 1, 5,000. Count 2, 1,000. Count 3, there's currently no bond.
The state would have no objection to 5,000, it's an F3. So.
Set bond at 5,000. Count 4, where you decide we would RR, or no, we reduce it, that's 1,000.
Yes, sir.
Count 5, 250. Count 6, 5,000. Yes, I didn't say that point. I don't, well, maybe I didn't ask him actually. I got sidetracked with this argument. You gonna hire a lawyer or you want the public defender, sir?
Public defender.
You have any source of income?
No, sir.
All right, point to public defender. All right, thank you. Attorney Davis, looks like got a resisting without and warrants for violations of probation. You have a right to a lawyer. You're gonna hire a lawyer, you wanna see if you qualify for a court-appointed lawyer.
Public defender.
You have any source of income?
Yes, sir, I do.
How much do you bring home?
It's disability.
How much do you get per month?
The time I pay all my bills and everything, it's about 1,600. It's 1,600.
What's the total amount you get per month?
1,600.
Point to public defender. Find probable cause. Set bond on count 1 at 1,000. Violations of probation are stemming from the arrest, holding no bond on those. Thank you. Then we got Robert Deshomes.
Sanderson Public Defender's Office, Your Honor. He's currently charged with 3 separate counts of resisting an officer without violence. I just speak to the state before court, and we have a stipulation that on 2 out of those three charges, there is no probable cause, and he should be released on his own recognizance, so there'd be only 1 resisting left.
All right.
Is this the Shomes? Because he's from the South County.
This is Durr.
This is,
Oh,
who is this?
Durr, D-U-R-R.
okay, where is the Shomes?
I don't know, I guess we skipped over this.
There's no Deshaun's on our docket.
He was at South County.
He was at South County, I guess he wasn't, we have not done this case yet.
You have paperwork for Deshomes?
We have Deshomes on our list.
Put them on tomorrow.
Yes, sir.
All right, Samir Durr. Got a violation of probation. You have a right to a lawyer. You're gonna hire a lawyer. You wanna see if you qualify for a court-appointed lawyer.
Court appointed?
Keith Jones.
Do you have any source of income?
Yes, sir.
How much you bring home per week?
$750.
You have any minor children you're supporting?
2.
Appoint the public defender. It's a warrant. Find probable cause. No bond pursuant to the judge that issued the warrant. Holding no bond. Thank you.
Erickson.
Gregory Erickson, possession of cannabis, misdemeanor amount, possession of drug paraphernalia, possession of methamphetamine. You have a right to a lawyer. You're gonna hire a lawyer, you wanna see if you qualify for a court-appointed lawyer.
Public defender, please.
You have any source of income?
No, sir, I don't. They canceled my social security check.
Appoint the public defender.
Devon.
Find probable cause. Bonds 1,000 count 1, 1,000 count 2, 5,000 count 3, leave as set. Thank you.
When my court date?
I don't know, let's see, the arraignment date is July 7th.
All right, thanks a lot.
Horace.
Ellis Horace, charged with possession of cannabis, possession of drug paraphernalia.
Wilson.
You have a right to a lawyer. You gonna hire a lawyer, you wanna see if you qualify for a court-appointed lawyer.
Do you want a court-appointed lawyer, or are you gonna hire your own? Lawyer? Do you want a court-appointed, or are you gonna hire your own? No.
A court appointed?
Do you have any source of income?
Money? Do you make any money?
Yes.
How much money do you make per week?
Weekly, how much? About.
I don't know. I don't know weekly, but
More or less than 600?
more.
More than 600?
Yeah, more than 600.
Like more than 1,000?
Nah, I don't know.
All right, well, do you have trouble hearing, sir? I'm not sure why you can't hear me.
Are you having trouble hearing?
Yes.
Okay. Do you have any minor children you're supporting?
Do you have any children?
No.
All right, you're not gonna qualify for this public defender, you'll have to hire your own.
You have to hire your own. You don't qualify.
Qualify.
You make too much money.
Okay.
Find a probable cause. Bond set at 1,000 each count, leave as set. Thank you.
1,000 and 1,000 for your bonds. 2,000.
Okay.
Let's see.
Thank you, Deputy.
Jones, Keith.
Keith Jones,
Lisbon.
charged with domestic violence, petty theft, tampering with a witness, domestic violence, aggravated assault. You have a right to a lawyer. You're gonna hire a lawyer. You wanna see if you qualify for a court-appointed lawyer.
A PD?
Do you have any source of income?
No.
Appoint the public defender. Find probable cause. Currently held without bond. State you want to be heard.
Yes, sir.
Looks like he has an open
He's got an
case.
open case, yes, sir.
Oh.
On the felony battery, we would ask for we'd ask for 10,000 on the felony battery, 1,000 on the petty theft, 5,000 on the tampering, 5,000 on the ag assault, and no weapons and no contact as conditions. He does have an open case CF 253879 that he was out on.
All right, revoke his bonds in 25 CF 3879 pursuant to Parker v. State. In the new case, set bond on count 1, 10,000, count 2, 1,000, count 3, 5,000, count 4, 10,000. If he bonds out, he's on pretrial release. He's to have no contact with the victim, no weapons or firearms. Thank you.
Have a seat in that one. Jones, Javon?
We were appointed. Thank you.
All right, Javon Jones, resisting an officer without violence, domestic violence battery. You have a right to a lawyer. You're gonna hire a lawyer, you wanna see if you qualify for a court-appointed lawyer.
Appointed lawyer.
You have any source of income?
I bring home 400 a week.
Appoint the public defender. Item probable cause, currently held without bond, state one of your,
And the state would ask for 5,000 on the DV battery and 1,000 on the resisting, and then no contact and no weapons as conditions.
all right, count 1,000, count 2, 5,000. If he bonds, to have no contact with the victim, no weapons or firearms. If he resides in the same residence, can go back one time with law enforcement to get his personal belongings. Thank you.
Can I ask a question with?
What's the question?
Would I be able to get a signature on both charges? Because the whole situation is false. None of it true.
All right, that's not a question. We're not going to talk about the facts of the case. You have a lawyer. They'll assist you. Thank you. What's this gentleman's name?
Lisbon is I got from yesterday on the fentanyl charge, and I haven't received any supplemental reports.
All right, is this Junius Lispin?
Yes, sir. Yes, sir.
All right, so we appointed the public defender. We came back because we didn't have enough information about the fentanyl.
Yes, sir.
No supplement, we gave the state 24 hours, no additional information's come forward. So finding no probable cause on the possession of fentanyl at this time. Show him RR on that count.
Yes, sir.
Thank you.
Mr. Lisbon, you still have the bonds of a total $11,000 on your other accounts from yesterday.
Yes, ma'am. Thank you.
Thank you.
Okay.
All right. Okay, let's see who's up next. All right, Reginald Lloyd. Charged with possession of drug paraphernalia, possession of cocaine. You have a right to a lawyer. You're gonna hire a lawyer, you wanna see if you qualify for a court-appointed lawyer.
Court appointed.
You have any source of income?
No.
Appoint the public defender.
Miller?
Find probable cause. Bond set 1,000, count 1, count 2, 5,000, leave as set. Thank you.
Mencio Nickerson?
Nickerson or Mancio. Okay, charged with battery, 2 counts. You have a right to a lawyer. You're gonna hire a lawyer, you wanna see if you qualify for a court-appointed lawyer.
Court appointed.
You have any source of income?
Right now, I'm on disability for back surgery.
How much money do you get per month?
2,700.
Appoint the public defender. Find probable cause. These bonds are too low. Set them at 5,000 per count. Thank you.
Excuse me?
If he bonds out, he's to have no contact with the victim. Can't return to the event location. Thank you.
Why?
Melvin
Quick
Arthur.
question, Your Honor.
Yes.
Why is the bond so high? It's my first offense, and and I'm not guilty. I was assaulted, and I defended myself.
All right, I'm basing this decision on the probable cause affidavit alone. So those are things to be decided down the road. You have a lawyer, they can advise you. Bonds remain as they are. Thank you.
Melvin Arthur.
Charge of possession of drug paraphernalia, possession of cocaine. You have a right to a lawyer. You're gonna hire a lawyer, you wanna see if you qualify for a court-appointed lawyer.
Public defender, Your Honor.
Do you have any source of income?
Yes,
How much do you bring home per week?
500.
Appoint the public defender. Find probable cause. Bonds are set, count 1,000, count 2, 5,000. Leave as set. Thank you.
Thank you, Your Honor.
Miller.
Right here, Mr. Rob.
Sanderson Public Defender's Office. I have a stipulation with the state regarding one of his charges. It's the second charge on the docket, the possession of controlled substance without prescription. That on that one charge, there's no probable cause, and he should be released on his own recognizance. This is a duplicate charge for the alprazolam.
All right.
Howell.
Mr. Miller, you're charged. What, you got a warrant out of Hillsborough County? You got charged here with drug possession, possession of controlled substance, possession of methamphetamine, possession of alprazolam. Can't help you with Hillsborough County. Looks like you got 2 warrants out of there. And the charge is here in Polk. You're entitled to a lawyer. You can hire a lawyer, or you want to see if you qualify for a court-appointed lawyer.
Court appointed, please.
Do you have any source of income?
No, sir.
Appoint the public defender. Looks like the warrants out of Hillsborough County have bonds of 2,500. Leave those as set. Says Ms. Smith says there's a stipulation on count 2 to RR for no PC. Is that correct?
Yes, sir.
All right. Show that RR. Count 3. Find probable cause. 4. Find probable cause. Bonds are set 5,000 each of those counts. Thank you.
Miranda Martinez.
Sanderson Public Defender's Office. I have a stipulation with the state, there's probable cause for a lesser charge, a second-degree misdemeanor of driving a license has been revoked. There's no prior conviction
On the back, one up here.
in the affidavit.
That's correct, John.
All right. So Ms. Miranda Martinez, you're entitled to, or Mr. Miranda Martinez, you're charged with driving a license suspended. You're entitled to a lawyer. You're going to hire a lawyer. You want to see if you qualify for a court-appointed lawyer.
Public defender.
Do you have any source of income?
About $300.
Appoint the public defender. Find probable cause for driving a license suspended as a misdemeanor. Currently held without bond. State, you want to be heard.
The state would ask for a $1,000 bond and no driving without a valid driver's license.
Looks like there's a DUI suspension. So set bond at 5,000. No driving without a valid driver's license. Thank you.
Howell.
Let's see, Freddie Powell, charged with possession of cannabis misdemeanor amount, possession of firearm by convicted felon, resisting an officer without violence, possession of drug paraphernalia, possession of cocaine, possession of fentanyl, driving a license suspended, and you had 3 failure to appear misdemeanor cases. I don't know if you got a lawyer on the misdemeanor case. You're entitled to a lawyer on the felony case and the misdemeanor case. You're going to hire a lawyer. You want to see if you qualify for a court-appointed lawyer.
Qualify for a court-appointed lawyer.
Do you have any source of income?
Yeah, I make $350 a week.
Appoint the public defender.
Can I ask a question, Judge?
You got to hold on. You got a second page here. I don't know, some charge of structure, financial transaction, fleeing to elude, failure to leave information. Those are old cases. What are these things? What's IF mean?
Information file.
Okay. Okay. Now, right now, we're talking about appointing you the public defender, which we've done. I need to look at the PC affidavit.
Okay.
All right, so this guy was a co-defendant of the other guy. Is there any more information in this case on the fentanyl charge?
Yeah, that's what I was looking for. I don't see that it was tested.
All right, because there's warrants on this other stuff. There's a petty theft, domestic violence, battery, and battery. Is that on the list here?
Yes, sir, I have.
No, those are the failure to appears, okay. What about, where's this, on the upgraded charges, on these other charges? Yep, there's a warrant, structuring, okay. So that's got a probable cause.
I don't see the fentanyl. Is it even mentioned?
It's mentioned in here, it doesn't show anything.
It's the same thing, the pill fragments. They
They
suspected to be fentanyl, but he tested the green
Hold on,
leafy
go
substance
back,
and
go back.
tested the cocaine, but
All right. Well, absent the fentanyl, I'm finding probable cause on everything else.
yes, sir.
RR on the fentanyl count, so no PC. The other accounts are showing no bond.
Yes, because he had the other cases. The state would have no objection to scheduled bonds on the new law violations.
And he already has bonds actually in all the FTAs and the warrant and the other direct file information. They just take them off when they come to jail. So he already had bonds set.
That's correct.
On he has bonds I see on the FTA, and then on the direct file charge, was there a bond on that?
Yes, sir, on the CF 21, it's 5,000,
Yep, there is, okay.
and then on,
An older case, I think the plea is 1,000.
and the CF 19 is the fleeing to elude is 1,000, and the failure to leave information is 250.
This is an older case.
But those are direct files, not,
Yes, sir.
okay. All right, so then what we're dealing with is the misdemeanor possession, set it at 1,000. Possession of firearm by a convicted felon, set that at 15,000. Resisting an officer without violence, set that at 1,000. Possession of drug paraphernalia, set it at 1,000. Possession of cocaine, set at 5,000. Driving license suspended, set that at 1,000. And so he's got bonds set on everything else.
It's on the misdemeanor case, it was 500 per count, sorry.
Right,
On
okay,
the
that's on
20.
here. Okay, so we had 500 per count on the FTAs, 5,000 on the financial structure direct file, 1,000 on the fleeing, 1,000 or 250 on the failure to leave information. All right, I think that covers it for Mr. Powell. Thank you.
Sir, could you tell what all the total of my bonds is? I'm kind of confused a little bit.
Yeah, that's pretty confusing, but it's a large amount. Let's see, 16, 17, 18, 23, 24, 25, 25, 5, 35, 5, 36, 5, 5, 36, 750.
36,750.
36,750.
All right. Thank you.
Thank you. All right, this Donald Reeves says possession of drug paraphernalia, possession of methamphetamine. You have a right to a lawyer. You're gonna hire a lawyer, you wanna see if you qualify for a court-appointed lawyer.
I think I still got one from another case. Public defender.
This is a new case, we would have to be appointed on this.
Yeah.
Okay.
All right,
Okay. Then I guess appointed one then.
all right. So do you have any source of income?
Yes.
How much do you bring home per week?
Like 200.
Appoint the public defender.
And looks like he's on probation, MN 255918.
Yeah, he's on probation, so violate him on his probation, do an instant or warrant, 25 MM 5918.
Yes, sir.
Hold him no bond on that. The other cases, he'd be entitled to bond. State, you want to be heard?
The state would have no objection to schedule bond, so 1,000 on the paraphernalia and 5,000 on the cocaine.
All right, 1,000 count one, 5,000 count two. All right, thank you.
And I would ask to be appointed on the other case, I'm not sure whether we're on that case or not.
Appoint the public defender on all matters.
All right.
Rivers,
Samuel Rivers is charged with possession of drug paraphernalia, possession of cocaine. You have a right to a lawyer. You're gonna hire a lawyer. You want to see if you qualify for a court-appointed lawyer.
Court appointed.
You have any source of income?
No, sir.
Appoint the public defender. Find probable cause. Bond, no bond set. Why is that? You have an open case?
No.
He says no.
I mean, there's several cases, but it looks like they're already
There's a
over.
CF 22, but that looks like that's a fugitive case. That's not the case. I don't see anything open.
Says he's a career offender.
Yes, sir. He's got a history.
All right. Set bond on count one, 5,000. Set bond on count two, 10,000. Thank you.
Romero,
Charge of no valid driver's license. You have a right to a lawyer. You're gonna hire a lawyer. You want to see if you qualify for a court-appointed lawyer.
Court appointed lawyer.
You have any source of income?
Yes, sir.
How much do you bring home per week?
600.
Appoint the public defender.
Wappy,
Find probable cause. Currently held without bond. Is there an ICE hold on him? Looks like there,
That's
yes,
the only thing I can figure, Your Honor.
there
I don't
is.
see anything open.
There is an ICE hold on him.
We would just ask for $1,000 bond on the no valid.
1,000 count one. You've got an order to detain from Department of Homeland Security, so hold them. Thank you.
Rosado,
I do that all the time. I do that all the time. All right, Eduardo Rosado Duran looks like charged with use of display of a firearm during a felony, possession with intent to sell or deliver, possession of cannabis over 20 grams. You have a right to a lawyer. You gonna hire a lawyer? You want to see if you qualify for a court-appointed lawyer?
See if I qualify.
You have any source of income?
Yes.
How much do you bring home per week?
800.
You have any minor children you support?
2.
Appoint the public defender. Finding probable cause, currently held without bond, count one, the firearm charge. State, you want to be heard?
The state would ask for a $10,000 bond on that count and no objection to the bonds that are currently set on the other 2 counts.
All right, 10,000 count one, 5,000 on count two, 5,000 count three, leave as set. Thank you.
Thank you.
Slappy,
Right here.
All All right, Jesse Slappy, charged with possession of drug paraphernalia, possession of methamphetamine. You have a right to a lawyer. You're gonna hire a lawyer, you wanna see if you qualify for a court-appointed lawyer.
Let's see if I qualify.
You have any source of income?
Not right now, no.
Appoint the public defender, find probable cause, bond set at 1,000, count 1, count 2, 5,000, leave as set. Thank you.
Are those misdemeanors or?
One's a felony, one's a misdemeanor.
Okay.
Raphael Smith, charged with battery, possession of a synthetic drug, has violations of probation, 2 counts. You have a right to a lawyer. You're gonna hire a lawyer, you wanna see if you qualify for a court-appointed lawyer.
Court-appointed lawyer.
You have any source of income?
No, sir.
Appoint the public defender.
Taylor and Walker.
All right, finding probable cause. Violations of probation stem from the new offense, holding no bond on those. State, you want to be heard on count 2, domestic violence.
Yes, sir. The state would ask for 5,000 on the DV battery with no weapons and no contact as conditions.
All right, let's see, he's also, the synthetic drugs got no bond. You want to be heard on that?
We'd ask for 5,000 on that count also.
All right, 5,000 count 2, 5,000 count 3. If he bonds out, he's to have no contact with the victim, no weapons or firearms, cannot return to the property unless with law enforcement at one time for purposes of obtaining personal property. Thank you.
Thank you.
Colton Summers,
How you doing, Your Honor?
I'm fine. Thank you. Let's see, charged with burglary, trespass, grand theft. You have a right to a lawyer. You're gonna hire a lawyer, you wanna see if you qualify for a court-appointed lawyer.
I'd like to see if I qualify.
Do you have any source of income?
Not at the moment, sir.
Appoint the public defender. Finding probable cause. Current, let's see, has bonds already set. 5,000 count 1, 250 count 2, 5,000 count 3, leave as set. Thank you.
Thank you, sir.
Charles Taylor, possession of a concealed weapon, what's the whole charge? By a convicted felon. You have a right to a lawyer. You're gonna hire a lawyer, you wanna see if you qualify for a court-appointed lawyer.
See if I qualify.
Do you have any source of income?
Yes, sir.
How much do you bring home per week?
I say about 400.
Appoint the public defender. So they've charged in possession of a concealed weapon. This looks like this charge should be possession of a concealed firearm or possession of a firearm. Currently, there's probable cause certainly for possession of a concealed weapon. Looks to me like it's a more serious offense than that.
Yes, sir. Looks like he's got, I guess he's on juvenile probation because there's some juvenile cases that are open.
Well, that might make it not a convicted felon, but
Yes, sir.
an adjudicated
Convicted delinquent, yes, sir.
All right.
And then there's some CT cases in Lakeland, but I think they're all D6. I don't think there's,
Yeah, this says he's a convicted felon out of Escambia.
okay. Given the record, the state would ask for a $15,000 bond.
It's that bond of 15,000. Thank you.
Yes, sir. Thank
Walker.
Jesse Walker, charged with domestic violence, battery. You have a right to a lawyer. You're gonna hire a lawyer, you wanna see if you qualify for a court-appointed lawyer.
See if I qualify.
You have any source of income?
Yes, sir. I make about 400 a week.
Appoint the public defender. Finding probable cause. Currently held without bond. Dave, you want to be heard?
State would ask for $5,000 bond and no weapons and no contact as conditions.
Said bond at 5,000. No weapons or firearms. No contact with the victim. If you share a residence, can go back one time with law enforcement, get your personal belongings. Thank you.
Yes, sir. Thank you, Your Honor.
We skipped a couple people.
Okay, well, it looks like there are no more inmates.
Well, we did skip several, so.
All right, who else are we missing?
There was a Green Leonard who was never called.
Deputy, you know anything about
Medically-
Leonard?
Medically unable to appear today.
All right, put him on tomorrow.
And then Mr. Richard Marshall, who was in transit yesterday, wasn't here today either.
Also medically unable to appear today.
I would ask to reset him also.
Put him on tomorrow. Anybody else?
believe that was it.
Is that it on your end, Deputy?
As far as I'm aware of.
Okay, thank you. Have a good day.
You too. Hello.
Hi, good morning.
He should be on his way down.
Thank you. Good morning, Teal Clay.
Mental health and the Southside West.
Morning, how are you?
Good, how are you?
Good. Sorry, my PC and my phone doesn't seem to want to work with the
That's
Tom
okay.
PS Gordon screen. Sorry.
That's no problem.
Thank you.
Hold on. Thank you. Good morning, Mr. Miller.
Good morning, Miss.
Morning. We're here today for your rep hearing, so we're gonna get started with that, okay?
All right.
Good morning. I am P.O. Meissner, hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Miller Jason, number 254676. Today is December 9th, 2025. This hearing is being conducted via video at the BOPP Central Office in the Cheshire Correctional Institution. This is a public hearing. Public access to this hearing is available. It will be a video live stream. Can you please state your full name and DOC inmate number for the record, sir?
Jason Miller, 254676.
Thank you. And we have a parole officer present today. Can you please identify yourself for the record? Oh, you're muted. It's back muted.
Can you hear me now?
Yes, yes.
Oh, it's P.O. McClay out of Hartford Parole. Sorry about that.
Thank you. This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better or weightier evidence must establish that more probable than not the allegation is true. If I do not find there is a preponderance of evidence to support a violation or one more conditions of your parole, I'll reinstate your parole, which means releasing and placing you back on parole supervision. If I find you violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. This is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge if the state your parole officer is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to present relevant testimony. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I'll announce my findings. If I find you violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure, sir?
No, ma'am.
Okay, you important rights, right to have an attorney present. Do you want to continue without counsel?
Yes, ma'am.
Okay, you have a right to receive the written notice of charge of the violation. Did you receive the written notice?
Yes.
You have a right to review the evidence. You have a right to submit evidence for your case at this hearing. You have a right to call and examine voluntary witnesses and cross-examine diverse witnesses. Do you understand these rights and are you ready to go forward?
Yes.
All right, so we will now review the charge the state or parole officer is bringing against you and the information underlying each charge. Charge one is not taken into consideration as a no findings made at the time of the prelim. So P.O. McClay, can you please read charge two?
Oh. Charge 2, halfway house placement. On 9/29/2025, your parole was reinstated by the BOPP and you were instructed by Parole and Community Services to go to a halfway house. During your preliminary hearing with the BOPP on 9/29/2025, you stated that you would comply with residing in a halfway house if parole instructed you to reside in one. BOPP hearing examiner Meisinger asked you if you were to go to a halfway house, do you have a problem with that? Can you comply with that? And you responded, yes, I can. After reinstating your parole, hearing examiner Meisinger told you if you were placed in a halfway house today, you need to go there and comply. When you met with the Bishop Halfway House staff on 9/29/2025, you stated that you wanted to be relocated because your co-defendant was in the area. You became uncooperative and refused to engage in the intake process. P.O. Jackson was notified about your behavior. When P.O. Jackson made attempts to speak to you and de-escalate you, you continued to yell, be uncooperative, and continued to refuse the intake process. Therefore, you are in violation of your additional parole condition halfway house placement that states, in the event I am placed in a halfway house, I agree to go directly to and reside in the facility designated by the Parole and Community Services Division until released by the Parole and Community Services Division. Evidence. Exhibit A, Connecticut Conditions of Parole. Exhibit B, Remand to Actual Custody Order, Connecticut Department of Correction. Exhibit C, Notice of Parole Violation, Notice of Parolee Rights. Exhibit D, Parole Violation Report. Exhibit E, Parole Violation Report dated 9/15/2025. Exhibit F, Preliminary Hearing Summary dated 9/29/2025, Bishop House. Exhibit G, Bishop House Incident Report dated 9/29/2025. And Exhibit H, Department of Correction, Bishop House Discharge Plan Report dated 10/1/2025.
Thank you. And these are
You're
the
welcome.
exhibits that we put on the record at the time of the preliminary hearing. We have no witnesses today. At this time, I'm going to swear you in, Mr. Miller, as well as Theo McClay, in the event that you would like to speak today. So can you both please raise your right hand? You solemnly swear, solemnly affirm, as the case may be, the evidence you shall give concerning this case to be the truth, the whole truth, and nothing but the truth, to help you God without penalty of perjury.
Yes.
I do.
Okay, so at this time, the state will have an opportunity, if you'd like to present evidence and speak to any of the evidence submitted at this time.
I don't have any additional evidence to speak about. I mean, well, I do just want to note that since we did bring him back into DOC custody, he did receive 6 DRs. 1028, there was 2 tickets interfering with safety and security and destruction of property. 1024, refusing housing. 10-7, destruction of property. 10-2, interfering safety and security. 10-2, interfering in safety and security. And those were 6 total DRs since we brought him back. And then I also want to note that last time we had the preliminary hearing with Mr. Miller, he also noted at the end of his hearing that he did not want his parole. He was not interested in being back on supervision out here in the community. So I just wanted to make note of that. So,
All right.
and
Do you
that's
have
all.
do you have anything in regards to the charges, though?
Oh, no, nope.
Okay. Okay, so now is your opportunity to respond to parole violation charges against you. However, remember that you may remain silent if you so choose. Would you like to say anything in regards to the charge, Mr. Miller?
Yes, Miss.
Okay, go ahead.
First and foremost, Miss, I would like to say that I take full responsibility for my actions and for my behavior since I've been back inside the DOC. Far as my tickets go. I would just like to say that I've been sitting in here and I've been thinking, and I realized what happened in my situation, Miss, is that I experienced a setback far as the first violation that nobody wants to talk about, far as September 15th, when I was put back into custody because they said that I violated my special parole conditions when I was never on special parole, and that I should have had the opportunity to self-sponsor because I could have always self-sponsored. It wasn't mandatory or recommended that I go to a halfway house. I just went there because at the point in time, all of my family lived out of state. However, like I said in the beginning, I take full responsibility for my actions and for my behavior since I've been back in. And I realized that what I experienced, because I worked so hard to obtain employment, to obtain my grant for my CDLs, on the day that I was moved from Hartford to New Haven, it was a setback. And I just had to understand, which I understand now, is that I should have gave myself some time. I should have had patience. And I should have just understand that everybody in life, not only me, go through setbacks, and that I should have gave myself time to see what was going to happen. Because, Miss, I just worked so hard over the summer to get a job, to get into school, to get myself a career. And then out of the blue, somebody just told me that I was being moved, and my car, my job, my school, everything was taken from me. And I at that point in time, Miss, I didn't know what to do. I just didn't believe in myself. I felt fear. I felt worry. I didn't know what to do. But like I said, that doesn't give me, that doesn't give me a reason to behave the way that I behave, and that I apologize for my behavior. And I just understand now from sitting in here that everybody, experience setbacks, and that I should have just given myself time to see how everything, panned out.
Okay. Well, I appreciate your statements. Definitely sound different than you did last time we spoke. So it's good to hear you're actually thinking about what's going on and what you're doing and how it's affecting you negatively. So And I'm just gonna announce my findings in regards to the charge. So regarding that charge to, I do find you violate that condition, halfway house placement. This is based on evidence that was provided, which is exhibits A, D, G, and H. So that includes the fact-finding portion of the hearing. Before I make a recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. This part of the hearing is to help determine what outcome I will recommend. So Theo McClay, would you like to say anything at this time?
Yes, this is Mr. Miller's second violation while on parole supervision. The first one were due to criminal charges. And then we took him back the first time. We do know that his parole was reinstated the same day, but then we went and got him at Brooklyn CI, took him to Waterbury, and then it was the same exact situation that put him back in DOC custody when we took him to Waterbury over at Bishop House. We took him back the same day that he was reinstated. I am recommending 6 months for a sanction, seeing as, again, this is his second violation while on parole supervision, and because when he was reinstated, because he was brought back the same day that he was reinstated, that's what my recommendation is going to be, is the 6 months. And because of the 6 DRs, since we last brought him back to DOC.
Thank you.
You're welcome.
So at this time, Mr. Miller, it's your time to speak. I don't know if you would like to discuss your plans to go back out into the community and things like that. Now's your time to speak about that.
Okay, miss, when I came to jail, I was 21 years old, right? And I'm 45 years old. Since I've been on parole, and my parole officer can attest to this, she wasn't my parole officer for more than a week, miss. I received her on a Friday. She called my phone and she told me on a Friday that she was my parole officer. When she called me, she said, Mr. Miller, I'm your new parole officer. I said, okay, miss. I said, with the fact that you being my new parole officer, the biggest problem that I'm having is that I can't find employment, and can you please help me? So within that time, on a Friday, she recommended 2 places for me to get an application filled out. Instead of filling out 2 applications, miss, I filled out 4 applications and I sent it to her. So that was on a Friday. The next Friday, which from Monday to Friday, I didn't hear from her. And then that following Monday is where she called me in to tell me to come down to her office, where they took me to New Haven. So, and she told me that I violated because special parole. So I just would like to point the fact that when you let me out on from May all the way to September 15th, miss, I worked so hard to get a job. And she could tell you the day before, well, the next day, because September 15th, when they took me in, miss, September 16th, I was supposed to start my job making $19 an hour. And she knows this. Number 2, due to the fact that I was supposed to be starting my job the next day doing flagging, I was supposed to be receiving 2 $720 stipends from CRT because I received the job. Number 3, you can look and you can talk to my counselor at the American Job Center. I went down there soon as I was released from prison, and I did all the necessary steps for me to get a grant for $7,500 to get into CDL school so that I can get a career. Nobody was helping me. So when these people call me down and they tell me, and nobody's explaining to me, or nobody got in touch with me to tell me, oh, Mr. Miller, this is what happened. Do you want to be able to self-sponsor? Do you want to do this? Do you want to do that so I can keep a job? Nobody spoke to me. That's number 1. Number 2, since I've been in the community, miss, I never had a dirty urine. I never missed curfew. When I was supposed to go to my meetings for anger management, everyone I went to, I conducted myself out into the community like I was supposed to. when it came
Tell
to
me, I want to know what you're gonna do when you go back out now. I
Well,
know
miss-
we talked about that. What's your plans when you go back out?
All right, well, I don't know if she knows this or you know this, but miss, I discharged in May. So
I
when
know.
she says, 6 months, the biggest
I know
problem that I
when
have
you
right.
discharge.
All right,
Yeah.
so miss, the biggest problem for me right now is that if I'm released, I'm gonna be homeless. So it's like, okay, you're saying I leave, like you can't do anything, I discharge. But the reason why I was working so hard and why I was doing everything that I missed because I don't want to be homeless. So you're telling me that, okay, Mr. Miller, you got a job and you got a career, but now you're telling me 6 months, you want me just to go back out
Well,
to
listen,
society?
that's not. I want to know what your plan is. She made just a recommendation. I wanted you to tell me what you want to do when you get out. What are you planning? You need housing, obviously. So what area would you want to go to housing?
Miss, my whole thing is that I established myself in Hartford. I go to school there. I got employment there. Miss, I understand. I never deviated from my course from what I was told to do. Like before, when I came in front of you and my lawyer said my charge while I was arrested, they threw my case out. So it's the thing with me, miss, is that I understand from sitting in here that I have to learn how to be patient. I came out of jail with so much ambition, and I didn't understand that I have to have patience, and that's it. I have to have patience. I just have to understand that sometimes you can't move things. Things just have to move by themselves. And I just want to go out there and conduct myself and get my career, because I had my family talk to the guy at the American Job Center. He said that I might have to do everything, but I could still get my grant. I understand, miss. I have to get a career. I have to get out there and I have to work. And I only have a limited amount of time from here to May. So I need to get a job. I need to be able to get a place to stay. I don't have a place to stay. All my family lives out of state.
So you're saying you want to go to Hartford, correct?
Yeah, that's miss. Everything is established there. My credit union is there. My grant from the American Job Center is there. My job is there. My family lives in West Hartford, meaning that I have a nephew who his mother and them has my car in their garage right now with my stuff, because I had to take my stuff out of storage. I went up there and I established my whole life. And the reason why I don't want to go back to Bridgeport or to that area is because, miss, I'm trying to not get caught up into selling drugs again. Somebody died in my case, so their family members live in New Haven and Hartford. They feel some type of way. Miss, I'm just trying to do the right thing and move.
Hold on. So you said you wanted to go to Hartford, is that right?
Yes.
Okay,
yes.
so you want to go to Hartford, you want to go back to American Job Center.
Yes.
What else do you do when you get out? Are you going to attend meetings, or what is your plan?
If I have to finish up my anger management, I'll go to anger management. I have no problem with that.
Okay. Is there anything else from either side before I make a recommendation?
If he gets put back in a halfway house, he has to understand that Miller, if you go back to a halfway house, you have to understand you need to comply with the intake, okay? You do have the right to self-sponsor if you can find a sponsor, but you cannot refuse housing or you're going to end up in the same position.
You understand?
We're not going to do this a third time.
Yes, ma'am. Yes, ma'am.
Okay. You need to understand that.
All right. So I've listened to testimony today from both sides. I have reviewed all the evidence. I did want to put on the record that the offender does EOS May 16th of 26. He did come back on the same day for a reinstate that was done previously. There is one prior violation, no misconduct. He's only out there a day before he came back. Based on all the information I have, I am going to recommend that parole be revoked to be re-paroled for January 29th, 2026, about a 4-month period of confinement as a sanction. I recommend the following parole conditions: halfway house placement, behavior management program for anger management, no contact with your co-defendant, Anthony Patterson and Kevin Preston, no contact with your victim, family of deceased victim of your offense. operation of motor vehicle and general no contact Curtis Easton. My findings are going to the parole board on December 18th. So the board, they can lessen that sanction, let it stand, or impose a sanction longer than what I recommended. If they want a longer sanction, you'd have a supplemental hearing. Do you have any questions, sir?
Miss,
So
I just want to get up.
Obviously, you know that because you don't have housing, you're going to be going to halfway house. So I don't expect to see you again. I expect that you are going to comply. You know you need to comply. You know you have plans to stay out there. I'm trying to give you a one final shot to get the help and assistance you need before you are completed with your sentence, which you do have a flat sentence that ends in May. So I'm trying to give you this opportunity. Like I said, it is up to the parole board. So December 18th, the board's going to make that decision. You're going to get it in writing about a week after that from the board. It'll tell you if they agreed with me or not. If they decide anything else, you'll know. It'll stay on your disposition you'll get from the parole board. Okay?
Yes.
Okay. So we're all set for today. That concludes the revocation hearing. Thank you, P.O. McClegg.
Thank you.
Have a good day, both of you.
Bye.
Yeah, once they're gonna come back down in a second, and they just gotta make sure that they put their mic on. All right. Because otherwise you won't be able to hear them.
Good morning.
There we go. All right, good morning.
What's your last name, sir?
Kennedy.
Good morning.
Good morning.
Morning. All right, Mr. Kennedy, we're here today for your revocation hearing, so we're going to get started with that. Everybody's here.
All right.
Good. Yeah. Good morning. I am P.O. Meissner, hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Kennedy Lamar, number 397921. Today is December 9th, 2025. This hearing is being conducted via video at the BOPP Central Office in McDougall Walker Correctional Institution. This is a public hearing, public access. This hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record, sir?
It is Lamar Kennedy, 397921.
Thank you. We have parole officer present. Can you please identify yourself?
Parole officer Dunn, Hartford Parole.
And we have counsel here
Sure.
today.
Attorney Alfonso Sirico with the Parole Revocation Unit. May I just put one thing on the record? Mr. Kennedy, I'm not sure if my message made it to you. You were scheduled on November 26th. We were all ready to go. There was an issue at the facility with the video equipment. That's why you got moved to today. I did call and speak to your counselor. I just wanted to make sure it was not our fault that we didn't go forward on the 26th, okay?
Yep, I know.
All right,
Appreciate
perfect.
that.
Thank you. All right, no problem.
So this is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better awaited evidence must establish that more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation on one or more conditions of your parole, I'll reinstate your parole since releasing you and place you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as the appropriate sanction. My recommendation will be given to a panel for final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge, state your appeals bring against you. I will review and identify exhibit file for the record. The state will have an opportunity to present our relevant testimony. After the state is finished, counsel will have the same opportunity. After considering all the evidence presented, I'll announce my findings. If I find you violated one more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, counsel will have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
No, I do not.
Okay. Okay. You have important rights today. Right to have an attorney present. You have counsel here. You have a right to receive the written notice of charges of violation. Did you receive the written notice?
Yes.
You have a right to review the evidence. You have a right to submit evidence for your case. At this hearing, you have a right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes, I am.
All right, so you'll now review the charge the state your parole officers bring against you and the information underlying each charge. So P.O. Donnie, please read the charges.
Okay. Charge number 1, GPS. On 5/3/25, you did not charge your assigned GPS unit as instructed, and as a result, the unit shut down from 9:14 p.m. until 5/4/25 at 3:34 a.m., leaving you unaccountable in the community for over 6 hours. On 5/9/25, you did not charge your assigned GPS unit as instructed, and as a result, the unit shut down from 5:39 a.m. until 12:33 p.m., leaving you unaccountable in the community for almost 7 hours. On 5/10/25, you did not charge your assigned GPS unit as instructed, and as a result, the unit shut down from 4:48 p.m. until 8:41 p.m., leaving you unaccountable in the community for almost 4 hours. On 5/6/25, you violated your parole sanction curfew of 9 p.m. and did not return home until 9:10 p.m. On 5/20/25, you did not charge your assigned GPS unit as instructed, and as a result, the unit shut down from 3 a.m. until 3:19 p.m., leaving you unaccountable in the community for over 12 hours. On 5/24/25, you violated your parole sanction curfew of 9 p.m. and did not return home until 9:17 p.m. On 6/3/35, that one, do you want me to read that even though we didn't?
No, the only charge, you charged them with GPS.
Okay, yep. On 6/4/25, you violated your parole sanction curfew of 9 p.m. and did not return home until 9:06 p.m. On 6/20/25, you violated your parole sanction curfew of 9 p.m. and did not return home until 9:28 p.m. On 7/7/25, you reported to Hartford Parole and were instructed not to return to an address as Parole was investigating claims of an incident occurring there. You stated that you understood and would not return there under any circumstances. The residence was then entered as a victim zone in your GPS. Later that same day, you violated that zone and went to that address.
Thank you.
You're welcome.
And can you please read the evidence?
Yes. The evidence introduced is the remand to custody order, the signed Connecticut parole conditions, notice of parole violation report, misconduct dated 5/13/25, Allied Universal event log from 5/3/25 to 5/6/25, misconduct dated 5/29/25, Allied Universal event log from 5/20/25 to 5/24/25, misconduct dated 6/5/25, Allied Universal log from 6/3/25 to 6/4/25, misconduct dated 6/12/25, Allied Universal event log from 6/7/25 to 6/7/25, call log / note from P.O. Shep, Allied Universal event log from 7/7/25 to 7/7/25, and signed GPS agreement.
Thank you. Did you receive notice of parole violation report, and those other documents that were just marked? And did you review them, sir?
Yes, I did.
And counsel's filed the following exhibit for identification is Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. We also received the addendum from PCS. Can you please read the addendum that was submitted?
Yes.
Thank you.
Yes. In a previous parole violation report from 2023, the subject was charged with obedience to the law for a charge of CGS 53-155, tampering with or fabricating physical evidence. On 10/15/25, the subject was seen before a judge at GA 14 in regards to docket number H14H, CR 25-0768576-S. The subject pled guilty, was found guilty, and sentenced to 5 years jail, execution suspended after 1 year, probation 2 years. pertaining to the current parole violation, after Kennedy was incarcerated on 7/8/25, he was subsequently arrested by warrant by Hartford Police on 8/1/25 for the crime of CGS 53A-64CC, strangulation, suffocation, 3rd degree. The victim of the crime was the same victim that he violated the victim zone in his current GPS technical charges. On 10/15/25, the subject was seen before a judge at GA 14 in regards to docket H14H CR25-0772292-S, where he pled guilty to his crime of assaulting a female and was sentenced to 6 months jail.
Thank you. So I do want to know, that strangulation second 6-month jail sentence, the EOS date on that sentence is 1/29/26. The EOS date for the 1-year jail sentence is 5/5/26 with a, we have TS of 11/4/25 for that. So we have no other additional evidence. Do you need to continue the hearing with any additional evidence? We have no witnesses today. At this time, the state is going to have an opportunity to present evidence, to speak to any of the evidence submitted. P.O. Dunn, as well as Mr. Kennedy, I'm going to swear you both in today in the event at any time you would like to speak. So can you please raise your right hand? You solemnly swear, solemnly affirm, as the case may be, the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
I do.
I do.
All right, so P.O. Dunn, would you like to say anything in regards to the charges?
No, nothing besides, I mean, the biggest part of it, everything kind of stems into what happened in the body of the addendum. As we can see, he was charged after the fact due to his actions of what happened on 7 earlier before 7/7. So other than that, it pretty much speaks for itself. Just that Kennedy was charged. The report itself blatantly states that the victim reported that Lamar began assaulting her by punching her, kicking her, and at one point put his hands around her neck and choked her. Dill reported that Kennedy punched her in the eye and stomped on her a couple of times as well. Dill reported that she had trouble breathing when Kennedy put his hands around her neck, but did not lose consciousness. We just want to point out that he did plead guilty to this, and he is currently incarcerated serving time for that right now. And this was a behavior that he committed while he was out on parole. And that's where we stand. Thank you.
Is now defense's opportunity to speak to any evidence?
Yeah, just a couple quick questions for P.O. Dunn because we have the disposition from the court. P.O. Dunn, just to clarify, I know the hearing examiner is aware of this. The incident where he received the 5 suspended after 1 with 2 years probation, you're aware that incident occurred in July of 2023, correct? July 19th of 2023. Okay.
Yes.
So he was out on supervision, and because of that arrest that occurred, I think in actually January 14th of 2025, not arrested until January 14th of 2025 for an incident that occurred on July 19th of 2023. Is that's correct?
Yes.
Okay. So the new incident is the one that occurred in July with the female victim, correct?
Yes. The 2023 incident, he had that settled. We just wanted to make the board known that something that occurred in a prior parole violation that we charged him with was settled. We really have no interest in that whatsoever. We just wanted to go on record for a prior time that we hit him with the charge that we found out that he was sentenced on this, and we wanted the board to be known about it. In regards, we care more about the second charge about what occurred in July.
And one other question regarding the GPS, the charge, I broke them down into parts, but 1, 2, and 3, May 3rd, May 9th, and May 10th, where the unit was not charged. Do you recall having a conversation with Mr. Kennedy at some point after those violations of him not charging his GPS unit?
No, I do not recall a specific conversation.
Okay. Do you recall at any point in time, having the units swapped out?
The unit might have been swapped out, but that does occur from time to time.
Okay. And
if that does happen, though, we we take that into account. We do check their charge history. And we also tell the offenders if they believe there's an issue with their GPS, they need to let us know. At the same time, if that did happen and he signed a misconduct, he was stating that he understood that he did something that he wasn't supposed to be doing, such as not charging a unit.
Sorry, I'm not this, I apologize, the feed is
Lagging.
it's lagging a little bit.
Yeah, it is on my end too. That's not a problem.
All right. So Lamar, a couple quick questions. Do you recall speaking to your parole officer regarding the GPS shutdown for May 3rd, May 9th, and May 10th at some point? Or did you speak, you spoke to Mr. Dunn or a different PO?
I believe it was done. He told me to call in about, he called me personally. He told me to come in about the GPS monitoring because he was having issues with it, that he's saying that it wasn't like, he said that it wasn't showing up, like, it wasn't showing up. He said, he knew it wasn't me. He told me to come to the office. I came in, he swapped it out, and that's when he swapped out what's the name. That was also my day I had to see parole on that Tuesday. He told me to pretty much come in for a monitor swap.
Right. And do you recall roughly when that unit was swapped out, if you recall?
I know it was before July. It was right before July. It was recent because I had seen parole every 2 weeks. So it was right before that. So I was due for parole July 8th, that Tuesday. So 2 weeks before that, about 2 weeks before July 8th.
Okay. All right. I don't have anything else to add. I just want to put on the record that my client did indicate to me there was some issues in May. He did indicate to me he did speak to a parole officer, and as parole officer and my client indicate that unit was swapped out at this time. I'm not disputing what PO Dunn put on the record regarding the misconduct. I know how this works, but just want to make it a record that the unit was swapped out because there were some issues with it.
Thank you. So what I'm gonna do next is I'm gonna announce my findings. So regarding that charge 1, I do find you violated that condition GPS based on evidence provided in support of the charge, exhibits B, E through O. So that includes the fact-finding portion of the hearing. Before I make a recommendation, the state will have an opportunity to speak your background and history. After the state is finished, council will have the same opportunity. The purpose part of this hearing is to help determine what outcome I will recommend. So at this time, PO Dunn, would you like to make any statements regarding the offender's violation, background, or history at this time?
No, nothing further at this time. Thank you.
This is the last time to speak.
Yes,
If you
that's
have
fine.
anything you wanted to add at all?
No, just I think we've spoken about everything we need to in regards to the state's position on Mr. Kennedy so far.
Okay, thank you. So I'll
Thank
turn
you.
it over to council.
Yes, on behalf of Mr. Kennedy, my client is 26 years old. He does have one child. On his previous release, he was sponsored by Ms. Rivera in Hartford. He was at that address until he was remanded. And his previous release on discretionary parole in 2022, he was at the Connecticut Renaissance Halfway House program in Waterbury. He was in the process of attending a course in person to obtain a security guard card. As far as employment, his recent positions held on supervision. He indicated to us full-time security for Security Ministries out of East Hartford for approximately a month, and construction, working out of Hartford, doing various jobs, tear downs and ventilation in homes. And also previously, while Renaissance CC indicated did have a job at Connecticut Silver Doors in Oakville, and this was through this Steadfast Tent Agency in Waterbury. I also worked at various security establishments in West Hartford, and also had a side job for a moving company. He indicated to us, looks like October of 2022 to December of 2022, just successfully complete the outpatient cognitive therapy at Connecticut Renaissance in Waterbury. He is on the wait list for the New Thoughts program. He does have a sponsor in his Texas door in Hartford, and I provided you with the phone number and it on the road with the understanding he needs to comply in Connecticut. He'd like to transfer to North Carolina because that's where his mother is currently residing. He does want to complete a security guard card and is interested in returning to school to study social work. Lamar, anything left about your background or what you want to do when you get off? If you want to add anything, that report that we submitted, she has a copy, the PO has a copy. Anything you want to add, now's the opportunity.
Anything else I want to add to that? Not really. It just, not really.
Okay,
I do,
thank
but
you.
I got nothing.
So I'll be right with you with my recommendation. Deal done. Do you know the victim's initials?
1 second, please.
Or Mr. Kennedy, do you know what the initials are of your victim?
Yeah, it's YRR.
YRR?
Yeah.
What was her relation to you?
That's my child's mother.
Child's mother. Right, two things I'm gonna put on the record before I make a recommendation. You were out in the community for less than 3 months before you were returned to custody, for this violation. You did get the two new convictions that were noted, and received the 1-year jail sentence, as well as 6 months jail sentence for the strangulation second, which is related to domestic violence. As I stated, the TS date is 11/4/25 for eligibility, which has passed. Your US date was 5/5/26 off those new charges. You are on special parole until February of 2027. This is, you have a prior violation for absconding, receiving new charges, where you did 1 year previously for that. Based on the information I have, I'm going to recommend that your parole be revoked, that you be reparoled for May 5th of 2026, which is approximately 10-month period of confinement as a sanction. This is the US date on the new conviction that was noted in the PPR addendum. I recommend the following parole conditions: no consumption of alcoholic beverages, mental health evaluation, and medication and treatment deemed necessary, behavior management program for domestic violence, no contact, YRR without PO's permission. My findings are going to the parole board on December 18th. So the board can lessen my sanction. They can impose a longer sanction or let mine stand. If they want a longer sanction than what I've recommended, you have a supplemental hearing and they would bring you before the board and let you know the reasons why they may want to exceed that recommendation. During the supplemental hearing, you would have an opportunity to speak to the panel of the board. You will get this in writing from the board, what their decision is about a week after December 18th, as well as what your conditions would be.
So Lamar, if there's any issues with that recommendation, when we get the report from the board, I'll reach out to you if I need to, okay?
Okay.
All right, good luck. Good luck. Thank you, Pierre Dunn.
Thank you.
Thank you. Have a good day.
You too, take care.
You too.
Already know one guy started talking.
We left. I'm in, hopefully that was me. Mate. Man? Yeah. Thank you, bro. Thank you, brother. I'm in. All right.
Appreciate it.
Good morning, Mr. Fitzpatrick.
Morning.
Morning. We're here today for your preliminary hearing. We're gonna get started, okay?
All right.
Good morning. I am Peel Meister, hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing for Fitzpatrick John number 415780. Today's December 9th, 2025. This hearing is being conducted via video at the BOPP Central Office in McDougall Walker Correctional Institution. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Sean Fitzpatrick, 415780.
Thank you. We have counsel here, to identify yourself.
Sure. Attorney Alfonso Sirico with the Parole Revocation Unit on behalf of Mr. Fitzpatrick.
This is a preliminary hearing, which is the purpose of the Connecticut law is to determine if there is probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has responsibility to show there's probable cause to believe you violated one or more conditions of your parole. If I do not find probable cause, I'll reinstate your parole and release you and place you back on parole supervision. If I find probable cause and determine the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know a preliminary hearing is an adversarial proceeding. Anything you say this hearing can be used against you. This hearing is being recorded. So this is the procedure for today. I'm going to read you your rights. Then we'll review the parole violation charge. The state your parole officer is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to just issue a probable cause and severity of the allegations. At the conclusion of the hearing, I'll inform my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
Nope.
Okay, your important rights today, right to have an attorney present, you have counsel here. You have a right to receive the written notice of charges of violation. Did you receive the written notice?
You did.
Yes.
You have a right to review the evidence. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes.
We will now review the charge, the state your false claim against you, and information underlying each charge. The charge 100 bail laws will be into the law. Your charging officer reported at 5/19/24. You were the driver of a stolen white Infiniti that intentionally rammed into an East Hartford police cruiser. You did this with a 4-year-old child in the back seat. You then violently reversed the vehicle in the direction of a man holding a small child and a female. The man and child he was holding was thrown towards the building. The female was thrown to the ground. The child in the backseat of the car you were driving was thrown out of the vehicle to the ground against a concrete wall. The vehicle you were driving nearly ran all 4 individuals over and pinned them against the wall. You then accelerated your vehicle towards the East Hartford police officer, nearly hitting him. You then continued to ram the police cruiser in an attempt to flee the location. The East Hartford police officer had to deploy a service weapon at your vehicle as you were using your vehicle as a deadly weapon likely to cause serious injury. You were then able to leave this location and you drove the car to Hartford where you exposed the vehicle, which was under your sole possession and control during the incident. Subsequently, due to your actions and behaviors, you were charged with criminal attempt to commit assault on a police officer, 2 counts of reckless endangerment, 2 counts of injury to a minor, possession of a stolen vehicle, and evading responsibility. You were arraigned at GA12 and have an next court date of 12/17/25. Charged 200 no driving. Your charging officer reported you were driving a stolen vehicle in the commission of a crime on 5/19/24. You rammed a police cruiser and almost ran over 4 people. You were never given permission at any time to drive a vehicle from your assigned parole officer. And so in regards to that charge number 1, conditional bail laws will be into the law. Judge, Superior Court, State of Connecticut has determined there's probable cause to believe that you committed the crime of criminal attempt to commit assault on a police officer, 2 counts of reckless endangerment, 2 counts of injury to a minor, possession of a stolen vehicle, and evading responsibility. Cannot revisit this finding, therefore the charge is not considered at the hearing. This means there's no need to take statements, testimony, or review evidence regarding charge 1, conditional bail laws will be into the law at this time. The state has filed the following exhibits are pre-marked for identification purposes as Exhibit A, signed statement, understanding agreement, conditions of parole. B, remand to actual custody order. C, violation notice, parole rights. D, parole violation report. E, state of Connecticut, judicial branch pending case detail. F, BOPP information summary. G, revocation summary. H, arrest warrant and police report from East Hartford Police Department. Did you receive notice of parole violation report, and those other documents I marked? And did you review those?
Yes.
Do you need to continue sharing to take
No.
additional evidence? We have no witnesses today. Is now defense's opportunity. If you'd like to respond, make short statement and testify with respect to probable cause.
Yes,
Severity of the allegation.
correct. Regarding the finding of probable cause, I'm not disputing that, but I need to put some things on the record that directly tie with this particular charge. I previously represented Mr. Fitzpatrick. It was technical violations and it was a criminal charge which was nollied in court. So my client was actually remanded on September 19th of 2024, as I indicated, for a technical and criminal violation. Those charges were resolved in court on December 17th of 2024. The information I have here, the addendum from the case that was resolved on December 17th of 2024 was not received by the Board of Pardons and Parole until October 10th of 2025. So if my math is correct, that's approximately a 10-month wait to have my client scheduled for his revocation. I'm not sure what happened to the regulation, section 54-124A-J1-7, where it indicates under subsection A, the supervising parole officer shall monitor the status of a criminal prosecution of each offender accused of violation of parole based upon criminal conduct, which there was a criminal charge, no later than 14 business days following any new conviction. My client's conviction was on December 17th of 2024. The supervising parole officer shall report to the board the circumstances regarding the conviction. Was not 10 months. The issue with this regulation is there's no remedy if the 14 business day rule is violated. So my client was held for 10 months when he should have been scheduled for a revocation hearing within 14, not scheduled, the addendum should have been submitted. And it was not received at the board until October 10th of 2025. Now, we had a revocation hearing on the underlying one on November 6th of 2025. So my client had technical violations, the criminal charge was not in court, and he received a 14-month sanction, which is way outside the typical range of technical violations, in my opinion. But the hearing examiner did do the right thing and re-paroled my client. His new re-parole date was November 20th of 2025. Now, while my client was incarcerated on the remand from 9/19/24, there was a new warrant that was served on my client on January 4th of 2025, which ties in with this current violation, which is the obedience to the law and the driving. January 4th of 2025, a new warrant is served on my client for an incident that occurred in May of 2024. So that's even prior to my client's remand on the original. This is supposed to be a impartial and fair system. So he's served a new warrant in January of 2025. He's violated on another incident. His new re-parole date is 11/20/25. Is it coincidence or is something not right here where the new remand for that incident is not served until his new re-parole date of 2025? I don't think it's coincidence. I'm not sure how this is a fair system. We're 10 months late with the addendum. He served a new warrant in January and we let another 10 months go by before he served with the remand. So he thought he was going home on November 20th because that was his new re-parole date, with the understanding that there was a bond to be posted. His mother contacted a bonds person and she was told, sorry, there's a hold. And she's like, well, that warrant was served in January. Why did they wait 10 months to remand him again? I did have an answer for her because it's typical that they wait until the day when he was re-paroled. So he sat for another 10 months, and on his new re-parole date, this warrant that was served on him in January was brought up 10 months later. I'm not disputing that there's a case pending, the probable cause. I don't have any issue with that. I just need to give you a timeline of what's going on here. Mr. Fitzpatrick has not been treated fairly in this process. I'm not casting anything. It's PCS. How can they sit on a addendum for 10 months? My client, we could have wrapped that up and he could have potentially posted bond prior to the other warrant being served on him, but we won't know that. So there's a regulation, but the regulation doesn't state what the remedy is if they miss deadlines. So I just want to make the record abundantly clear what's going on for Mr. Fitzpatrick's case here. I know he has a case pending, and I know we're not going to have a revocation now until this case is resolved, and he's been sitting since September 19th of 2024. Thank you.
Noted.
And if I just say, Deshaun, is anything I just put on the record inaccurate?
Besides, the only thing that was wrong was the date. The date he didn't serve me. He didn't remand me until the 25th. I was supposed to go on the 20th. He didn't.
Yeah.
Let
me clarify that. I apologize. We did speak about yesterday. The actual, to the credit, the actual remand of custody is dated 11/20. They have 3 business days to notify you. If you look at the calendar, give me 1 second. I apologize. You beat me to that. I should have put that on the record also. Give me 1 second.
It's 2 business days. You're right. It's 2 business days.
That part is correct. It's Friday, Thursday is the 20th. So you have Monday, Friday was the 21st, Monday was the 24th, 25th. So that part, the only thing that was done within the time frame was the 3-day business for that. I don't have an issue with that. Thanks for bringing that up. So yeah, I agree with that.
Okay.
Thank you.
I'm going to announce my findings with respect to charge 2. So regarding charge 2 condition, I make a finding of probable cause, no driving based on evidence presented, which exhibits A and H. I do find the act of serious enough to warrant revocation. Attorneys should detain while you wait for revocation hearing. At the rep hearing, myself or another hearing examiner will determine if you violate conditions via parole. If so, the hearing examiner will make recommendations regarding whether your parole is to be revoked, what any sanctions should be imposed. So upon disposition of those charges, we bring you back and determine if there's a violation or not. Do you have any questions?
No.
Deshaun, as soon as that case is resolved, I'll set up a call with you. Once I see what the dispo is, we'll have another discussion prior to the revocation, okay?
All right. Thank you.
All right. We're all set for today. That concludes the preliminary hearing.
Yep.
Thank you. Have a good day.
Okay. Thank you.
Good morning.
Hi, good morning.
Morning. Is Mr. Glover there?
Yes,
Can I see him first, please?
okay.
Thank you. Oh, you want me to give you the whole list right now? I
Well, I
can do
have the
that
list,
for you
so-
if you'd like.
Okay, I appreciate it.
Yeah, so I'll see Glover, let's see, that's the only one you have?
Yeah, and it's Neil, we continued it here.
Yes, yes. Can I then see, I'll just go straight down, Merrill, Bobo, Foster, and then Oaks.
Okay, so Glover first, then Bobo, Merrill, and then go down the list you're saying?
Yeah, what is your list?
I got Bobo, Merrill, Oaks, Glover, and Foster.
Oh, so your list is all over the place. So can I see, Glover, then Merrill,
Okay,
then Bobo, then Foster, then Oaks?
okay, thank you so much.
No problem.
Okay. Glover. Glover.
Yeah.
Morning, sir. I'll be with you in 1 second. I just need to put something on the record that does not have to do with you. Okay, regarding inmate Michael Neal, 176673, revocation hearing has been continued to the date of December 29th per attorney request. All right, so we're gonna get started with your revocation hearing. Good morning, I'm Theo Meister, hearing examiner for the Board of Pardons and Paroles. It's a revocation hearing concerning Glover Christopher, number 343503. Today is December 9th, 2025. This hearing is being conducted via video at the BOPP Central Office in Carl Robinson Correctional Institution. This is a public hearing, public access. The hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Christopher Glover, 343503.
You have counsel here today, identify yourself.
Yes, Hannah Dean on behalf of Mr. Glover.
This is a revocation hearing, determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is, the better awaited evidence must establish that more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation or one more conditions of your parole, I'll reinstate your parole since releasing and place you back on parole supervision. If I find you violated one more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. This is the procedure for today. I'm going to read through your rights. Then we will review the parole violation charge the state appeals bring against you. I will review and identify exhibit file for the record. Counsel will then have an opportunity to present a relevant testimony. After considering all the evidence presented, I'll announce my findings. If I find you violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure?
No.
Okay, you have important rights to have an attorney present, you have counsel here. You have a right to receive the written notice of charge of violation. Did you receive the written notice?
Yes.
You have a right to review the evidence. You have a right to submit evidence to support your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes.
All right, so we'll now review the charge the state your posters bring against you. Any information underlying each charge. I will note charges 1, 2, and 3 are not taken into consideration as no findings are made at the time of the preliminary hearing. So charge 4 is halfway house placement. Charging officer report on September 6, 2025, 11:20 a.m. You packed your belongings to exit the Rogers Sherman halfway house without permission. Your whereabouts committee were known until you turn yourself in on 9/29/25. This behavior places you in clear direct violation of your signed parole conditions, especially under halfway house placement, as you violate a rule in your signed halfway house agreement where it states will not leave this confines to the halfway house unless authorized by program staff or parole. You do not have permission from anyone to exit the program. And the state has filed the following exhibits that were marked A through J. These are put in the record at the time of the preliminary hearing, and were noted as received. And council has filed the following exhibit pre-marked for identification expense exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing, contain any additional evidence?
We do not.
Okay, we have no witnesses today, so it is now defense's opportunity. If you'd like to speak to any evidence submitted at this time.
Yes, thank you. No comments concerning the charges, other than to just note that that is accurate. My client did turn himself in and try to do the right thing. He did go to the residential treatment center at Foundation to try to get some help for his substance use, and that was where he turned himself in. But we would, at the appropriate time, like to speak to his background and history. Thank you.
Thanks. All right, so I'm going to announce my findings in regards to that charge. So on that charge 4, I do find you violated the condition of halfway house placement based on evidence provided, which is exhibits D, E, and I. That includes the fact-finding portion of the hearing. Before I make a recommendation, council will have an opportunity to speak to your background and history. The purpose part of this hearing is to help determine what outcome I will recommend. So if you would like to.
Yes, thank you. My client's 37 years old, born and raised in Milford. He received support in the community from his mom and brother, who both live in Connecticut. My client has a history of successfully completing Roger Sherman halfway house. He also previously utilized the REACH program in New Haven while on parole. My client received certifications in advanced manufacturing technology, OSHA 10, and quality control through Housatonic Community College, and also got a CertSafe certification as well. In addition to the schooling, my client has a prior employment history that includes Ramstead LV Fulfillment Center in Wallingford and Madison Polymetric Engineering. My client, as far as treatment goes, was doing the Act Foundation inpatient program prior to that, which he did successfully complete. Prior to that, he had done the First Step Detox program in Bridgeport. He also was doing IOP and Act Foundation after he stepped down from inpatient treatment. Since being remanded, my client requested additional programming for substance use and has been on the wait list for that. He also has received no disciplinary reports during this period of incarceration. Upon reinstatement of his parole, he would like to be placed at a New Haven area halfway house. He hopes to return to school to obtain his associate's degree in advanced manufacturing technology and hopes to find a job in his field, but is open to all available opportunities. He's also open to returning to the Act Foundation and also utilizing 12-step programs in the community for additional support. I am asking you to consider releasing my client for the next scheduled board review date. I believe that this is his first violation of this term of special parole, and he has been incarcerated since, I believe, the end of September. Again, I will just note that I think he did do the right thing by going to Act Foundation to get treatment and for turning himself in, which I think deserves some consideration. Mr. Glover, is there anything that you want to say at this time that I didn't cover?
Another certification I have is a recovery coach, and I have been going to Alcoholics Anonymous meetings. I've recently been put on the active list, so I've been going to those also.
Perfect. Thank you.
Thank you for your comments. So I have reviewed all of the evidence and I have listened to testimonies. A few things I will put on the record. You were in the community for 3 months and 20 days on special parole before you were returned to custody. Your whereabouts were known for approximately 23 days. Prior, you were on parole supervision for about 1 year and 7.5 months, I believe, before you started special parole. You don't have any prior violations. There is one misconduct that was issued. Field was requesting 1 year incarceration. I will note that no findings were made on 3 of the 4 charges. Based on the information that I have, I am going to recommend that parole be revoked, be re-paroled for December 29, 2025. It's about a 3-month period confinement as a sanction. I recommend the following parole conditions: halfway house placement, no consumption of alcoholic beverages, mental health evaluation, treatment deemed necessary, no contact with your victims, EK and KK. My findings go into the parole board on December 18th. So if the board agrees with me, you'd be released December 18th, December 29th. So you'll get a written decision during that week, what the board's decision is. So they can agree with me, they can let you out as soon as 12/18, or they can also hold you in longer. Just so you know, that is a possibility. Do you have any questions?
You meant, December
29th,
29th?
recommended.
So we'll know for sure on December the 18th. The Board of Pardons and Paroles just has to vote on the recommendation she made. So if you would like to either call my office on the 18th, or if you prefer, I could set up a call with your counselor to update you on what happens. We can definitely do that.
Okay.
Okay, so you are all set for today, sir.
All right. Thank you very much.
Good luck.
Have a great day to both of you.
Thank you. Take care.
Good morning, Mr. Merrill.
Good morning. How are you?
Good morning. Good morning, Attorney Jones.
Good morning. Sorry, I was muted.
That's okay. All right, we're here today for your revocation hearing. Do we have P.O. McHugh here?
Hi, good morning.
Good morning. Were you able to fix the issue?
I was not, so I'm just calling in over the phone. I have a help desk ticket in for the video.
Okay, gotcha. All right, so we'll get started. Good morning, I'm P.O. Meissner, hearing examiner for the Board of Pardons and Paroles. It's a revocation hearing for Merrill Trenton, number 435340. Today is December 9th, 2025. This hearing is being conducted via video at the BOPP Central Office in Carl Robinson Correctional Institution. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record, sir?
Yes, Trenton Merrill 435340.
Thank you. We have a parole officer present. Please identify yourself for the record.
Hi, good morning. Parole Officer McHugh of Hartford Parole.
And we have counsel here today. Please identify yourself.
Yes, thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit, on behalf of Mr. Merrill.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better read evidence must establish that more probable than not, the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which is releasing and place you back on parole supervision. If I find you violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction. My recommendation be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. This is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state your PO is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to present a relevant testimony. After the state is finished, counsel will have the same opportunity. After considering all right to review the evidence, you right to submit evidence in support of your case. At this hearing, the right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes, ma'am.
Okay, so we will now review the charge the state or falsers bring against you and the information underlying each charge. So P.O. McHugh, please read the charges.
Do you need to swear me in or I'm good?
I will swear you in after.
Okay, got it. Just making sure. All right, the charge Mr. Merrill received is for obey all laws on September 16th, 2025 at approximately 8:10 p.m. You were involved in a verbal altercation at 200 Blue Peel Avenue. You admitted to spitting on the victim several times during this altercation. Subsequently, you were arrested for Connecticut General Statutes 53A-182 disorderly conduct. You arraigned out of Hartford GA 14 on docket H14H-CR250773-120-S and given a future court date of 10/29/2025.
And could you please read the evidence and the addendum?
Sure. The evidence is going to be Exhibit A, remand to actual custody, Exhibit B, notice of parole violation, Exhibit C, parole violation report, Exhibit D, conditions of parole, Exhibit E, Hartford PD incident report case number 25-021912, and Exhibit F, State of Connecticut pending case detail. The addendum states it was submitted on November 3rd of this year on 9/16/2025. Trenton Merrill inmate number 435340 was arrested and charged with Connecticut General Statute 53A-182 disorderly conduct on October 29th, 2025. This charge was nully out of Hartford Court GA14 on docket H14H-CR25-0773120-S. A state police record check rap sheet provided that on November 3rd, 2025 to confirm this information, and it was scanned in under evidence.
Thank you. Did you receive notice of parole violation report, and the other documents that were just marked? Did you review them, sir?
Yes.
Okay, and counsel has filed the following exhibit that's pre-marked for identification purposes. Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
No, but may I ask that Defense Exhibit 1 from the preliminary hearing be marked as Defense Exhibit 2 for purposes of this hearing?
Yes. Defense Exhibit 2 will be list of parole accomplishments and future plans for reinstatement. Defense Exhibit 1 is statement from Arizona Phillips dated 10/25.
All right, thank you. Thank you.
So at this time, the state is going to have an opportunity to present evidence and speak to any of the evidence submitted. So P.O. McHugh and Mr. Merrill, I'm going to swear you both in the event that you would like to speak today. So can you please raise your right hand? You solemnly swear, solemnly affirm, as the case may be, the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes.
Yes, I swear.
Okay, so P.O. McHugh, would you like to say anything in regards to the charge at this time?
No, I have nothing else additional to add. Thank you.
Okay, so it's now defense's opportunity if you'd like to speak to any evidence submitted.
Just simply that the addendum is stated accurately. My client did appear in GA14 on October 29th. The case was nollied. He's been in custody ever since that arrest, obviously. Nothing else as to the charges.
Okay. So what I'm gonna do next is I'm gonna announce my findings. So regarding that charge 1, I do find you violate that conditional obedience to the law based on evidence that was provided in support of that charge, which is exhibits D and E. I will note that as was stated, the charge was nullied in court. So that includes the fact-finding portion of the hearing. Before I make a recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. This first part of the hearing is to help determine what outcome I will recommend. So P.O. McHugh, would you like to say anything at this part of the hearing?
No, I have nothing else to add. Thank you.
Okay, we'll turn over to counsel.
Yes, thank you very much. My client's 23 years of age. He is single. He has no children. He receives his primary support in the community by way of his mother, sister, brother, friends, and their parents. So he has an extensive support system in the community. He grew up in Rockville, Connecticut. He was in the community during this period of supervision for, I believe, approximately 18 months. And during that period, he was initially sponsored to his sister's home in Glastonbury. Then he relocated to sponsor to his grandmother located in Ellington, Connecticut. I think it's important to note that he has no history whatsoever of domestic violence. The only incident on his criminal history is the incident for which he is on parole for. He has no other prior criminal history, and that includes no history as a juvenile or no history as a youthful offender as well. I would just point out in Defense Exhibit 1, we stand by the fact that my client denies any allegation that he intentionally spit on anyone, and the alleged victim supports that statement by way of the statement that she provided to our office. Our office shared that statement with his public defender in GA14 who represented him, and the result of that was that the state did not pursue those charges and nollied them. Again, I also would note that that individual was also arrested. It was an argument, a verbal argument as well. My client At the time of his remand, he was initially gainfully employed during the period of supervision. However, at the time of his remand, he was unemployed and looking for employment. He's open to all employment opportunities when he is reparoled. We are asking that he be reparoled at the next available date, noting that he has been in custody for now almost 3 months on this matter. A disorderly conduct carries a maximum penalty of 3 months, and in this situation, that matter was nollied and it was not pursued based on the evidence that we already stated. Upon reinstatement to parole, and I just clarify with my client, he would like to sponsor. Sir, I know you provided my social worker with the information for your grandmother. Is that that's the first information that you would want presented to the board as the place where you'd like to go?
Yes.
Yes, okay, so that information is contained within Defense Exhibit 2, which was just remarked as Defense Exhibit 2, parole accomplishments for my client. And again, he's open to all treatment recommendations as well. I would note that the DIS indicates that he had his offender accountability plan did not include any recommendations, though while he was in the Department of Corrections, I believe he completed 3 programs. It indicates that 0 programs were required. However, he did complete 3 programs. So I would also just point that out to his benefit. Again, we would be asking that he be reparoled at the next available date. Thank you.
Thank you. So I listened to testimony. I have reviewed all the evidence that was provided. As was stated, the offender was in the community about 1 year and 5.5 months before he was turned to custody for the new charges that were nollied in court. There are no prior parole violations. One misconduct was received in this period of supervision. I don't see any prior releases to community release. So based on this information, I am going to recommend that parole be revoked to be reparoled for December 18, 2025. This is my next board review date that I have available. This is an approximate 3-month period of confinement. As a sanction, I recommend the following parole conditions: behavior management program for anger management, no contact with your co-defendants, J1 Soso and Joseph Sandone, a general no contact with R.J.R. Phillips without PO's permission. My findings will go on the parole board on December 18th. If the board agrees with me, you'll be released that day. If the board, for whatever reason, did not agree with me, then you would have a supplemental hearing. You'd come back and the board would talk to you about reasons why they didn't want to exceed my recommendation. So just so you know that that is an option. But do you have any questions?
No, not at this time. Thank you.
If I could just make one comment as well. I would just note that you did indicate a no contact with, I believe, I'm sorry, was it AP were the initials or?
Yes.
Without the PO's
permission.
Without PO's permission. But I also would note a caveat in that my client, that person still has a case pending in court and it's not down for disposition, which I assume it also will be nollied on December 24th. She may still have, he may still be the protected party in her case, in which case I just want PO McHugh to be aware of that as well, that even if he were given permission, he should not have contact with her until her case is resolved.
At this time, I'm just going to do a general no contact with her. So
I mean,
no
I would prefer that
they can change it. They can always change it. So
because I believe that he intends to continue a relationship with her. That's what both parties would like. I'm just putting him on notice that.
Is that what is liked?
Yes,
is this?
That's what she would like, and that's what he would like. Correct. However, I want him to be aware that he should not have any contact with her until her case is resolved. And then once that happens, he should discuss that with his parole officer.
Okay. And this is. And what you need to do and make sure you go over your conditions with your parole officer, because the board's going to vote on your conditions. So the board can make that a strict no contact if they want. So you need to follow what the condition says, as mine are just recommendations. Okay?
Okay.
So just for clarification purposes, you are recommending no contact without PO's permission?
I am recommending it, but.
Okay, thank you. All right, but so you understand everything there, Mr. Merrill?
Yes.
Okay, so communicate with your parole officer in that regard, okay?
Okay.
All right.
All right, so you're all set for today. That concludes your revocation hearing.
Okay, so,
All right.
what's the soonest I can hear, from the board, before the 18th?
No, that is the date, the 18th.
Okay, thank you.
Okay,
Have a good day.
okay, you're welcome. All right, thank you.
Thank you. Thank you,
Thank you. Bye-bye.
Bye. Good morning, Mr. Bowatorn.
Yes, good morning.
Morning. We're here today for your revocation hearing. So we'll get started with that. Good morning, I'm Theo Meisinger, hearing examiner for the Board of Pardons and Paroles. The revocation hearing, Attorney Bobo Torre, number 432726. Today is December 9th, 2025. This hearing is being conducted via video at the BOPP Central Office in Powell Robinson Correctional Institution. This is a public hearing. Public access to hearings available via video live stream. Can you please state your full name and DOC inmate number for the record?
Warren Bobo, 432726.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence, that is. The better awaited evidence must establish that, more probable than not, the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more conditions of your parole, I will reinstate your parole, dismiss you, and place you back on parole supervision. If I find you violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation be given to a panel for final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. This is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state appeals bring against you. I will review and identify exhibits filed for the record. You will then have an opportunity to present a relevant testimony. After considering all the evidence presented, I'll announce my findings. If I find you violated one or more conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure?
No, ma'am.
Okay, important rights. You have to have an attorney present. Do you want to continue without counsel?
Yes, ma'am.
Okay, you have a right to receive the written notice of charges of violation. Did you receive the written notice?
Yes, ma'am.
You have a right to review the evidence. You have a right to submit evidence in support of your case. At this hearing, right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, ma'am.
We will now review the charges the state or parole officers bring against you. Any information underlying each charge one, or restriction residence. Your charging officer reported on 9/9/25. You left your parole-approved residence at the Sierra Center halfway house on a community pass and did not return. You failed to contact your parole officer or halfway house staff, and you failed to return to the program. On 9/20/25, you were apprehended by Meriden PD and taken into custody. On charge two, under obedience of law, your charging officer reported on 9/20/25, you were found in possession of an aluminum wrapper containing fentanyl. You were subsequently charged by Meriden Police Department with violating, interfering, resisting, and possession of narcotics. Charge three, under halfway house placement, your charging officer reported at 9/9/25, left your only parole-approved residence, Sierra Center halfway house, on a community pass and didn't return. You failed to contact your parole officer or halfway house staff, and you failed to return to the program. Your whereabouts are unknown at this time. Also, your actions violated your signed halfway house agreement, specifically the clause, which reads, I will not leave the physical confines to the halfway house unless authorized by program staff or parole. And the state has filed the following exhibits that are pre-marked for identification as Exhibit A, remand to extra custody order. B, parole violation report. C, notice of parole violation. D, notice of parole rights. E, signed PCS conditions. F, signed halfway house agreement. G, Sierra Center halfway house incident report. H, BOPP rev hearing summary. I, BOPP hearing dispo. J, Meriden PD police report. And K is C2 judicial branch case lookup. Did you receive notice of parole violation report, and those other documents I marked, and did you review those?
Yes, ma'am.
Okay. Do you need to continue the hearing to obtain any additional evidence?
No, ma'am.
Okay. We have no witnesses today. I did receive the addendum from PCS. The addendum reported on 10/3/25. Torn appeared at GA7 on docket ending in 6149 for the criminal charge for interfering, resisting, and possession of narcotics. On 10/3/25, the following decision was handed down. Possession of narcotics, not guilty, and interfering, resisting, guilty with an unconditional discharge. with your total effective sentence being an unconditional discharge. So now is your opportunity to respond to parole violation charges against you. Remember that you may remain silent if you so choose. I'm just going to swear you in under oath so you can speak today at any time. So can you please raise your right hand? You solemnly swear or solemnly affirm as the case may be, the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes.
All right, so would you like to say anything in regards to those charges that I just read you?
Not really.
Okay. So what I'm gonna do next then is I'm gonna announce my findings in regards to those 3 charges that I read. So regarding that charge 1, I do find you violated the condition residence. This is based on evidence that was presented, which is exhibits E and G. On charge 2, I do find you violated the conditional obedience to the law based on your conviction of interfering, resisting, and received a sentence of unconditional discharge, as well as exhibits E, B, and J, which support the finding. And on charge 3, I do find you violate condition halfway house placement based on evidence provided, which is exhibits E, F, and G. So that includes the fact-finding portion of the hearing. Before I make a recommendation, you will have an opportunity to speak to your background and history. This part of the hearing is to help determine what outcome I will recommend. So do you wish to make a statement regarding your background history, plans to go back out? Now is the time for that.
Okay, I do have drug addiction. Since I've been here, I've addressed it by reading the Life Bible study. It coincides with the 12-step program. If I was to be released, I am gonna go to meetings and continue to study and read the 12-step program in the Bible that I have. When I was in the community, I made some good contacts. I completed Strive, which was held at City Hall in New Haven. The lady that did Strive, her name is Yvonne Matthews. I have contact with her. I also met some people through Strive that are giving me possible employment. I also have another contact. Her name is, I believe her first name is Karen, but she's head of human resources, which get jobs for formerly incarcerated people. I do have some support from family, my brother and my sister, a good friend of mine. I just feel like if I was to be released, I would need a reach bed instead of a halfway house. I don't know if that could be arranged or anything like that, but other than that, you know, I just have faith in God that I'll do the right thing.
Unfortunately, I can't place you in a reach bed. I'd have to put halfway house down. Usually we don't roll out to reach beds. It's up to your officer. I don't know if there's beds available in the program. So that would be up to the supervising officer. We put halfway house on there just if you have nowhere to go, we have to put that on there.
Okay.
So you have options, but ultimately, I mean, that would be your goal is to go to that program if you need that assistance. Is there anything else that you would like to say at this time?
Yeah, that since I've been incarcerated, I'm sick and tired of the in and out, the whole street life, drug addiction thing. I just put my faith in God that that He'll help me at least try to cope with my situation.
I appreciate your statements. And you do EOS in March 22nd, 26th right now is your EOS off your sentence. Then you do have 3 years probation to follow. So I'll be right with you with my recommendation. If you were to go to a halfway house, what area would you go to?
New Haven, because I have some contacts and some resources there that I built since my last time there.
Do you have a problem going to a halfway house? I know you prefer reach bed, but do you know what the issue is that's,
Well, I don't have a problem going to a halfway house. It was just kind of difficult and frustrating that I couldn't find a job right away, because I wanted to do the right thing and I needed a job in order for me to, survive out there. So I don't have a problem with a halfway house. It's just sometimes, I get frustrated and,
well, what are you gonna do differently if they put you back in one and the same thing happens? Because it's a possibility that it does take for anybody to get a job. Sometimes it takes a while. So that's unfortunately, I mean, it's a process. So what's gonna happen this time if the same thing happens?
Well, the same thing's not gonna happen because I don't have no plans on doing anything to come back to prison. I'm not coming back to prison. Whether you're giving me a shot now or I EOS, I'm not coming back. And like I said, I have faith in God that He'll guide me in the right direction. That's just what it is now. I do plan on doing the right thing whenever I leave prison, a job or two, because of the way the economy is now. I need a roof over my head. I do think that a halfway house would be a good stepping stone to prepare these steps for me. Yeah.
Well, I hope that you stay there and you utilize the opportunity that you're given, because you're not working, you're not taking, you don't have to pay to live there. It's there to aid you when you first get out. So use the opportunity you have. I understand the frustration in trying to find employment. I mean, that happens. So it's all in what you do instead of making these choices that you did in the past that aren't going to help you. Do you plan on doing any other types of substance use treatment? Because obviously it seems like it's a big issue that you need to address, or else you're going to come back. So I understand you want to do these meetings. Do you feel like some type of programming when you first get out is going to be helpful?
I mean, anything would be helpful, but I feel like 12-step. I was doing CCAR when I was out there.
Okay. Are you going to do that again?
Yes, I am.
Okay. All right. So based on the information I have, I am going to recommend, and this is after testimony today. I did review all the facts of the case. I know you did receive the unconditional discharge for this interfering with all the charges were nolly. There are no prior violations. You are on discretionary supervision. As I stated, till March 22 of 26, you don't have any misconducts that were received, but you weren't out there about a month before you absconded from supervision. It sounds like you do need treatment in the community as well as housing. So I am going to recommend that parole be revoked to be re-paroled for December 22nd, 2025, which is approximately a 3-month period of confinement as a sanction. I recommend the following parole conditions, which is halfway house placement, preferably as you stated in New Haven. I'm going to present this to the parole board on December 18th. So the board can let you out as soon as 12/18 if they wanted to. They can agree with the 12/22 date I gave you, or they can revoke all discretionary parole. You will know about, you might be gone by, if they agree with me, you might be gone before you receive the paperwork. You are discretionary parole, so that's on or after date. And if the board wants a longer sanction, you'd be notified of that, and that they would want to talk to you. And you come back for a supplemental hearing if they decided that. But as I stated, you are done in March. So it's up to the board. You will know December 18th that week. You'll get it in the mail what the board's decision is. okay?
Okay.
So
You said,
just make better choices and get involved in your recovery, as soon as you get out, as well as now continue doing what you're doing. What's your question?
you said that, I might be gone before I get the decision.
Well, I'm saying if the board agrees with my release date of 12/22, by the time we send the paperwork out, you might be paroled already. Because it takes
Okay.
about a week to get to the facility. During that week, you'll get the paperwork from the parole board. So
Okay.
that's what I mean by that. If they agree with me, you might be
Okay.
gone already. But you'll know in that case that they agreed with me because you'd be gone.
Okay.
Okay. So you are all set for today, sir. Wish you best of luck.
All right. Thank you very much.
You're welcome. Mr. Foster,
Yes.
good morning. I'll be right with you, okay?
Thank you.
Good morning.
Hello.
Is your on?
I'm sorry, I totally forgot. I've been
Yes.
really busy.
No, it's okay. I can hear you. Everything's good. We're all here.
I've been with PD on the phone all morning, so I'm so sorry.
Oh, that's no problem.
Officer Meissinger.
How you doing, Dopey?
Hello.
Thank you, Dopane. Okay.
Okay, you all set? I'll just get started.
Yes.
Okay. Good morning, I'm Theo Meisinger, a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing for Foster Michael, number 346678. Today is December 9th, 2025. This hearing is being conducted via video at the BOPP Central Office in the Carl Robinson Correctional Institution. This is a public hearing. Public access. This hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record, sir?
Michael Foster, 346678.
Thank you. We have a parole officer present today. Please state your name for the record.
Parole Officer Barrios.
We have counsel here today.
Good morning, Peter Matthews, the Public Defender's Office for Mr. Foster.
This is a preliminary hearing. The purpose of Connecticut law is to determine if there is probable cause you've been act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant revocation of your parole, and to determine if you should be held in prison pending further proceeding. The state, not you, has responsibility to show there's probable cause to believe you violated one more conditions of your parole. If I do not find probable cause, I'll reinstate your parole, which is releasing you, place you back on parole supervision. If I find probable cause and determine the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know a preliminary hearing is an adversarial proceeding, and in these ways, this hearing can be used against you. This hearing is being recorded. This is the procedure. I'm going to read through your rights. Then we will review the parole violation charge. The state appeal is bringing against you. I will review and identify exhibits filed for the record. The state will have an opportunity to address the issue of probable cause and severity of the allegations. After the state is finished, counsel will have the same opportunity. At the conclusion of the hearing, I will inform you my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure before we begin, sir?
No.
Important rights today: the right to have an attorney present. You have counsel here. You have a right to receive the written notice of charges of violation. Did you receive the written notice?
Yes.
You have a right to view the evidence. You have a right to submit evidence for your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes.
All right, we will now review the charge the state if false is bringing against you and the information underlying each charge. So PO Beers, please read the charges. You're muted.
Hi, I'm sorry. The first charge is obey all laws, obedience of the law. On September 5th, 2025, New Britain PD executed a search warrant at your parole approved address at 153 Grove Street in New Britain, Connecticut. You have access to the basement, which is accessible via the south entrance to the common stairway, as well as the east exterior entrance. The basement is a common area accessible by anyone inside of the residence. During the search, the following items were found in the basement: 5 mature marijuana plants, total weight 23 pounds, 11 small marijuana plants, total weight 6 pounds, 1 plastic bag containing marijuana, total weight 120 grams, and another plastic bag containing marijuana, excuse me, total weight 54.2 grams. Also 1 plastic bag containing marijuana, total 92.1 grams. A cardboard box containing anabolic steroids and syringes, 1 black digital scale, and a straw containing cocaine residue, with several lines of cocaine observed on the top of a laptop. A box with numerous plastic sandwich bags consists with packaging material. When you were being transported to the Hartford CC on September 5th, 2025, you reported to the parole officer that you were aware of the activity occurring in the basement. You also acknowledged using steroid and you cycled on and off to gain muscle mass. As a result of the findings found in the approved residence, New Britain PD applied an arrest warrant, which was granted on November 13th, charging you with the following: 2 counts of possession of controlled substance, possession of drug paraphernalia, operation of a drug factory, possession of more than 1 kilo of marijuana. Based on your behavior, you are in violation of your special parole condition, obedience of the obey all laws, obedience of the law. Charge number 2, drugs. On 9/5/25, New Britain PD executed a search warrant at your parole approved address at 153 Grove Street, New Britain, Connecticut. You have access to the basement, which is accessible via the south entrance to the common stairway, as well as the east entrance, exterior entrance. The basement is a common area accessible by anyone inside the residence. During the search, the following items were found in the basement: 5 mature marijuana plants, total weight 23 pounds, 11 small marijuana plants, total weight 6 pounds, one plastic bag containing marijuana, total weight 120 grams, and another plastic bag containing marijuana, total weight 54.2 grams. Also, one plastic bag containing marijuana, total weight 92.1 grams, a cardboard box containing an anabolic steroids and syringes, one black digital scale, and a straw containing cocaine residue with several lines of cocaine observed on top of a laptop. A box with numerous plastic sandwich bags consists with packaging material. As a result of the finding found in the approved residence, New Britain applied for an arrest warrant, which was granted November 13, 2025, charging you with the following: 2 counts of possession of controlled substance, possession of drugs, paraphernalia, operating of a drug factory, possession of more than 1 kilo of marijuana. Based on your behavior, you are in violation of your special parole condition, obey all laws, drugs. Charge number 3 is weapon. On September 5th, 2025, New Britain PD executed a search warrant at your parole-approved address at 153 Grove Street, New Britain, Connecticut. You have access to the basement, which is accessible via south entrance to the common stairway, as well as east entrance, exterior entrance. The basement is a common area accessible by anyone inside of the residence. During the search, a weapon was found in the basement in a room connected to the common area of the basement. Detective opened a dresser next to a chair and located a handgun. The firearm was determined to be a Taurus G3 9mm semi-automatic handgun, labeled number SNAEL 855479 with 17 rounds in the magazine. Also, the following items were in the basement: 2 boxes of 9mm ammunition, total 83 rounds, various firearm accessories, including 1 spare barrel, firearm mounted light, multiple holsters, and 1 empty 17 magazine. Per your special parole conditions, you are not allowed to be in your possession or control any firearm, ammunition, or any other weapon. Also, you are registered on the Connecticut Deadly Weapon Offender Registry, which prohibits you from possessing or being in the vicinity of any type of firearm or ammunition. Based on the weapon being found in the common area of the basement and you having access to the common area, you are in violation of your parole condition, special parole condition, obey all law, weapons.
Thank you.
You're welcome.
And in regards to charge number 1, conditional bail laws, obedience to the law, a judge, Superior Court of the State of Connecticut has determined there's probable cause to believe that you committed the crime: 2 counts, possession of controlled substance, possession of drug paraphernalia, operation of a drug factory, and possession of more than 1 kilo of marijuana. I cannot revisit this finding, therefore this charge will be considered at hearing. That means there's no need to take statements, testimony, or review evidence regarding charge 1, conditional bail laws, obedience to the law at this time. In the state, filed the following exhibits: pre-marked for identification purposes as Exhibit A, conditions of special parole; B, remand into custody; C, parole violation report; D, notice of parole violation; E, New Britain arrest warrant 11/13/25; F is 13 photos. Did you receive notice of parole violation report, and those other documents I marked, and did you review them, sir?
Yes.
Okay, and counsel filed the following exhibit, which is pre-marked for identification purposes: Defense Exhibit 1, Connecticut BOPP Rev Summary. Do you need to continue this hearing to obtain any additional evidence?
No, I don't.
Okay, we have no witnesses today. So at this time, I'm going to swear in Mr. Foster as well as P.O. Barrios in the event that you would like to speak during this hearing. So can you please raise your right hand? You solemnly swear, solemnly affirm, as the case may be, the evidence you shall give concerning this case to be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes.
So at this time, the state will have an opportunity, if you'd like to make a short statement and testify with respect to probable cause and the severity of the allegations.
Would that be
like
me?
Yes. Would you like to say anything?
So my understanding here, because I picked up this violation once it was already transferred from Waterbury. So I did the second violation on Mr. Foster. And due to the warrant that New Britain was able to execute for an arrest, it was noted that he did have access to the basement through the common area of inside the building. I think the last time they were decisive because he didn't have access from the outside of the basement, but he does have access from the inside of the basement. And due to some of the statements that were said by the other two arrestees, they did say that Mr. Foster did have access and would be at the basement on a frequent basis.
Thank you.
You're welcome.
It is now defense opportunity. If you'd like to respond and testify respect to probable cause and serious allegations.
Yes, thank you. I understand there was a finding on charge 1 in court, and we're not gonna readdress that at this point in time, but I just would note that charges 2 and 3 seem almost identical to the previous charges that were previously litigated at the prior violation hearing. There was a preliminary hearing, and there was a final revocation hearing, and there was no finding made back in October. It seems to me it's res judicata. This is a already decided issue if you got those 2 charges. And I don't think that they should be brought back again a second time. With regard to the first charge, he's going to address this in court. I think a lot of the same issues that were raised at the parole hearing and the evidence that was presented at the parole hearing will be relevant to those charges in court as well. I do dispute that this was a common area in the basement. I think my investigator put on testimony at the hearings as to how you get to the basement and who would access the basement. He was a second floor tenant. This wasn't his apartment. So I think there's a lot of issues there that will also be relevant. And we're hopeful that that case is going to be resolved favorably for him down the road. But given the fact that charges 2 and 3 were previously litigated, I certainly would ask for a no finding on those 2 charges based just on general principles of res judicata. If there is a finding made on charge 1, I would also ask for him to be released, given the fact that this was already addressed and he's been released for a month now. There's been nothing new, and there's something that was already heard by the board. Thank you.
Thank you. I'll be right with you with my findings. So I have listened the testimony and I have reviewed all of the evidence. As I previously stated, charge 1, there is a finding of probable cause as there is a signed warrant from the judge. Regarding charges 2 and 3, I make no findings on these charges. And the same behavior offender was charged with in the previous violation in which no findings were made. So I do find the acts though are serious enough to warrant revocation. I've turned to detain while you wait for revocation hearing. Upon disposition of those charges, we bring you back to determine if there's a violation or not. Do you have any questions, or do you have any questions, sir?
No.
Okay. So
I'm all
you're all
set.
set. Yeah,
Thank
this
you.
concludes your preliminary hearing.
So there's no findings on the weapon or the other
No
charges?
findings on charge 2s or 3, only obedience of law, charge 1.
All right, thank you very much.
Thank you. Thank you, Pio Barrios.
Thank you.
Have a good day.
Yeah.
Good morning, Mr. Oakes.
Morning.
Morning. Before we get started on anything, I know that you had checked, you wanted to waive your preliminary hearing. I just, because you don't have a criminal violation, I have to see you. So I can grant that waiver if you would like to. It's up to you, or we can move forward with the hearing today.
You just move forward with the hearing today.
Okay, PO Deviler, we're there, okay, perfect. All right, so, we'll get started then with your hearing. Good morning, I'm P.O. Meisinger, hearing examiner for the Board of Pardons and Paroles. It's a preliminary hearing starting Oaks Allen, number 3255582. Today is December 9th, 2025. This hearing is being conducted via video at the BOPP Central Office in Carl Robinson Correctional Institution. This is a public hearing, public access. The hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record, sir?
Alan Oaks, ALLEN, OAKES, number 325582.
Thank you. We have parole officer present. Can you please identify yourself?
Megan DeVilder, Hartford Special Management Unit.
Thank you. This is a preliminary hearing, which is the purpose of under Connecticut law. It's to determine if there is probable cause to believe you commit an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has responsibility to show there's probable cause to believe you violated one or more conditions of your parole. If I do not find probable cause, I'll reinstate your parole, which is releasing you, place you back on parole supervision. If I find probable cause and determine the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know a preliminary hearing is an adversarial proceeding. Anything to say this hearing can be used against you. This hearing is being recorded. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state your PO is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to just issue a probable cause and severity of the allegations. After the state is finished, you will have the same opportunity. At the conclusion of the hearing, I'll inform you my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No
Okay.
question.
You have important rights today, which I'm going to review with you. The right to have an attorney present. Do you want to continue without counsel?
I do.
Okay, you have the right to receive the written notice of charges of violation. Did you receive the written notice?
I did.
You have a right to review the evidence. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
I do, yes.
Okay, so we'll now review the charge. State your false or bring against you. Any information underlying each charge. Computer Violet, please read the charges.
Charge number 1 under release direction, GPS. On 8/16/2024, you failed to charge your GPS unit as required, resulting in a battery shutdown beginning at 4:33 p.m. and ending at 8/17/2024 at 5:51 a.m. For approximately 12 hours, your whereabouts in the community were unknown. On 9/7/2024, you failed to charge your GPS unit as required, resulting in an approximate 3-hour shutdown from 12:27 p.m. to 3:34 p.m. Your whereabouts in the community were unknown at this time. On 9/8/2024, you failed to charge your GPS unit as required, resulting in an approximate 2-hour shutdown from 3:51 a.m. to 5:36 a.m. Your whereabouts in the community were unknown at this time. On 7/4/2025, you failed to charge your GPS unit as required, resulting in a shutdown from 3:29 a.m. to 10:05 a.m. Your whereabouts were unknown during this time. On 11/16/2025, you purposely cut the strap to your GPS unit at approximately 7:17 p.m. and removed it from your ankle. You left the GPS unit in the basement of the halfway house. Charge number 2, program participation. You were unsuccessfully discharged from CTPSB sex offender treatment due to a continued display of high-risk behaviors, stalking, harassing, that mirror previous behaviors. Charge number 3, under residence, on 11/16/2025, after removing your GPS unit, you exited the front door of a halfway house with no intention to return to your only parole-approved residence. At no time between 11/16/2025 and your remand date of 11/19/2025 did you return to this residence. Charge number 4, absconder. On 11/16/2025, after cutting your GPS unit strap, you intentionally walked out of your residence at approximately 7:17 p.m. At no point did you attempt to contact your supervising officer as you evaded your parole supervision. Your whereabouts were entirely unknown until you were located at Bradley International Airport by Connecticut State Police Troop W on 11/19/2025. Charge number 5, halfway house placement. On 8/6/2024, you were on a work pass from the halfway house and were due back by 5:22 a.m. You admitted that you deviated from the pass and went to the airport, which is a misuse of the pass system as you are only permitted to go to and from your employer. On 4/1/2025, you were issued a pass to Accurate Staffing from 10 a.m. to 1 p.m. and stated that you were there. A review of your GPS monitoring indicates that you never reported to that destination. This is a misuse of the pass system. On 6/16/2025, halfway house staff witnessed you smoking a marijuana joint on smoke break, which you admitted to. A search of your space yielded you to be in possession of marijuana. These actions violate the halfway house agreement as you are not to consume or possess marijuana at a halfway house. On 7/4/2025, you were directed by your supervising officer that you were not to get in a car with anyone other than an approved driver, as you are aware of in your halfway house agreement. A review of your GPS monitoring indicates that you were in a car on 7/4/2025, 7/6/2025, and 7/7/2025. At no time did you propose anyone to drive you, nor was anyone given permission to be an approved or authorized driver. On 7/8/2025, you admitted that you knowingly violated this rule and you received rides home from work. On 9/7/2025, when you returned to the halfway house from a work pass, you were found to be in possession of marijuana. At no time are you to consume or possess marijuana in a halfway house. On 11/14/2025, you were issued a common pass to attend religious services. At no time did you go to your destination, which you admitted to. This is a misuse of the pass system. Under charge number 6, enhanced internet and device monitoring. On 6/24/2024, you were found to be in possession of an unmonitored cell phone. On 7/11/2024, you reported during group with the Center for the Treatment of Problem Sexual Behavior that you were using the computer at the halfway house, which is unmonitored. On 10/29/2025, you were found to be using an unmonitored computer at the halfway house. You knowingly use this unmonitored device to access prohibited sites and material to evade parole. Charge number 7 under problem sexual behavior treatment. On 7/11/2024, you reported during group with the Center for the Treatment of Problem Sexual Behavior that you had been frequenting a dating website. Per your treatment agreement with the connection, you are not to access any dating sites without prior permission. On 9/12/2024, a review of your IPPC, Enhanced Internet and Device Monitoring, was conducted. Supervising officer reviewed over 374 pages of keystrokes. A significant number of these keystrokes were through the use of various end-to-end encrypted applications, including but not limited to Caption Call, Text Me Up, WhatsApp, Telos, Cloud SIM, Vumber, Incapation, iPlum, OpenPhone, BIP, Ring4, and Duo. In these applications, you are attempting to message, call, and or text random telephone numbers in sequential order. In many of these messages, you are identifying yourself as Brittany, attempting to make contact with a female. You admitted that you were hoping to get an answer and that you can't stop as you are trying to satisfy your sexual needs. Excerpts from the numerous randomly attempted contacts include, "Hey, sorry to wake you. It's Brittany. Let me taste you. I'm so horny. I want to play with you. I'll pay you." You were soliciting sexual acts and offering to pay between $50 upwards to $350. In addition, you inputted the following: young sex, young girls naked, young cunt, little girl panties, 7-year-old girl tits, and little girl ass. You also used a web image downloader to create sexually stimulating pictures of children that you saved to your phone. On 10/29/2025, you reported to have been using an unmonitored computer at the halfway house. You provided your supervising officer with login and your history was reviewed. Per your CTPSB treatment agreement, you are not to be communicating on social media or chat sites. You had created a Reddit profile with the name laddercookie4728. You made at least 3 thread posts on the site to include stating, "Man who loves to spread his asshole. Hello, I'm in love with pegging my hole with toys, fingers, hands, whatever." You also viewed and reposted 2 pornography videos, including "My Boyfriend Had Fun with Molly Little" and play with both tight holes. At no time are you to view sexually stimulating material on any electronic device. In addition, you were searching various platforms for your former supervisor. When questioned about this, you stated you wanted to learn more about her. You are not permitted to access social media platforms per your CTPSB agreement. And lastly, on 11/20/2025, the Center for the Treatment of Problem Sexual Behavior unsuccessfully discharged you from problem sexual behavior treatment based on the continued high-risk behavior that mirror your previous offenses.
Thank you. If you just please read the evidence.
A, remand to actual custody order. B, PCS conditions. C, parole violation notice. D, parole violation report. E, CTPSB sex offender treatment agreement. F, GPS agreements. G, misconducts, incident reports, disciplinary reports with supporting evidence to include GPS attendee monitoring, pictures, etc. H, CTPSB letter documenting unsuccessful discharge. I, police report and corresponding evidence. J, CHR email thread. K, Reddit printouts from 10/29/2025. And L, BOP decision information summary update.
Thank you. And the only thing I added was halfway house agreement that added that to exhibit F with the GPS agreement. Sir, did you receive notice of parole violation report, and those other documents that were just marked? And did you review those?
I did.
Okay. Do you need to continue this hearing to obtain any additional evidence?
No, I do not.
Okay. We have no witnesses today. So at this time, I'm going to swear in Peel DeViler as well as you, so that in the event you would like to speak, you may. Can you please raise your right hand? You solemnly swear, solemnly affirm, as the case may be, the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth, so help you God, upon penalty of perjury?
I do.
Sir, that was for you too.
I'm sorry, I do. Yeah, I do as well.
Okay. So at this time, the state will have an opportunity. If you'd like to make a short statement and testify with respect to probable cause and severity of the allegations, you may at this time.
I don't have a statement at this time.
Okay. So it is now your opportunity to respond for all violation charges against you. I'll remember that you may remain silent if you so choose. Would you like to respond to the charge at this time, sir?
Briefly.
Okay. Go ahead.
You know, I mean, I take full responsibility here. I mean, I intentionally cut off my bracelet. You know, these things are something I've been dealing with my whole entire life. When will I get it? I don't know. I mean, there's no excuse. I'm not here to make excuse. I'm not here to fight. I did what I did. I face full responsibility for actions committed because I knew what I was doing. I knew what would happen when I did. It's just been a stressful time in my life. Things seem to always start off by going good. Then there's something that is in my mind with the anxiety that feels otherwise. And that is something that I must get under control, is to understand why I get anxious and why my depression always takes over, and me misreading into things throughout my life, or the behaviors that I display are from me being anxious for whatever reason. So it's time to stop avoiding and evading that part of my life and get it together. And that's what I plan to do for the next 10 months that I have. I've already made that decision myself.
Okay, well, I appreciate your statements today. So what I am going to do, is there anything from either other side before I announce my findings?
No.
No.
All right, so I'm going to announce my findings in regards to the charges. So regarding charge 1, I do make a finding of probable cause GPS based on evidence and testimony presented in support of the violation, which is exhibits B, F, and G. Regarding charge 2, I make a finding of probable cause program participation based on evidence and testimony presented in support of the violation, which is exhibits B, E, G, and H. Regarding charge condition 3, residents, I make a no finding of probable cause based on the charge not meeting the elements. On charge 4, I do make a finding of probable cause absconder based on evidence and testimony presented, exhibits B and G. Regarding charge 5, I make a finding of probable cause halfway house placement on all everything noted in the violation. This is based on evidence and testimony presented B, F, and G. Regarding charge 6, I make a finding of probable cause on enhanced internet and device monitoring based on evidence and testimony presented, exhibits B, E, and G. Regarding charge 7, I make a finding of probable cause problem sexual behavior treatment based on evidence and testimony presented in support of the violation, exhibits B, E, H, I, and G. I do find the act serious enough to warrant revocation or to detain while you wait for your revocation hearing. At the rev hearing, myself or another hearing examiner will determine if you violated conditions of your parole. If so, the hearing examiner will make recommendations regarding whether your parole should be revoked or whether any sanctions should be imposed. So it's a technical violation. So we have 60 business days from your return to custody to schedule your hearing. So we will schedule that and you'll be notified of that date. Do you have any questions, sir?
I do not.
Okay, so that concludes your preliminary hearing. And we will see you shortly. Okay?
Thank you. Thank you.
Violet, do you plan on participating at the rev hearing too?
Yes, I will be
Okay.
there.
So I will put you down for that as well. All right, so we're all set for today. Have a good day.
Thank you.
Thank
Take
you.
care.
You too.
You too.
Good morning. My name is Parole Officer Mack. Today is Wednesday, December 10th, 2025, and this is a hearing of the Connecticut Board of Pardons and Paroles. Following board members are present this morning and by stating their names on record, certified they have reviewed all statutorily required documents and available pertinent information in preparation of this hearing.
Good morning, Robert Sazowskis.
Deborah Smith Palmieri.
Good morning, Alex Tekhoff.
Thank you, board. Also present is the Office of Victim Services. Please state your name and inmate number for the record.
My name is Reggie Gonzalez, 288-366.
Thank you. This hearing is being conducted in consideration of the parole application for Reggie Gonzalez, number 288366. He is serving a sentence of 10 years jail followed by 5 years special parole for burglary first degree. As of today, records reflect the parole eligibility date of April 17, 2025. There is victim input in this case. There is an offender accountability plan. It has been reviewed and shows the offender has completed voices in Tier 2. Utilizing the statewide collaborative offender risk evaluation system, the offender's overall score falls within the high range for risk of recidivism. Mr. Gonzalez, this is your opportunity to express to the board why you believe you should be granted parole. You may begin.
Well, as I've been here, I started off in a struggle, and I kind of hit rock bottom. While I was doing all my programs, I just started to give up, and then I just stopped everything because of, behavioral management. And I was given a chance to, with a little seed planted, I have to go home, and I was thinking that I'm gonna have to make some changes because living out there is not like living in here. So I took the advice of one of the council members here, just to stop catching tickets and do more programming. And I was able to do the Tier 2 program, and I've been out of any conflicts or trouble for 6 months. And I would just like to say that the problems I've had for contraband were all things that are legal outside of prison, but in prison, it's illegal. Like making tools out of, the nail clippers we get sometimes could be seen as a disciplinary conduct, or, cooking stuff that might be, not good for the population. But I discontinued any of that. I finished Tier 2. I have a job lined up in East Hartford. Allied Roofing. I know the boss. I know the boss's father. His father, Mr. Mayett, his son now is Pat Mayett. And that's my first step as soon as I get out to see what they're doing for the winter. Whether it's now or the end of next year, that's what I plan on doing. And my family, they've always been frowned upon people going to prison. So if I go to prison, I don't have help for my family, and they don't really want to talk about what you're going to do when you get out while you're in prison. So when I get out, I have to show them that the rehabilitation that I was given or something in my head worked. And I'm going to give them a reason to trust me, and I'm going to get my family back, and I'm going to move forward. And I hope to have your help when I move forward, because I need your help. The parole, the, DOC, transitional service. It's been a long 9.5 years, and I got to get my mind out of prison and learn how to be successful in society again. I have to learn about housing, food. I need a mentor, just so I can have some help, and I'm asking for that today. I left some paperwork in front of you if you got any of it. I think I finished Tier 2 in June, and that was just because I had to do something different. I said, let me do Tier 2. And last time I came to the board, I didn't have any of my paperwork. I have restitution payments to the victim services. Maybe during the trial period of this crime, the feelings were kind of tense, but afterwards, after sentencing, after I took this 15 years, I spoke to the victim during in correspondence just to understand that we're both humans. We came to understanding, and I decided to give her help with her mortgage payments because she was having trouble with her family. And I just did that as a courtesy because there was no bad intentions. When this happened as a victim, I didn't pick anybody as a victim. It just so happened that that night, it was her car and her property, and I'm sorry. And if I knew that what I was doing that night, that my brain would have said, "What are you doing?" But that's what happened, and I made sure there was restitution payments for a security system, and also Wheeler Clinic for the Kids found that there was no further need for therapy, and the mortgage payments, as a courtesy, I help with the mortgage payments of $3,000, just because I didn't do any damage. I still wanted to try to help make this better, and I have to help my family now when I get out to understand that I'm better. And I don't even know why this night happened, but I know everything happens for a reason. So I left on your desk something that I tried to do during this 9 years, is find out why this happened. And I put my civil case, it's a civil case toward the medical facility in Hartford, where 3 days before I was released in June of 2016, I was on a medication called prednisone. And in high doses on prednisone, your body develops a need for that steroid. And when I was released without that steroid. And 3 days after I was released, I woke up in the hospital with organ failure. And these are the exact symptoms you find when you take prednisone steroid improperly. So just to find clarification of like who this person was that day, I tried to go forward and find out what did I do wrong. And I think that that's one of the things. I didn't take my medication correctly because I was, I wasn't smart enough, or I didn't know how to do anything but what DOC tells me. So like I said, to be outside of this facility, I need help to understand. And in the suit, it says on page 5 of 8, this is the cause of action. Basically, it says the defendants know suddenly stopping prednisone may have serious consequences. And the defendants knew prednisone is capable of affecting every body system. The defendants knew of the substantial risk that the very fact the risk was obvious. Without medication for use upon discharge, including the high doses for lack of supervision or monitoring, the defendants knew that the tapering was a gross departure of accepted medical standards. The defendants knew failure to provide medication and continuity of care upon plaintiff's discharge is grossly incompetent, inadequate, or excessive as to shock the conscience or to be intolerable to fundamental fairness. It constitutes deliberate indifference. Defendants disregarded the above.
Mr. Gonzalez, we've read the documents that you submitted about this matter. So we've received all of that. Is there anything else besides that issue? I heard you say a couple of other things about programming and how you've changed your mindset, but is there anything else that you'd like to say on why you believe you deserve parole before we start with the questions?
Well, deserve, I don't know if deserve is a question. I need it. That's what I know.
Okay.
If I deserve it, that'll be up to you.
Okay.
I appreciate your time.
I'm glad to see that you decided to make changes and that you recognize that it's you need to be different when you go out, because one way or another you're getting out soon. You know what I mean? You're going to be out there soon. You don't want to come back, right? I mean, you don't want to repeat what just happened. You were not out long before this last one happened.
No.
Okay, so what's going to happen today is we're going to take turns asking questions. And then when we're done, we're going to deliberate on the record. You'll be able to listen to us, and then we'll give you our decision today, okay?
Okay.
Okay, my colleague, panel member Smith Palmieri, she's going to start with the questions this morning.
Thank you. Thank you, Mr. Gonzalez, for giving us some information about how you're seeing things today. We did, as the chair said, review everything in your file very thoroughly. Yours is a very serious case, so, we try to look at as much information as possible. So let me see if I understand this correctly. You did not know the victim prior to committing this burglary?
No.
Okay, so it
No.
was a random person?
Yeah.
Do you know how you ended up in that area?
I was intoxicated and I hadn't slept, and I was
Okay.
I was going through this organ failure, so I couldn't eat. I was on dialysis, and you know, addiction took over. And I can't say that I was confident during that night. I remember finding something to eat and something to drink, and then I woke up in the car.
Okay. Now, you were in the community, you had been only back out in the community for what, about 3 months, did I read?
Yes. Yeah, 3 months
And during-
exactly.
Okay, okay. And during that time, you had discharged from your sentence, from your former sentence. And,
Yes.
you know, what were you doing to try and structure your life at the time?
Well, I remember the first day I tried to get custody of my kids because there was an issue with my wife and the kids. And this was during the time that the prednisone was in my system. So I got out on a Monday, and then on Wednesday, I woke up in the hospital and they said I had organ failure, and I didn't know why. So from that time on, I was on dialysis for 2 weeks in the hospital in ER. And then after that, I did outside inpatient outside services for dialysis 3 times a week. So it was terrible on my mind and body.
Yeah.
That's what I have record
those
of.
medical, I agree. Those medical conditions do sound like they would take a terrible toll on your body.
Yes.
You know, I don't have to say it again. You know, you understand how serious the charge is. And you have 5 years of special parole to follow this. And when I look at your history of community supervision and your criminal history, you know, there's a lot of burglaries. So this seems to be kind of what you may, even when you say you were not in your right mind, something that you kind of fall back into becomes what you do when you get desperate. Why do you think it'll be different this time, being on supervision in the community, especially on special parole? Because you know that's a much more intensive level of supervision.
Thank you. That's a good question. But I've done a lot of thinking about this question. I've asked myself this question in so many different ways. I've looked at all the paperwork too, and I've seen the police reports. I've seen the charges, and I've also seen that every time I'm waking up in somebody's property in an intoxicated manner and don't remember what happened. So if I could stay sober, then none of this would ever happen. So that right there is the key for me. Be sober, and then I can make conscious decisions. Instead of waking up on people's property, like what happened? That's not fair to me or the public.
That is right. It is not fair for people to not feel safe in their homes, not to feel safe in the community. So you talk about struggles with alcohol, and I also have an indication of opiates and cocaine. Is that correct? Okay. So are there any periods of time that you've been in the community that you've been sober?
There are times, when I'm working, I'm probably on supervision if I am. When I'm being observed by the state, I'm forced to stay sober, so I know that that's when I do. And because of the organ failure, I dove into drugs. I said, there's no other way to live but drugs. I can't eat anymore. I can't feel anymore. I can't think anymore. And I don't know why this is happening. I said, I have drugs and that's all I have. I don't think like that no more.
All right, let me ask you a question. So I'm gonna ask you a question, Mel. So that's what you say is what caused your relapse, was this your medical conditions that you felt you had really no recourse because of how serious they were. What about before though? What do you look back on and see as reasons for relapse on other occasions?
I guess just normal life could be a relapse, but I know what keeps me sober is my family, work, friends, just relationships, having responsibility, bringing paperwork to the parole office, like, yeah, I'm really doing the right thing. That stuff makes me sober. Just being happy about living successfully. That keeps me sober.
All right.
Church services,
Mm-hmm.
school.
Okay, so your family, church, when you're doing the right things, that's what makes you feel, that's what helps you remain sober, right? Yeah. And then there's times where you struggle. So, you have 5 years of special parole, and maybe based on what I'm hearing from you, you think that is an opportunity for you to kind of turn things around. Do the right things, live a sober life, work. Well, what happens when you're not on community supervision? What do you think will be those motivating factors?
Well, sobriety, number one, family's right there, number one, because when I'm not doing the right thing, right now, I have nobody to call home to, But when I get out and I'm doing the right thing, I have a huge family and a lot of love. So every day there's a benefit to staying sober and out of criminal activity. That's the benefit. I have my life. Without drugs and jail, I have a life. That's what's going to keep me sober.
All right. Well, those do sound like very positive things that you have in your life. And I think that's true for a lot of people. When they're not doing the right things, it's hard for families to still be supportive, right? Yes. Sometimes you have to step back to let people find their own way. So I heard you talk a lot about making amends with the victim, restitution, helping out with different financial needs you felt the victim needed. Where did you get all the money to pay the restitution? I mean, you've been incarcerated for a while now.
My mother loves me to death. Margaret Gonzalez. My grandma passed away during this incarceration. And shortly after that, my brother died during the COVID when it first hit. That's when I dove into this. I don't know what I'm doing with my life. And I started catching tickets. That's about that time, around 2021, 22. And those things have been a factor in me moving forward. And my grandmother had an estate next to ESPN, and all the kids, they split up the estate and they sold it. So my mother was able to, put up restitution at the time of the sentencing. There was money to allocate, and she said, you know what? She helped me with that as a favor to me because I felt so bad for the victims. My mother understands it. Well, any mother knows they're gonna love their child, but my mom knows that I can do good when I'm doing good, and she knows how bad I felt, so she did that for me. And I guess it was $4,200.
Okay.
Or 5,000, yeah.
5,000. I thought I read someplace.
Yeah, and now my mother has it in her head. She wants me to come home, and with the rest of the money, she's not touching it, but she wants to buy a house. And she knows how much I love building maintenance, carpentry. I've been doing it forever since I was a youth. I went to a youth program as a juvenile and I learned how to build houses. And from then on, I loved working outside, building houses, roofing, siding, everything. And my mother knows how good I'm at it. And she wants me to buy a fixer-upper house and fix it up for her.
Okay, well, I think that sounds like a way to keep yourself busy, a way to help you structure your life outside employment. So I hope that works out for you, because it does sound like it could be very beneficial for you. You brought up all the tickets that you have. I have a total of 29 tickets through this term of incarceration. The last ticket was in March 2025. So right, maybe 8 months or so, give or take. So you kind of turn things around, right? In that time, since then, you have finished the Tier 2 program.
Yes.
Have you done Tier 2 before?
I did Tier 4 in a prior incarceration, but right now they don't offer it here. If there was a next step for me, that's what it would be. If say if I'm not released, that's where I will go.
Okay, but you feel like you've got a little something out of the Tier 2 program?
Yeah, and I've been in Tier 4 before.
Okay. Yeah, Tier 4, but you just finished Tier 2. So
Yes.
I heard you when you talked about the disciplinary report, that a counselor gave you some advice.
Yes.
Right. Why do you think you were able to listen to that advice and make some change because of it?
Why just like I told you already, my family, I'm ostracized right now. Until I prove different, I have no family. So for somebody to give me any support is rare. And sometimes that's how I feel. Being in this environment, I become a product of it and learn how to live here. Technically, I have to. You can still make good decisions and bad decisions. But like I said, none of these things are against the law. And they were just to make money. Like the contraband tickets for sharpening pieces of metal to make screwdrivers. That's a ticket. And there's no way around it.
Yeah.
And,
Mr. Gonzalez, I'm going to stop you because I can appreciate how you maybe rationalize the behavior.
Yes.
But I would encourage you to think about things more in terms of following rules, right? So there's rules at the facility because there's so many people, so many different people with different mindsets, different backgrounds. So the rules are intended to keep order, to help everybody stay safe. So just like in the community, right? There's laws, there's rules, there's even unspoken rules in society that help people live together in a nice, orderly community way, in a positive way. So, and you've been incarcerated now for a while, so you know that those rules are in place for a reason. And I hear what you're saying, that, sounds like, they were intended for whatever, like making some money for a commissary or fixing things perhaps, but they create a problem at the facility. And really, I think you know that.
I know.
And you know that when you're committing those different types of offenses.
Yes.
So going forward, it's important. I think it's important for you to really think about, whether it's right or wrong. And oftentimes there's no gray.
Thank you. And I would like to add, if you don't mind, the counselor said to me, they said, if you want parole or you want to get released, you can't catch any more tickets.
Mm-hmm.
So I just did the opposite of that. I stopped catching tickets, and then I was on the list for Tier 2. And now I'm on the list for the religious programs and addiction service. And that's why I'm here today with no tickets and some new certificates. To answer your question.
Yeah, well, you want to know, I am really happy for you that you've been able to make that change, because you do need to figure out how to live differently when you're in the community, right? How to live as a sober person, how to reunite with your family. All your family sounds very important to you, and without reuniting with them or some level of reunification, you know, I think you're going to be, it sounds to me like you're going to be unhappy. So all this good work that you do, not having to look over your shoulder when you're doing things, it's, you know, it's all good change. It's all good thinking change, as we like to say.
That's a benefit too. Don't have to look over your shoulder.
Absolutely. Absolutely. All right, Mr. Gonzalez, I have for a release plan that you want to go to the halfway house, and you mentioned an opportunity for employment. So hopefully all that works out for you. I'm all done with my questions this morning, so I'll give it back to Mr. Chair.
Thank you very much, Pamela Smith Palmieri. Okay, Mr. Gonzalez, so my colleague talked about your disciplinary reports, and I know that you did have one in March, and that was at the time that this our information was sent to us, but I did notice that you received an additional one after that on June 20th.
Yes.
What happened on June 20th? What happened on June 20th? Yes.
Yeah, I believe it was a contraband ticket for a toothbrush. It was a toothbrush with an attachment.
I see a different one with a toothbrush. That was in March 17, toothbrush. Was this one on June alcohol related?
Yeah. I had fruit juice, and I felt like I was targeted because I had a history of contraband tickets, and I was just like, you know, I'm signing the ticket. I got to get out of SAG, and I'm going to make some changes. So,
So that ticket on June 20th was, they believed that you had Pruno on June 20th.
Yes.
And you got out of tier 2 on June 17th, 3 days before that. So after tier 2, you received the Pruno ticket.
Yeah, Marceli's birthday was coming up, and basically that was, you know, I have to live with somebody in prison, and I can't decide what a person do, you know, but we had an agreement, and I guess he had his case open in court, and I took the blame.
Okay. Well, I appreciate your explanation, and just, I appreciate your explanation and clearing that up, what happened. The only other thing I wanted to ask you about, one other thing. Oh, is the victim, I don't want to use the victim's name in this conversation, so please don't mention it, but the female victim, you've stayed in contact with her?
Yeah, I actually spoke with the parole liaison, I guess, about a letter that I wrote. She wrote me a letter after I found out she was struggling. And the letter, I really wanted you to have the letter today to read it and observe it. Just by looking at it, you could state that nobody is feeling threatened by this letter. But I sent it to my attorney, hoping to go back to court and reevaluate things. But my attorney says he can't find it. So.
Okay. But the letter talks about how you're remorseful, and that's what you're saying, and how you feel about what happened? Or
the letter that I wrote her. No, she wrote me a letter. Okay. And she wrote me a letter on how she feels and how the kids are doing and what was going on with her living status.
Have you ever talked to her on the have you ever talked to her on the telephone?
I felt like that would be illegal, so I would never try that. Because I noticed. Yeah.
I just wanted to understand what the situation was with you and the victim, and what, you know, so I got it. She wrote you a letter and you responded to her about how you feel remorseful. Okay.
Yeah. And I sent the check. Okay. This was through my attorney.
I did see, we did get the records about the payments, like my colleague said. So we did see that. And I do appreciate that, because sometimes we see people that are not able to find a way to take care of those things. So I'm glad that you have the family support and you were followed through with that with your attorney to take care of that. It's important for the victim. So I appreciate your efforts since June until now. I hear that you want to be a different person. I really do in your voice. I believe you're sincere that, you know, after this conversation, you had with your counselor, it sounds like it was impactful on you in that, you know, you understand that this can't continue. You know, I understand you say that these wouldn't be crimes out in the community, but you have to, you know, there are going to be lots of rules on special parole that are not crimes. Do you understand that?
Yes, sir.
Yeah, so special parole is going to have a whole list of rules. They're going to say you can't do this, you can't do that. It's going to be really restrictive, especially in the beginning, right? So, so it's just going to be like when you're in prison. Some of the rules that they say, like, maybe you can't have contact with this person, you can't go to this location. They're not crimes, you know, but there's still rules that you're going to have to obey by. If you don't obey those rules on special parole, you're going to find yourself back in trouble again. Okay. Okay. All right. I'm going to see if my colleague, panel member Sarkoff, has any additional questions.
I do not. Thank you.
Okay. All righty, sir. So originally we thought that we were going to have a statement from the victim today. I've been told that that's not going to be the case. So we're going to deliberate about your case now. You can listen. Please don't interrupt during this time. And when we're done, we'll give you an answer.
Yes, sir.
Okay. Thank you. Panel member Smith and Mulberry.
So I think we've all appreciate that Mr. Gonzalez is making efforts to think differently, respond to things in a different way. It is, you know, a burglary in the first degree. I listened to his explanation of it all, and I hear what he's saying. However, it doesn't diminish the fact that it's burglary in the first degree, breaking into someone's home, and the fear that that causes to a person in that situation. Mr. Gonzalez has a criminal history that is similar to what he's currently incarcerated for: burglaries, first, burglary thirds, burglary seconds. He readily admits he's got a problem with drugs and alcohol. He has done the Tier 2 program. I say I did not have that most recent disciplinary report, so I appreciate my colleague bringing that out. And it's unfortunate Mr. Gonzalez did not mention that new ticket when I specifically mentioned the March tickets, which I think is also concerning in terms of taking responsibility and owning up to behaviors, because he can still move forward from that. Still, you know, it's still 6 months ago. That was it. So there has been even change since then. But for today, you know, based on the number of different tickets all through this term of investigation, the charge itself, I think that Mr. Gonzalez is not suitable for discretionary parole today for those reasons, and he does not have all that long to end his sentence. And I do think that Mr. Gonzalez could benefit much more prior to his release from taking some additional programs, maybe some additional addiction services. We didn't talk about it, but it looks like he's had some mental health services while he's been there. So I think that that is really important for him to continue with, and he can certainly benefit. And it sounds as though as long as he stays on the right path, he'll have support in the community. But for today, I don't find Mr. Gonzalez suitable for discretionary parole.
Thank you. Yeah, so I agree, you know, and I just wanted to point out some of the good things like you did that he's doing, because I don't want him to be discouraged by this, because he's coming out. He's going to be out soon. You know, in the documents I read, he said he was interested in NAAA in the community. He talked about church today. He has some, sounds like a solid lead on employment. So there are some good things and some thinking that's going on and planning on what's going to happen in the community. And I'm encouraged that he's gone 6 months after having so much trouble with disciplinary reports, that he's been able to go 6 months. That's encouraging. It sounds like that this conversation he had with this counselor has made a difference in the way he thinks. And I hope that he can just continue that straight through into his special parole. But for today, I agree with you. Panel member Sarkar.
I agree with both of you. But hopefully he's on the right track. No tickets since June. You can hopefully carry that to special parole supervision. But the facts, this offense are just too concerning. Tickets to all his incarceration. Cannot find him suitable.
Okay. Let's talk about the reasons. I definitely have criminal history and poor institutional adjustment. Did you want to add a third one, either nature and circumstances or inadequate evidence of offender change?
No.
So you're okay with criminal history and poor institutional adjustment?
Yes.
Member Sarkoff, is that okay? Okay. We have to set the special parole conditions also. Member Smith Palmieri?
I had no alcohol, halfway house placement, mental health evaluation and treatment as deemed necessary, and no contact with the two victims, JM and KM.
Okay, that's what I have. Anything else? Okay, I think we're ready. In regards to Reggie Gonzalez, inmate number 288366, I'm gonna make a motion to deny discretionary parole today based on his criminal history and his poor institutional adjustment. And a further move to set his special parole conditions as no alcohol consumption, halfway house placement, mental health evaluation and treatment as deemed necessary, no contact with the victims, KM and JM. Do I have a second?
Second.
All in favor? Aye. Okay, Mr. Gonzalez, I hope you listened to all of that, because all three of us have heard some really good things from you. And the last thing we want you to do is be discouraged and go back to your previous troubles, you know? We don't want you giving up. You're doing really well. You've put together 6 months in a row, and for you, based on your record in prison in the past, that's a big deal to have 6 months without any tickets. We understand that and recognize that. Your plan for release, it sounds pretty good. You know, you talked about church, AA, NA, support from your mother. You know, you have some potential, it sounds like a strong potential for employment. So need to keep all those things in mind and keep going in a positive direction. There may be opportunities for you to go to a halfway house through DOC. If you can stay free of disciplinary reports, I don't know, that'll be up to them. But I would just encourage you to keep doing what you're doing. You're on the right track. And we hear a lot of positive things from you. Today, we could not approve your discretionary parole though.
I understand.
Okay. All right. Good luck to you, sir.
All right, thank you. Have a nice day.
You're welcome.
Everybody, ladies and gentlemen.
This concludes the parole hearing for Reggie Gonzalez, number 288366.
You don't make parole on today?
If you ready? Is it on? Ex Santos?
Yep. You can come on and have a seat. All right, we'll be with you in a second, okay?
Mm-hmm.
Good morning. My name is Parole Officer Mack. Today is Wednesday, December 10th, 2025, and this is a hearing of the Connecticut Board of Pardons and Parole. Following board members are present this morning and by stating their names on the record certify they have reviewed all statutorily required documents and available pertinent information in preparing of this hearing.
Good morning, Robert Sazowskis.
Deborah Smith Palmieri.
Good morning, Alex Sarkoff.
Thank you, board. Sir, please state your name and inmate number for the record.
My name is Gilberto Santos, 205707.
Thank you. This hearing is being conducted in consideration of the parole application for Gilberto Santos, number 205707. He's serving a sentence of
7 years and 5 years probation.
He is serving a sentence of 20 years jail suspended after 7 years, followed by 5 years probation for robbery first and attempt to commit robbery first. As of today, records reflect the parole eligibility date of May 27, 2026. There is no victim input in this case. There is an offender accountability plan. It has been reviewed and shows the offender has completed voices and is currently participating in New Thoughts. Utilizing the statewide collaborative offender risk evaluation system, the offender's overall score falls within the moderate range of risk for recidivism. Mr. Santos, this is your opportunity to express to the board why you believe you should be granted parole. You may begin.
I would like to be granted parole because I know I can go out there and complete parole, probation programs. I do anger management. I'm there too, and I got a good head on my shoulders. And plus, I got my wife out there to support me and my 3 kids. My oldest 15-year-old got autism. He needs me out there, and I receive SSI because I'm disabled, and I know I can go out there and complete parole, probation, whatever y'all give me. I did it before. I know I can do it again and I can get myself together because now I'm back on my medication again and I feel better.
Okay. Hey, Mr. Santos, thank you very much for your opening statement. What's going to happen today is that we're going to take turns asking you questions. And then when we're done, we'll deliberate when we're done with that. And then we'll talk about your case and give you an answer today. Okay?
Yes, sir.
Okay. So I'm going to start with the questions this morning. We've read through all of your files. It sounds like it's related to 2 incidents. One of them was at an ATM. Do you remember that incident?
Yep.
Okay. Why did you rob the victim at the ATM?
Because he owed me some money. And he didn't want to pay me. I let him borrow some money when it was the COVID era for his electricity. He said he was going to pay me. He never paid me back. So I seen him and I was trying to get my money back. That's why.
So you knew him from before?
Yeah, I knew him. Yeah, he's coming to my house all the time, bro.
Okay. And when you confronted
him and everything, I
I
used to feed him, clothe him, cut his hair, everything, give him rides everywhere, and he tried to pay me for a few bucks. So I had to get my money.
Okay. So you confronted him while he was at the ATM, and what did he say? Did he say that he was going to give you the money back? Like, how did that interaction go?
Yes.
Okay. Did you have a weapon with you?
Huh?
Go ahead.
I
want to hear what you have to. A weapon. Did you have a weapon with you?
I always keep. I had a little knife on me. That's about it.
Okay. Did he give you the money?
Yep.
How did he give it to you? Did he hand it to you? What happened?
He just threw it down and walked away.
The report reads differently, like that maybe he didn't know who you were and you just robbed him coming out of the ATM, you know?
Nah, bro, that's all BS, man. Like, it's like this, man. I knew the dude, you and me, bro. We both went there together in my car, and he went in there, and then he tried to come out like he ain't had my money, and then, you know what I'm saying, that's how I got my money from him. That's what happened, but
and then he
regardless of whatever.
Police. Yeah.
Huh? He called, I don't know what he did, but I know I left, and that's it, you know what I'm saying, but
okay.
It ain't like I, you know what I mean, I already, huh?
Let's move on to the other one that was at the gas station. Do you remember the incident at the gas station?
Bro, that wasn't even a Western. That was a fight. Me and him fought, and we fought. He took one of my items out of my hand and ran off, and I chased him, and we fought. Him and his brother jumped me, but that ain't on record. You know what I'm saying? For them, they jumped me over there, bro. That's why I had to defend myself.
Okay.
You know?
Did you have a
either way it's like this. It's like this. Listen, sir. Excuse me. Either way it's like this, right? I know I ain't gonna win that. That's why I copped out to it. I ain't cop out because I was guilty. I copped out because I knew if I would have went to trial, I would have lost. That's why.
Yeah.
Nowadays, when they give you time, you don't take it, they got burn you, man. They got to give you more extra time, whatever, and that's why I copped out to that because I was trying to face them 20 years.
I've heard other people say things like that, so I understand where you're coming from about why you pled guilty. I understand that. Did you have did you have a BB gun with you on that incident?
Yes, sir.
Okay.
I wasn't right. I was on my medication. I was on drugs, and that's why everything happened. And you know, I just want to get back to my life, get back on my meds, and be with my wife and my kids again. That's all, bro.
Okay. How do you think? Go ahead.
Huh?
Go ahead. I want to hear what you have to say. It's important.
It's like this. I'm a level 3. I was a level 2 before that. I told an officer, I said, listen, I need to go get my chest checked out. I'm having chest pain. He slammed me on the ground. That's why I got all these tickets. And it's like, and when I was at McDougal, bro, I was around number 40, people that got 40, 80, 70 years. My best friend got killed. He went to another block and his son, he killed him. So you got me around all these pedophiles and people that got 60 and 70 years. I ain't a murderer. I don't understand this. I'm a level 3 right now. What am I doing here? My sonny got mad time. You got people here walking around with 80, 90 years. They don't care about life. So now you got me in here and it's jeopardizing my life. And it's like, you know, people don't care. So now I got to be on the same time as them. I got to be able to defend myself. I got to stand up to somebody that got 40 years. I'm just saying, though, you know, I don't belong here. Why I got me here? You know,
let me explain to you that I understand your frustration, and I hear in your voice that
my mother dying, my nephew just got killed, my niece just died, my sister just died. Before that, my dad died, HIV. I see my aunt get chopped up with a machete. I was on my medication. That's why I wasn't right. So
Yeah.
if y'all want to give it to me, I'll give it to you. If y'all don't, it's all good. Like, I'm not going to sit up here and lie about nothing. If y'all want to give it to me, I'll take it. If not, it's all good. I can go on halfway house, whatever, you know what I mean? The 15, I put it on my halfway house. And I'm not going to sit up here and make up no lies or nothing. You know what I mean? It is what it is.
Yeah, that's fine. We understand that.
I'm just trying to go home.
Our job is to ask you questions and then determine if you're suitable for discretionary parole today. So I
ain't gonna sit up here and make no lies up. If y'all want to give it to me, I'll give it to me. If not, y'all don't have to. I'm gonna go home with y'all. I got 16 months. I'm just trying to get out there to my mother. My mother got, you know what I'm saying, dementia. She's dying right now. She's in hospice, and my kids need me. You know, I need to get out there for that. If I can't get out there, I gotta do my time. That's it, bro. I'm not gonna sit up here and sugarcoat nothing. You know, I'm being real with you.
I want to hear the truth, and I appreciate your honesty.
I'm telling you the truth.
Is it okay?
When
if
I'm
we
not on
ask you
medication, I'm not good. When I'm not on medication, I'm not good. When I'm on medication, I'm better. I can control stuff, my actions and stuff. That's what it is. You know, I got my kids out here, and I miss my wife and kids, and that's the bottom line. You know, my little nephew just got shot in the head at Holyoke. He just got killed. My niece just died of a fentanyl overdose in Florida. You know what I'm saying? I'm going through a lot, man. I'm dealing with a lot. That's what's wrong with me.
Okay, so can I ask you a couple more questions, Mr. Santos?
Go ahead.
Okay. In November, you were found under the influence of K2. That's what the reports indicate. Do you want to explain what happened?
Oh, listen, it's like that. I wasn't on no K2. I wasn't on no K2. They assumed that they didn't even take a urine on me. How you gonna say I'm on K2 and they can't even take a urine? I told them I'm giving y'all urine, whatever. They just assumed it. I was on medication. I'm on medication I was taking, and it gave me a bad side effect. And I told them so. You know.
Okay.
One thing about this, I'm gonna take it like this, right? This K2 situation shit is crazy because they don't even give you a urine. They don't test you or nothing. They just assume by your appearance, and that's bullshit. You know what I'm saying? Because how you gonna give somebody a intoxication ticket and you can't even take a urine on him or blood? You can't determine that he high. You understand what I'm saying? That's bullshit, bro. I did my tier 2. I've been straight, bro. I've been chilling, bro. I don't know, man. They just, anything they give you here, if you don't cop out, it's extra. Like, the CO will tell you, listen, man, if you don't cop out to this ticket, we'll give you 90 days of SAG. Or we'll give you 90 days of loss of compensation, 90 days of this, 90 days. Come on, man. You got to cop out. That's how it is here. If you don't cop out, you're done.
Okay.
They just give you whatever they want to give you.
Can you tell me about your plan on how you're going to stay sober? You said that drugs have been a problem for you and it's led to some of your crimes. Can you tell us what your plan is to stay sober when you get out?
My plan is to stay sober is to I'm Muslim, so I go to mosque and I go to AA and you know what I'm saying, I read my Quran a lot and I pray a lot. I pray 5 times a day. I just want to spend time with my mother before she died. You know what I'm saying? That's all I want to do, man. And I'm gonna stay clean because you know what I'm saying, I don't want to come back to jail. I'm tired of this life. I want to do my programs and that's it. I want to actually, you know what? I'll be real with you. If you want, you don't gotta give me parole. Put me in a halfway house. That way they can monitor me. I don't care. I want to get back on my mental health shit, and that's what I want, basically. I don't care about parole. Put me in a halfway house. We good. A parole house. I'll take that all day. I don't care. Man, listen, man, I'm trying to get out there and get my life together. Not, you know what I'm saying? I'm not even trying to, you know what I'm saying, just go out there and do no dumb shit. I'm trying to get my shit together, bro. Last time I was on probation, I completed all my probation and everything. I haven't had a problem when I was out there. I completed that in Middletown, and they let me go in 3 years on 5 years probation. That should say something. And I did anger management. I did all my programs, good time. I did everything I had to do. So, like, I'm not gonna do it. You know what I mean? I'm gonna stay drug free. I already know that. I don't got no problem with drugs like that.
Okay, good. All right, those are all the questions I have, Mr. Santos. I'm going to see if my colleagues have questions for you, and then we'll go from there, okay?
Yeah, I don't mind taking drug tests every week. I don't care about that.
Okay.
I'm not stay clean.
Any questions?
Sure, I don't think I do.
Okay. Panel member Smith, Palmieri.
No, I'm all set. Thank you.
Okay. Okay, Mr. Santos, so we're done with the questions. I appreciate you explaining everything and answering my questions. We're going to discuss your case. You can listen. Please don't interrupt during this time. And when we're done, we'll give you our answer, okay?
Yep.
Okay, thank you, sir. Okay, so Mr. Santos is here for robbery first and attempted at robbery first. He explained the circumstances from his point of view, which were different than what we read in the police reports. In my records, he's rated at a moderate risk to recidivate. And he has a record that includes robbery, burglary, larceny, failure to appear, violation of probations in the past. He's drug and alcohol score of a 5, and he's had 26 disciplinary reports while incarcerated, some of them related to substance. So today he said, in addition to giving his version of what occurred on those crimes, he talked about the difficulty and the environment that he's in to remain disciplinary report free. He said that although they said that he was using K2, he was not, and that was a problem with his medical situation. He said while he's in the community, he plans to stay sober and he wants to go to AA, and he talked about praying and spending time with his family. He said he wants to stay clean in the community because he doesn't want to come back to jail. So I did hear some good things today from him about him wanting to stay sober when he gets out so that he understands that that's part of what has led to his crimes, being involved in illegal narcotics and his reaction to that. But for me today, based on the disciplinary reports and his description of what occurred with these robberies, I cannot support his discretionary parole. And also his criminal history is concerning for me. So, Panel Member Sarkov?
I agree with your assessment, Mr. Chair. So I'm in the same place.
Okay. Panel Member Smith Palmieri?
I agree as well, for all the same reasons.
Okay. So I have criminal history, inadequate evidence of offender change, and poor institutional adjustment. Everybody okay with that? It looks like he has probation, so we don't have to set the conditions here for parole. Okay. In regards to Gilberto Santos, inmate number 205707, I'm going to make a motion to deny discretionary parole today based on inadequate evidence of offender change, his criminal history, and his poor institutional adjustment. Do I have a second?
Second.
All in favor? Aye. Okay, Mr. Santos, we were not able to grant you discretionary parole today. Okay? Good luck to you, sir.
Don't ever call me back to this shit.
This concludes the hearing for Gilberto Santos, number 205707.
Excuse me, I'm good to.
Mr. Ortega?
Asked it another time.
Mr. Ortega?
Yeah.
All right, just have a seat. We'll be with you in a minute, okay?
I gotta stay inside.
Good morning. My name is Parole Officer Mack. Today is Wednesday, December 10th, 2025. This is a hearing with the Connecticut Board of Pardons and Parole. Following board members are present this morning and by stating their names on the record, certify they have reviewed all statutorily required documents and available pertinent information in preparation of this hearing.
Good morning, Robert Sazowskis.
Deborah Smith Palmieri.
Morning, Alex Sarkov.
Thank you, board. Sir, please state your name and number for the record.
Lenny Ortega, 438197.
Can you say your number again?
438197.
Okay, thank you. This hearing is being conducted in consideration of the parole application for Lenny Ortega, number 438197. He is serving a sentence of 20 years, suspended after 5 years, followed by 5 years probation for 2 counts of burglary first degree with a deadly weapon and carrying pistol without permit. As of today, records reflect the parole eligibility date of March 14, 2026. There is no victim input in this case. There is an offender accountability plan. It has been reviewed and shows the offender has completed voices, anger management, tier 1 and tier 2. Utilizing the statewide collaborative offender risk evaluation system, the offender's overall score falls within the moderate range of risk for recidivism. Mr. Gonzalez, this is your opportunity to express to the board why you believe you should be granted parole. You may begin.
Mr. Ortega, not Gonzalez.
Yeah, sorry, Mr. Gonzalez. Or Mr. Ortega, this is your opportunity to express to the board why you believe you should be granted a parole.
I completed all my programs. I've been going to school. That's really it.
Okay, thank you very much, Mr. Ortega. What's going to happen today is that we're going to take turns asking you questions. And then when we're done, we're going to talk about your case and then we'll give you an answer, okay?
Yeah.
Okay, my colleague, panel member Sarkoff, he's going to start with the questions this morning.
Good morning, Mr. Ortega.
Good morning.
So I understand you were very, very young when you committed your offenses. Why do you think you made those choices at the time?
I was young and dumb, following the wrong crowd.
All right, one thing that really stands out about your time incarcerated is the number of tickets, right? I have 41 tickets, maybe there may have been more. You received some last month, you received some in October. How do you explain all that?
Yeah, I was just being dumb.
I mean, this is happening now, right? You got your last ticket just in November.
Yeah.
Have you thought about how your tickets might affect your parole suitability?
That's
How do you think your tickets affect your parole suitability?
It just looked like I'm not changing. I'm doing the same thing.
Right. Because we're not there to see you every day. I know you're probably doing great things, right? You're in school, you're taking programs.
Yeah.
We're looking at your record, and that's something that really stands out, right?
Yeah.
What about this assault on the DOC employee in July?
But that's really not even an assault. Like, when I was getting controlled strip search, one of the SEALs got hurt, and they gave me assault on DOC for that.
Okay, you do have other assaults and fights on your record, right? Tickets for fighting, quite a number of them.
Yeah.
Right, you did complete some programs. Is there a program that stands out to you that was helpful?
Conflict resolution.
And what did you take from that?
It just, I understand every conflict don't gotta get solved with violence. That's what I got from it.
All right, then you mentioned you're in school now?
Yeah.
Are you trying to get your GED?
Yes.
Okay, and how far are you in that process?
I just restarted my GED because when I left NY, I had 21 credits. I needed 4 credits to graduate, but I got kicked out of that facility. So I can't earn my credits no more. Now I gotta do the GED program.
Okay. That's a big deal. If you're able to get your GED, that's going to open up a lot of doors, right?
Yeah.
And I saw somewhere that you were attending church services.
Yes.
All right. Okay. You were in the true unit before?
Yes, I was in the True program. Yes.
Talk to us about your experience there.
Before I went up there, I was ticket free for like a year. I had went up there. I was taking multiple programs while I was there. Like, it really helped me change my mind and stuff. And then one day I just got mad and got into a fight with somebody. And I just threw everything I was doing out the window.
How do you think your offenses affected the victims?
Huh?
How do you think your offenses impacted the victims?
They probably traumatized from what I did.
Anything else?
Nah.
All right. And what are your plans when you're released?
Get a job. If I haven't finished my school, go back to school, get my GED. That's really it. Just stay focused on myself.
What do you think you've learned from this time of incarceration?
I learned that robbing people don't get you nowhere.
Yeah. Is there anything else you want to tell us that maybe I haven't asked you yet? Anything that you want us to know about you?
Nah.
Okay. All right. Thank you for answering my questions.
Member Smith Palmieri.
Thank you. So, Mr. Ortega, you mentioned to my colleague, and we read that you were in the True program. How long were you in the True program?
Like 6, 7 months.
Okay. And did I read that you still have interactions with your sponsor from that program?
Yes.
Okay. Is your sponsor in the community or still in the facility?
Facility.
Okay. How do you communicate?
I be seeing him in school and stuff because he in college, and he be having me call down to the True program still.
Okay. All right. Do you find that's useful, helpful for you? Do you like it?
Yeah. Helping me get back on track.
How do you see yourself getting back on track? What do you need to do to get back on track?
Just worry about myself and stop worrying about other people and what other people think.
Are you finding that hard to do?
Little bit, yeah.
Okay. All right. What are you, 19?
Yeah.
Okay. All right. What do you know about being 19 years old? What do they tell you that you need to be thinking about, trying to control?
My anger, just my anger and stuff, and like hold myself back from stuff.
Yeah. You know, we often see individuals, especially when we meet with people who are your age and who are involved with the True program or maybe not. One of the things we like to talk about is, right, controlling your anger, impulsivity, acting without thinking. Do you find does your sponsor talk to you at all about that?
Yes.
Okay. And what kind of things do you do to try and help yourself with that? Do you have any strategies?
Listen to music, walk away, then come back to the problem later and talk to him about it later. But sometimes I just like react in the moment without thinking.
Okay. All right. I mean, we can actually, we can see that with the troubles that you're having at the facility. So
yes.
Do you think that you're starting to work on that, starting to figure it out a little bit?
Yes.
All right. Can you think of an example recently where maybe you were able to walk away from a situation or not overreact?
Just yesterday, I had grabbed something from somebody and the CO was like, "Oh, what you grabbed?" And I was about to cuss him out. And I'm like, let me just walk away. It's pointless to argue with him.
Okay,
That's
probably
what
saved
it
you a ticket, right? Because if you had
Yeah,
gotten into a back and forth with them, who wins?
they always win.
Yeah, yeah. I mean, and that's true with a lot of situations. Sometimes it just shouldn't be worth, as I like to say to some other people, it's just not worth your breath.
Yeah.
Gets you nowhere. Any other things you can think about where maybe you've been able to control your emotions or control your anger?
Recently?
Yeah. Something else that you're kind of proud that you were able to avoid getting in trouble for.
Nah, not really.
Okay. Okay. All right. So at some point you want to release and you want to live with your sister in New Haven. She wrote a letter in
Yes.
support of having you come live with her. Do you talk to your sister much?
Yes, I talk to her every day.
That's great. That's great. And why do you think she would be a good person for you to live with?
But she want me to change and she always giving me good advice.
Do you think you'd be able to live with her and not have any troubles? Because, sometimes if somebody's doing really well for themselves, you want to try and not create, turmoil or problems for them. Do you think you'd be able to do that?
Yes.
Okay. 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 I was reading about some of your life before you got arrested, what you were doing in the community. And you had really no structure to your day, right? You were just doing whatever you wanted to do, not going to school, not really have a plan. What do you think a good day would look like for you when you're back in the community?
Going to work, finishing school, like if I'm still in school, go to school and come back home and just chill.
You're a young guy. I mean, even if you didn't get parole today, you're going to be what, 20 when you're back out? I'm thinking realistically, can a 20-year-old just kind of go back, hang out at home and watch TV? What do you think you could do to help you stay out of trouble?
Keep talking to people that was helping me while I was in here, focus, go to work and just focus on myself.
That sounds like a good plan. And your mentor, is he helping you come up with some ideas of what you can do when you're home? Stay out of trouble, stay out of people's way. They're going to get you into trouble.
Yes.
Yeah. What does he tell you?
He just been talking to me about job corps, just programs that I could take when I go home. Staying connected with other mentors on the True program that went home.
Are you interested in doing any of that?
Yes.
Are you starting to set up a plan for that?
Yes.
Okay, tell me how you're starting to set that up.
I just been looking at like places that hire felons. I've been texting one of my mentors that recently went home. That's really it. And I've just been trying to stay connected, reading, focusing on school.
Okay, well, that's a good start. Good start. Do you think you're going to be able to not get any more disciplinary reports for the rest of your sentence?
Yes.
Okay. How are you planning to do that?
Just keep going to school and not surround myself around people that's not trying to change.
Well, I think you should be proud of the fact that, just the other day you were able to avoid getting a ticket, it sounds like. So it
Yes.
does seem to me that, you know, despite what's going on for the last couple of years, that you do want to make some positive changes to how you think and how you behave so you can get back in the community, live with your
Yes.
sister, be, you know, and be a good brother. Not,
Yes.
yeah, because she wrote a nice letter wanting you to come and live with her. I think that's important. You have that kind of support. Okay, Mr. Ortega, thank you. Well said.
Thank you, Councilmember Smith Montgomery. Okay, Mr. Ortega, you shared some pretty good insight with my colleague, and I was impressed when he asked you about your disciplinary reports. You said, it looks like I'm not changing. I'm just doing the same thing. You know, I was surprised to hear you say that. And kind of, you understand, you know, you get it that we look at those disciplinary reports, you understand, right? That's something that we're looking at to see if you've changed, right?
Yes.
Are you worried about going home? You don't have a lot of time left. Regardless of what happens today, you're going to be out. Are you worried about coming back?
Coming back to jail?
Yes. Yes.
No.
Have you ever
I'm
talked
not
to any of the older inmates that have been back and forth?
Yes, I have.
Some people, they just go back and forth, back and forth. This is your opportunity. You really don't have a criminal history besides this, right? This is your opportunity when you get out to not come back. Do you understand?
Yes, I do.
Some of these disciplinary reports, if you did these things while you were at your sister's house or at your job or at your school, some of these are crimes that will end you back up in jail. Do you understand that?
Yes, I do.
You're gonna have to change over the next 10 or 11 months, whatever time you have left. You're gonna have to really think about this so that way you don't come back and you're not one of those older guys that you see in the prison, right? These people that are 60, 70 years old. You don't want to spend your whole life there, right?
No.
All right. You have an opportunity. You seem like an intelligent young man to me. I mean, you were able to, you know, understand what we're looking at, and you have some good insight and understanding. You have people that care about you in the community. Your sister's gone through a lot of trouble to try to help you. Have you ever heard of the reentry services that are in New Haven? There's a lot of stuff in New Haven for people in your position that can help you.
Yes, I'll be looking at them on the tablet and stuff. There's a lot of that stuff on the tablet.
Yeah, and you're going to be in New Haven, so you're in a good spot because those services are very close, you know? So you really need to look at those. There's people, organizations that want to help you so you don't come back. But as soon as you get out, you got to have a plan. I would go there like the first day to one of these reentry service places and tell them your story, tell them what's going on, that you don't want to go back to prison. They'll help you find a job, all that stuff. They have counseling, all kinds of things, because no one wants you to come back. You understand?
Yes.
All right. That's all I really had to say, sir. We're done with our questions. We're going to talk about your case, and then we're going to give you an answer shortly, okay?
All right. Thank you. Appreciate it.
You're welcome. Councilmember Sarkov.
Okay, so Mr. Ortega, that's rated moderate for risk for recidivism, probably because he is so young.
Yeah.
And was so young at the time of these offenses, just 15 years old at the time, 19 years old today. Nevertheless, these are extremely serious offenses. I asked him about the impact on the victims, and he did acknowledge that the victims were probably traumatized. And I think he's probably right.
Yeah.
He has completed some good programs. He's done voices. He's done, according to my records, tier 1 and tier 2.
Actually, no.
He's done anger management. Talked a bit about conflict resolution. This is his first adult conviction. You know, what really stands out again is that the number of tickets and the nature of tickets. Quite a number of them are for fighting, some are for assaults, attempted assaults. C2 were assaults on DOC staff. And he's doing some good things. He's getting his GED, hopefully. He's attending church services. But unfortunately, the number and the nature of tickets really, I feel like, ties our hands here. And so I'm not going to be supportive of the discretionary parole. Hopefully, he's on a good track and doesn't come back into the system again.
Thank you. Member Smith Palmieri.
Yeah, I agree with Mr. Circle. It's the tickets that really tie our hands, because I do think that Mr. Ortega is starting to really focus in on how he thinks, what he needs to do to make changes, and the consequences of making poor decisions. It is about, but we know that individuals that are Mr. Ortega's age, you know, they struggle with thinking about the consequences and act impulsively. But I do hear some change. I hear somebody that's starting to recognize, you know, what he needs to do to live productively in the community. And the fact that his sister is supportive and that his mentor from the True program is still connected with him, is connecting him with people in the community, I think is a true benefit. It's a true, but is a benefit to Mr. Ortega going forward. And he should, and I'm really hopeful that he'll take advantage of it. But I have to agree, the tickets tie our hands.
Yeah, I agree. It's sad to see someone this age in this situation, you know? None of us want to see that, you know? But I mean, there's really no room here because of these tickets and the recency of them. But talking to him today, I mean, I hear, you know, I hear some insight from him, recognizing that he understands these tickets are a problem. He talked about what he learned, and he even talked about his impulsivity, and that sometimes he's able to control himself and sometimes finds himself in a situation that he just reacts without thinking. And those are the things that he needs to find a way to control through the guidance of his sister and his mentors, the other people he has. I hope that he engages with reentry services like he said he would, because I think that there's an opportunity here for him to stop this and move on in a more productive way in life when he gets out. Yeah, there's a window here that he can do something positive, get his GED, turn his life around, because he's so young, and then just never look back, you know. And I'm hopeful that that's what's going to happen here. But for today, I can't support his discretionary parole. Remember, Sarkov, what reasons do you have?
I just have the nature, circumstances, and constitutional adjustments.
And remember, Smith Palmieri?
That's all I had as well.
Okay, I'm fine with that. So there's no special parole here to follow, so that's where we're at. Regarding Lenny Ortega, inmate number 438197, I'm gonna make a motion to deny discretionary parole today based on the nature and circumstances of the current offense and his poor institutional adjustment. Do I have a second? All in favor? Aye. All right, Mr. Ortega, we were not able to grant your discretionary parole. Good luck to you, sir. We wish you the best.
Hey, Mr. Ortega, remember you cannot possess a firearm going forward. That'll bring you right back, okay? All right, and look to those programs.
This concludes the hearing for Lenny Ortega, number 438197. Morning, my name is Parole Officer Matt. Today is Wednesday, December 10th, 2025, and this is a hearing of the Connecticut Board of Pardons and Paroles. Can the board member please state their name for the record?
Robert Sazowskis.
Deborah Smith Mary.
Alex Starkov.
Thank you. This case review is being conducted to set the special parole conditions for Amber Bright, number 369320. On November 19th, 2025, the offender received a sentence modification that resulted in her immediate release from incarceration and the start of her 7 years of special parole.
Okay, thank you. So we're here to set the special parole conditions for Amber Bright. I've reviewed all of the documents and have no alcohol consumption, mental health evaluation and treatment as deemed necessary, no operation of a motor vehicle without the parole officer's permission. I also had no contact with the victim MZ without the parole officer's permission, and then no contact with co-defendants, Lemire Brooks and Christopher Solis. Is there anything else that we wanted to add to this? That's it?
I had nothing else.
Okay. So in regards to Amber Bright, inmate number 369320, I'm going to make a motion to set the following special parole conditions. No alcohol consumption, mental health evaluation and treatment as deemed necessary, no operation of a motor vehicle without the parole officer's permission, no contact with the victim MZ without the parole officer's permission, and no contact with co-defendants Lemire Brooks and Christopher Solis. Do I have a second?
Second.
All in favor? Aye.
This concludes the hearing for Amber Bright, number 369320.
Actually, no. Actually, we won't. To turn my program. We're going to get started. So good morning. I'm Parole Officer Tricello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Keenan Campbell, inmate number 432941. Today is Thursday, December 11th, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Robinson Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Keenan Campbell, 432941.
Thank you. So this is a public hearing and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record? You're muted.
Sorry. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit on behalf of Mr. Campbell.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence, and that is a better weightier evidence must establish that more probably than not the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked. And if I recommend revocation, I'll make a recommendation as to an appropriate sanction. The recommendation will then be given to a panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. Mr. Campbell, can you please raise your right hand? Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth,
the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes, ma'am.
Thank you. So we're going to go over the procedure for today. So you can put your hand down. Thank you. First, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
So we're going to go over your rights for today. So your first right is that you do have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes, ma'am.
You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, ma'am.
So we're now going to review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. So on charge number 1, the condition of obedience to the law, the charging officer reported that on 12/19/24, you were observed at the First Track bus stop in New Britain. You were observed by New Britain police officers removing a plastic baggie from your jacket pocket that contained a pile of white rock-like substance and handed it to a male in the area. Upon seeing you complete what appeared to be a hand-to-hand drug transaction, New Britain police verbally addressed you to stop walking, and while doing so, you shoved something in your pants, specifically between your buttocks. You deny that you had hid the narcotics in your buttocks, and subsequently a canine search was completed and hit you on your buttocks area. You remained non-compliant during the search and were transported to New Britain Police Department for a strip search to be conducted. You continued to clench your buttocks during the strip search and remained non-compliant until the last time you bent down, and you were informed by New Britain Police Department that they could see the narcotics. The white rock-like substance was field tested and produced a positive results for cocaine. You had 5.2 grams of crack/cocaine on your persons. Subsequently, you were charged with Connecticut General Statute 21A-279A1, possession of a controlled substance, 21A-277A1A, sale of narcotic substances, 53A-167A, interfering with an officer, and 53A-155, tampering with physical evidence. You were arraigned in G15 on 12/20/2024, and probable cause was found. You have a $90,000 bond and an next court date of 2/14/2025. On charge number 2, the condition of drugs, the charging officer reported that on 12/19/24, you were seen selling narcotics at the Fast Track in New Britain. After your arrest, you were strip searched and 5.2 grams of cocaine were found in your buttocks. Subsequently, you're charged with Connecticut General Statute 21A-279A1, possession of controlled substance, 21A-277A1, sale of narcotic substance, 53A-167A, interfering with an officer, and 53A-155, tampering with physical evidence. You're arraigned in G15 on 12/20/24, and probable cause was found. You have a $90,000 bond and the next court date of 2/14/2025. The state has filed the following exhibits that have been identified for today's purposes as Exhibit A, the parole conditions, Exhibit B, the remand to custody order, Exhibit C, the violation notice of parole, Exhibit D, the parole violation report, Exhibit E, the state of Connecticut judicial branch pending case detail, Exhibit F, the BOPP decision and summary, and Exhibit G, the New Britain PD incident report. In addition, they did file an addendum to the parole violation report on November 13th, 2025, and that states that Mr. Campbell was seen in court, I just want to get the date, on 11/6/2025, and the following happened. You were found guilty of tampering with physical evidence and sentenced to 2 years in jail. And the charges of possession of a controlled substance, sale of narcotic substance, and interfering with an officer were all nollied. So counsel, just to confirm, you and your client did receive the notice of parole violation, the parole violation report, and all the other documents identified for today?
Yes.
You're able to review them, correct?
Yes.
Thank you. I did receive an exhibit from the defense. I have Exhibit 1, a list of parole accomplishments and future plans for parole reinstatement. Counsel, do you need any time to submit any other evidence exhibits? No. We do not have any witnesses at this time, so it is now the defense's opportunity to call any witnesses, present evidence, and speak to the charges or any of the evidence submitted. So counsel?
Yes, thank you. In regards to charge one under obedience to the law, I just indicate the addendum is stated accurately, that my client did receive that 2-year sentence. I believe his TS eligibility date on that sentence to be December 19th of this year, with his EOS date to be December 9th of 2026. In regards to charge 2 under drugs, I would just make a note that my client was not convicted of any drug-related offenses in terms of his court appearance on November 6th. Nothing further as to the charges.
Thank you. Just gonna take a moment and I'm gonna announce my findings. So on charge number 1, Mr. Campbell, I am making a finding that you violated the condition of obedience to the law based on your conviction of the tampering with physical evidence on November 6, 2025, when you received that 2-year jail sentence. In addition, the evidence in support of the charge is exhibits A, D, E, and G. And for charge number 2, I'm also finding that you violated the condition of drugs based on the evidence presented in states exhibits A, D, and G. So that does conclude the fact-finding portion of today's hearing. Before I make my recommendation, you'll have an opportunity to speak to your background and history. The purpose of this part of the revocation hearing is to help determine what outcome I'll recommend. So counsel?
Yes, thank you. My client is 24 years of age. He's single. He has no children. He does receive his primary support in the community by way of his mother, siblings, 3 sisters, 1 brother, cousins. He's a high school graduate. He did complete in 2022 1 semester of college at 3 Rivers Community College, where he studied marketing as well as English 101. In 2023, he reports obtaining his OSHA 30 certification as well. He was in the community for approximately, I believe, 5 weeks. And this is his first violation of his parole. During the time that he was in the community, he was sponsored to his mother in Hartford. He remained there until his remand. Also during his community supervision, he was able to earn his driving permit. He also obtained employment working at Our Piece of the Pie, doing community work. This was employment he was able to secure immediately upon his release because he participated in an Our Piece of the Pie behind bars program while he was incarcerated. He also attended Our Piece of the Pie doing programming, reentry programming as well. I would note that his parole officer in the recommendation section of his parole violation report does indicate that he was compliant with GPS monitoring. He was always respectful, showed up on time to all reporting sessions. During the time period that he has been within the Department of Corrections, and he has just been recently sentenced, as you're aware, and he's been in custody now for approximately 1 year. So he hasn't had any programming available to him due to the fact that he was an unsentenced prisoner up until just recently. However, he has been attending Muslim religious services during his time period. He's indicating that upon reinstatement to parole, he'd like to be sponsored again to his mother. She was previously his approved sponsor. That address is located within Defense Exhibit 1, and it's in Hartford. By way of education, he is extremely interested in pursuing a career in plumbing. He's interested in enrolling in a plumbing apprenticeship program, either through local 777 or Porter and Chester. He does have his employment to return to, a full-time position at Our Piece of the Pie. He's also amenable to any treatment recommendations. We would be asking that he be re-paroled at his TS eligibility date with a MOA. That's the extent of my comments. I'm not sure if Mr. Campbell would like to address you.
Yes, I would like to just take responsibility and accountability for my actions, because I did violate and I did disobey the law while I was in the community. But I wanted to go back out there, re-parole, and work extensively with my parole officer to help me successfully finish special parole and be there with my family and continue to commence into my plumbing passion. That's really it.
Thank you. I appreciate your statement.
Thank you,
Anything
Mr.
further,
Campbell.
council?
No, thank you.
Thank you. I'm just going to take a moment. I'll announce my recommendation. So I have listened to the testimony today. I've reviewed all the evidence submitted. With that, Mr. Campbell, I am going to recommend your parole be revoked. I guess I do want to note a few things. I do recognize this is your first violation on special parole. However, you're only out in the community for, as your counsel said, 5 weeks. Parole's sent over as 48 days. So that's just concerning to me at this point. So I am going to recommend your parole be revoked and that you serve a 2-year period of confinement as a sanction. And that's with a re-parole date of December 19th, 2026. I'm going to recommend the following conditions: behavioral management program for anger management, no contact with victim KS, mental health evaluation treatment as deemed necessary, and I'll note the sponsor for the for your file. In the event the board does lessen my sanction, the MOA stipulation will be added as well. So what happens next, Mr. Campbell, is that your case is going to go in front of the board next week on the 18th. And on that date, the board can do 3 things. They can lessen my recommendation if they choose to do so. They can adopt it if they choose to do so. And if for any reason they would want to see a length of period of confinement longer than what I've recommended, they'll ask you to come back to speak with them and answer their questions and concerns before they impose anything longer. So that does conclude today's hearing. Do you have any questions? No?
No, that's not.
Keenan, you can contact me after December 18th and I can tell you what the board ultimately decided, okay? And then we can talk about that, okay?
Okay.
All right.
Thank you. This concludes the
Thank you.
revocation for Campbell, inmate number 432-941. Thank you, Mr. Jones. Good luck to you, Mr. Campbell.
Thank you.
Thank you. Have a nice day.
You too. Hi, Mr. McClendon.
Aye.
We're gonna get started, okay?
Yes.
Okay, so good morning. My name is Parole Officer Chiselle, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Seville McClendon, inmate number 406-118. Today is Thursday, December 11th, 2025, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office and Robinson Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Seville McClendon, 306-118.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Good morning, Peter Matthews with the Public Defender's Office for Mr. McClendon.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I'll review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence, and that is a better way to your evidence must establish that, more probably than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked. And if I recommend revocation, I'll make a recommendation as to an appropriate sanction. The recommendation will then be given to a panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Ms. McClendon, can you please raise your right hand? You solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury.
Yes.
Thank you. So we're going to go over the procedure for today. So first, you put your hand down. Thanks. I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I'll announce my findings. If any have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
We're going to go over your rights for today. So you do have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes.
You have the right to review the
Yes.
evidence against. Yeah. You also have the right to, what's happening? Are you good? Do you have a question? Or are you just responding to me
No,
and then I'm going?
no.
And we're just.
I was, yeah, it was a little bit off, so I was responding.
It's overlapping. Got it. I think we are a little bit off. I think there's a lag. So just want to make sure I'm not missing anything. All right. So you also have the right to receive the written notice that charges the violation. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. And you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes.
So we're going to review the charges that the state parole officer has filed or brought against you and the information underlying each charge. I do want to note on the record that a no finding was made for charge number 3 at the preliminary hearing for statutory release criteria. No new evidence has been received from Parole and Community Services for that charge, so it is not going to be taken into consideration at today's hearing. So on charge number 1, the condition of obedience to the law, the charging officer reported that on 7/29/25, you were arrested by the Hartford Police Department for a domestic dispute involving your sister, who for the purpose of this report will be referred to as Jane Doe. You were arrested for punching and then attempting to stab Jane Doe with a kitchen knife after becoming upset by an argument that ensued between yourself and Jane Doe over social media. You're arrested and charged with the following: Connecticut General Statute 53A-182, disorderly conduct, Connecticut General Statute 53A-63, reckless endangerment first, and 53A-61, assault in the 3rd degree. Subsequently, you were in violation of your signed parole condition number 2, obey all laws. Charge number 2, the condition of weapons. The charging officer reported that on 7/29/25, you were arrested by the Hartford Police Department for a domestic dispute involving your sister, for who the purpose of this report is being referred to as Jane Doe. You were arrested for punching and then attempting to stab Jane Doe with a kitchen knife after becoming upset about an argument that ensued between yourself and Jane Doe over social media. You're arrested and charged with the following: Connecticut General Statute 53A-182, disorderly conduct, Connecticut General Statute 53A-63, reckless endangerment first, and 53A-61, assault in the 3rd degree. Subsequently, you're in violation of your signed parole condition number 2, obey all laws. The evidence submitted was already identified at the preliminary hearing, so that all does remain the same. In addition, Parole and Community Services did file an addendum to the parole violation report that reads, on November 19, 2025, and that states that you were seen in court for the charges. They went.
It didn't have a date.
Did not have a date.
In the report. I do have it somewhere, not right in front of me.
Mr. McClellan, do you remember when you were in court for that case by any chance? What day?
When I did the last day, I believe it was the last day I went to court was the 18th of
The 18th of November?
Yeah. No,
Okay.
October.
Yes, that's correct. November 18th.
November 18th? November 18th.
Yes.
Okay, so we'll go with, so on November 18th, you did appear in court. And it states that all of the charges, which were reckless endangerment, disorderly conduct, and assault, were all nullied. You were sentenced on a violation of probation charge that stemmed from the arrest and were sentenced to 6 months. Your EOS is 3/11/26, and you do not have any pending charges at this time. Counsel, just to confirm, you and your client did receive the notice of parole violation, the parole violation report, and all the other documents identified for today?
Yes, we did.
Thank you. And I did receive exhibits from the defense. I have exhibit 1, a list of parole accomplishments and future plans for parole reinstatement, as well as exhibit 2, the statement from Herbert London, who's the uncle, correct?
That's correct.
Do you need any time to submit any additional?
I do not know.
We don't have any witnesses, so it is now the defense's opportunity to call any witnesses, present evidence, and speak to any of the charges or the evidence submitted. So, counsel?
Thank you. As was indicated, the criminal charges, which were the basis for charge 1 and 2, they were both nullied in Hartford Court back in November. Mr. McClellan always very strongly challenged the statements that were provided by his sister regarding this incident. Presumably, the prosecutor did review these allegations and review the evidence, and after taking everything into account, they elected not to pursue the case. I acknowledge reading the initial reports, it sounds like it was a serious incident, but I would ask you to consider the fact that it was not pursued. I know his uncle gave a very different version of what happened. Mr. McClendon gives a very different version of what happened. They indicated that his sister was hitting him on the head with both the two cell phones, and it sounds from that statement that she was the primary aggressor in this incident. I know there's been some history of animosity between the two parties, and Mr. McClendon did indicate he was just trying to protect himself from his sister, who was very angry and out of control at the time. So after reviewing everything, the state elected not to pursue any of these criminal charges. He did enter admission to a VOC, however, he didn't plead guilty to any of the domestic charges, which were the basis of this violation. This isolated incident was the sole basis of the violation. Other than that, it appears he was doing well with regard to his parole. So if there is a finding on any of these two charges, I would like to be heard further. Thank you.
Thank you. Take a moment and I will announce my findings. So I do understand, Mr. McClendon, that the charges were nullified in court, but that does not negate that behavior actually occurred for that. So with that, I am going to make a finding on charge number 1, the condition of obedience to the law based on the evidence presented in the state's exhibits C, D, E, and G, as well as defense exhibit 2. And I'm also going to make a finding of probable cause. Sorry, it's not probable cause. It's a totally different hearing. I'm making a finding that you violated the conditions. Did that one right? This one's wrong. Sorry, I'm making a finding that you did violate the condition of weapon based on the evidence presented in state's exhibits C, D, E, as well as defense exhibit 2. So with that, it does conclude the fact-finding portion of this hearing. Before I make my recommendation, you'll have an opportunity to speak to your background and history. The purpose of this part of the revocation is to help determine what outcome I recommend. So counsel.
Thank you. So Mr. McClendon, he's 39 years old. He was born and raised in Hartford with his family. He still has a lot of family in the Hartford area, including his 2 children who are 13 and 5. His daughter, she's autistic and nonverbal, and he does take a very active role in caring for her, along with both him and his mother do. And he has a very good and cooperative relationship with his daughter's mother in caring for their child. He also has a very close relationship to his younger sister, who has been undergoing a lot of medical issues that Mr. McClendon is hopeful to continue helping her with when he is released. I know based upon this, there may have been some issues with his other sister, but generally, Mr. McClendon has a good and supportive relationship with most of his family in the Connecticut area. So prior to his remand, Mr. McClendon was residing in a Reach House. He'd been there for about 6 months. Before the Reach House, he was in the Open Hearth Halfway House program. He did successfully complete the Open Hearth treatment program at that halfway house. He had been successful in multiple halfway house programs over the course of his parole. When he is released, Mr. McClendon is asking to be placed in the Hartford area. Prior to his remand, he was working. He was working at Denny's on Flatbush Avenue. He'd been there for about 7 months. He did have a very good relationship with his employer. He's hoping he'll be able to get that job back when he is released. He has procured a lot of positions over the past few years with temp agencies as well. The mitigation report he submitted does go through some of his work history, and he's always been good about finding work in a fairly quick manner. He's a hardworking man and doesn't want to get back to work when he's released. He graduated from high school. He did obtain an associate's degree at Manchester Community College. He did recently start additional classes at Capital Community College, and he is also interested in continuing to pursue this program as well when he gets out. So he was last released from incarceration in October 2024. He'd been under supervision for about 9 months at the time of the remand. During this period of time, the only other noted misconduct was there's one occasion where he returned a little late to the halfway house. But other than that, he was doing very well with his parole supervision. It seems he's been cooperative with parole during this period of time. He was engaging in mental health treatment through CRT. At the CRT program, he had done an IOP program, he had done group therapy, and he had done individual cognitive therapy. There's no noted positive urinalysis tests over this period of supervision. And as I indicated, he cooperated with the halfway house placement and the program there as well. So he's been very cooperative with all the treatment that's been set up for him by parole over this period of time. I know that PBR recommends that he continues with mental health treatment when he's released, and he's certainly willing to do that. He is apologetic about the incident with his sister. He, as I indicated, he disputes her version of events. And based upon the state's decision not to prosecute, I suspect they had some questions about her version of events as well. But he does acknowledge that it was an unfortunate incident that he probably could have handled a little bit differently. All the charges are misdemeanor in nature. There's no allegation of any felony conduct. And as I indicated, other than this, he was doing very well in supervision. I know Mr. McClendon has had a few prior violations, but I don't think his conduct in this incident is such to provide evidence that he's unwilling or unable to work with parole and cooperate with supervision. I think he is willing and able to cooperate with supervision going forward. He has a plan. He knows he needs to engage with mental health counseling. He knows he needs to get back to work, and he's planning on doing that. The recommendation from parole was a sanction of 6 months to 1 year. Given the outcome in court and everything else he's been doing, I would ask you to consider a 6-month sanction in this case, as opposed to a longer recommendation of 1 year. Given that the charges were not being pursued, I think that would be appropriate to put it on the lower end of the sanction that was recommended. He has been incarcerated for a few months now, and he is anxious to get back out there to see his family, to help with his daughter, and get back to work. Mr. McClendon, is there anything you'd like to add at this point in time?
No, other than my sister attacked me. I understand the situation in that, but I was attacked by my sister. Like I told y'all before, my younger sister had a heart attack. So all my sisters put a conservative for me to be in charge of my younger sister. We were supposed to go August 5th. You feel me? My other sister was still in my sister because he lost brain activity. So my sister and my grandmother was still in their money. My brothers and sisters put a conservative for me to be charged with my sister while she in her state because she can't move or she lost brain function. They purposely knew I was on special parole and they called the cops on me and lied to me so I won't make it to the conservatives on August 5th. You feel me? As my uncle stated, he was there, he was a witness, she was attacking me. I was just trying to get away. I was blocked from leaving the house. You feel me? I'm apologetic about the role I played and having a police contact, but this time around, I really didn't do nothing. I really tried to do the right thing, and I was punished for it. You feel me? Because they ain't want me to go to the conservative. That's all I want to say.
Thank you, Ms. McClendon. I do appreciate your statement. Council, anything further?
No, nothing else to add.
Just gonna take a moment. I have listened to all the testimony presented today. I have reviewed all the evidence presented as well, Mr. McClendon. With that, I am going to recommend that your parole be revoked and that you serve an approximate 6-month period of confinement as a sanction, and that's with a reparole date of January 29th, 2026. I'm going to make a recommendation for the following conditions: behavioral management program for anger management, no contact with victim OL, no general no contact with LM, a general no contact with DM without your parole officer's permission, a mental health evaluation and treatment as deemed necessary, no operation of a motor vehicle without parole officer's permission, and halfway house placement in Hartford. I just want to reiterate that, Mr. London, do not have contact with your sister unless you ask permission first, okay? Speak to your officer if you need to be around her or with her, whatever the case may be, okay? Just don't get yourself locked up with that one, okay? I didn't mean that.
Yes.
I just meant don't get yourself in trouble by doing that, okay? If the board accepts the recommendation, but I just want to make it known since I know you are family, but just be mindful, okay? So what happens next, Mr. McClendon, is my recommendation is going to go to the board. Actually, I think I need a MOA, right? He has that VOP running. Yeah.
It's not pending anymore, right?
It's running though until March. So I'm also going to do a MOA stipulation. What that means is if the board adopts my recommendation, that gives DOC the right to like look at you for early release for that sentence if they choose to do so. If not, you could be in
Yes.
for it, but it's up to DOC, okay?
Yes.
So I'll do a MOA recommendation as well, stipulation as well. So what happens is my recommendation is gonna go to the board next week on December 18th. On that date, the board's can do a few things. They can adopt my recommendation if they choose to do so. They can lessen it if they choose to do so. And if for any reason they would want to see a period of confinement longer than what I'm recommending, you'll be asked to come back and talk to them and answer their questions, concerns before anything longer is imposed, okay?
Yes, ma'am.
Do you have any questions? Did I confuse you about that, like, MOA stipulation thing? Because I probably confused myself a little. You understand that?
No, you didn't. Yes.
You're good?
Okay, so if you have
Yeah.
any questions, you can call, okay?
All right. I got one question. Can you see if, when I'm placed in the halfway house, can it be on like the south end of Hartford instead of the north end?
I don't have any control over that. Whoever you're reporting to, Pearland Community Services does housing placements. I can note it in the report that I'm gonna write, but it is ultimately up to them, and it's not even guaranteed you'll be in Hartford. They place you where their location if they have to release you. So I'll make note of it, but once you're out, maybe just try to work with them. If it's not the right place for you, just try to be compliant, work with them the best you can to get to where you need to be, okay?
All right, thank you.
All right, thank you, Mr. McClendon. Good luck to you. This concludes the revocation
you
hearing for Seville McClendon, ME number 306118. Thank you.
All right. Have a nice day.
Good morning, Officer Grant. I just want to confirm you're with us. She's on mute.
Yeah, I think I see the mic.
Good
Good
There we
morning.
go.
I am with you.
Perfect, thank you. Just gonna hope that Brooklyn answers.
They don't have it back in.
Seems like it. Mr. Grant, just to keep you updated, I just talked to Brooklyn. They said they didn't have the schedule for today, so we're trying to get down it for them to connect, okay?
Okay, no problem. Ms. Grant, if you're hearing us, I'm not sure if you could hear us. Our internet went down, so we're trying to get it resolved.
Can you repeat that one more time?
Our internet went down for the entire floor, so our IT department is working on trying to get it stabilized again and reconnected.
Okay. Okay, no problem.
Stop.
Which to me, there's designated hours in the building.
Yeah. Good. We'll look, we're back on. Thank you, Danelle. I really do appreciate it. All right, so let's see. Well, where the heck did Circa go? So how did Tom find that out?
Don't
We
know.
can hear you.
Thank you.
I mean, I'm
Alan, is it showing that they're answering? Because it's just pending. The officer said there should be someone in there to answer, which I don't know what's happening.
They haven't picked up yet, but I'm trying to dial them in again here at my end, so we'll see if we get them on.
Thank you.
Hi, there you are.
Hello.
So I can't see them. But they're here. Alan, do you mind coming over this way, please?
If you could bring, oh, there you go. If you could get Mr. I believe it's Garner Jimmy
Yes.
in, we'll be with him shortly.
Okay.
All right, we're making progress so we can see Gardner now. Officer Grant, can you just confirm your video is working so that we can see you? Thanks. All right, I think we did it. I think it's working now. So we're gonna get started. I don't want to jinx anything. Good morning, Mr. Gardner. We're gonna get started really quick right now, okay?
Good morning.
So good morning. I am Parole Officer Trissello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Jimmy Gardner, inmate number 2000386. Today is Thursday, December 11, 2025, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office and Brooklyn Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Jimmy Gardner, 200-386.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself for the record?
Sure. Attorney Alfonso Sorico from the parole revocation unit on behalf of Mr. Gardner this morning.
Thank you. And also as your charging officer, can you please identify yourself for the record?
Oh, Jimmy Gardner.
You're good, Mr. Gardner. Sorry, Officer Grant.
Parole Officer Lisa Grant, State of Connecticut, Department of DOC, Parole and Community Services.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I'll review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is a better or weaker evidence must establish that more probably than not the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked. And if I recommend a revocation, I'll make a recommendation as to an appropriate sanction. The recommendation will then be given to a panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can't be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Gardner and Officer Grant, can you both please raise your right hands? You solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury.
Yes.
Thank you, Mr. Gardner. I can't hear her. Oh, you were muted. I'm like, oh, I just figured there was a lag.
No, I can't hear, but it jumped a little bit.
Yeah. All right, so we're gonna go over the procedure for today. So first I'm gonna read you your rights. Then we're gonna review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state will then have an opportunity to present all relevant testimony, subject to cross-examination, and any relevant documents. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I will announce my findings. And if I find you have violated one or more of the conditions of your parole, the state will have an opportunity to speak to your background and history. And after the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
You talking to me?
Yeah, sorry, Mr. Gardner. Yeah, do you have any questions about the purpose or procedure?
No.
I didn't explain it to him.
Okay, all right, perfect. So we're just gonna go over your rights for the hearing today. So you do have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
He did.
Perfect.
Yes.
Thank you. You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
Thanks. So we're now going to review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. Officer Grant, can you please review the charges for us? And you are muted. Perfect. Thank you.
Okay. Charge number 1, absconder. On April 1st, 2025, you went to Chase Center's halfway house's front office to sign out for work. Staff informed you that you didn't have a pass and asked you to provide a work schedule in order for the on-call duty officer to give permission to create a pass. You told staff to review previous passes to verify your schedule. Staff told you that you could not provide a pass, that they could not provide a pass based off previous passes. You then asked, how were you going to show a schedule, and stated that you've been left the halfway house to go to work. You stated then your people would get your stuff. At 5:58 a.m., you proceeded to walk out of the the front door without permission from halfway house staff. This parole officer Grant called you and instructed you to return to the halfway house ASAP so that staff could contact the job to verify the schedule. You stated you were frustrated with halfway house, but agreed to return, but never did. At 7:30 a.m., PO was notified that you had not returned to the halfway house. Staff contacted St. Mary's Hospital, Waterbury Hospital, and checked Waterbury Police Station in an attempt to locate you, to no avail. Staff attempted to call your job and was sent to voicemail. Area Program Director Luis Rodriguez and job developer Ruben Rivera went to Global Steering Systems to verify if you were at work. The APD spoke with Christina from HR and Stephanie from the temp agency Randstad. At 11:45 a.m., Stephanie stated that you had perfect attendance until this week. Stephanie stated that you did not report to work. You walked out of your only parole-approved residence at Chase Center Halfway House located at 21 Cliff Street and Waterbury without permission from halfway house staff or parole. On 4/1/25, 4/7/25, and 4/16/25, parole instructed you to turn yourself in. You failed to comply and had made no efforts to disclose your location. On 4/23/25, parole conducted a community search for you in the Waterbury area and was unable to locate you. Your whereabouts in the community remain unknown. Your actions violated your conditions of parole, specifically release directions. I will live in a residence approved by my parole officer. Charge number 2, obedience to the law. On 9/24/25, you were arrested by Waterbury Police Department for interfering. Charge number 3, drugs. On or about 3/21/25, you used cocaine. Charge number 4, halfway house placement. On 4/1/25, you went to Chase Center Halfway House's front office to sign out for work. Staff informed you that you didn't have a pass and asked you to provide a work schedule in order for the on-call duty officer to give permission to create a pass. You told staff to review previous passes to verify your schedule. Staff told you that you cannot provide they could not provide a pass based off previous passes. You then asked, how are you going to show a schedule, and stated that you should have been left the halfway house to go to work. You then stated your people would get your stuff. At 5:58 a.m., you proceeded to walk out the front door without permission from halfway house staff. The parole officer, Grant, called you and instructed you to return to the halfway house ASAP so that staff could contact the job to verify your schedule. You stated you were frustrated with halfway house, but agreed to return, but never did. At 7:30 a.m., this PO was notified that you had not returned to the halfway house. Staff contacted St. Mary's Hospital, Waterbury Hospital, and checked the Waterbury Police Station in an attempt to locate you, to no avail. Staff attempted to call your job and was sent to voicemail. The area Program Director Luis Rodriguez and job developer Ruben Rivera went to Global Steering Systems to verify if you were at work. Area Program Director spoke with Christina from HR and Stephanie from the temp agency Randstad. At 11:45 a.m., Stephanie stated that you had perfect attendance until this week. Stephanie stated that you did not report to work. You walked out of your only parole-approved residence at Chase Center Halfway House, located at 21 Cliff Street in Waterbury, without permission from halfway house staff or parole. On April 1st, 2025, on April 7th, 2025, and April 16th, 2025, parole instructed you to turn yourself in. You failed to comply and had made no efforts to disclose your location. On April 23rd, 25, Parole conducted a community search for you in the Waterbury area and was unable to locate you. Your whereabouts in the community remained unknown. Your actions violated the halfway house agreement. Specifically, I will not leave the physical confines of the halfway house unless authorized by program staff or parole.
Thank you. You've also submitted evidence in support of the case. Can you please identify the evidence for today's hearing?
No, not you, Jimmy.
Oh, okay. Can you give me a minute to get the list?
Sure. If not, I do have it in front of me. I can
I have no objection to having the hearing examiner read it. I have a
review
copy.
it today. So it's Exhibit A, the remand to actual custody. Exhibit B, the parole violation report. Exhibit C, the PCS signed conditions. Exhibit D, the halfway house agreement. Exhibit E, the residential discipline report dated 3/31/25. Exhibit F, the Redwood toxicology laboratory report dated 3/31/25. Exhibit G, the PCS incident report dated 4/1/25. Exhibit H, the revocation hearing summary. Exhibit I, the substance abuse referral screening form. Exhibit J, the notice of parole violation. Exhibit K, the notice of parole rights. And Exhibit L, the Waterbury Police Department incident report 250093584. You did also file addendums to the parole violation report. Do you have those available, or would you like me to review them? Officer.
Please reveal them.
Yeah, no problem. So we have the first one is was submitted on September 29th, 2025. And that states that on 5/28/25, the Board of Parole issued a warrant based on the report declaring the offender an absconded from special parole supervision. And that on 9/24/25, Gardner was arrested and was apprehended by the Waterbury Police Department for interfering as well as an absconder. Then the second one was submitted on 11/17/25, and that states that on 11/6/25, under docket number ending in 629S, Jimmy Gardner did not enter a plea for interfering with an officer, and he received a nollie. Counsel, to confirm, you and your client did receive the notice of parole violation, the parole violation report, and all the other documents for today.
Yes, we did.
Thank you. And I did receive exhibits from the defense. I have Exhibit 1, a list of parole accomplishments and future plans for parole reinstatement, as well as Exhibit 2, the certificates numbers 1-16. Counsel, do you need time to submit any other evidence?
No.
We do not have any witnesses at this time, so it is now the state's opportunity to call any witnesses, present evidence, and speak to any of the evidence submitted. So Officer Grant, would you like to make any comments towards the charges?
So Jimmy Gardner discharged to special parole to Chase Center Halfway House initially on 7/18/2019. On 9/23/19, he transferred from the halfway house to community supervision. During that supervision period, he received 16 misconducts for mostly positive drug screenings and GPS violations.
Officer Grant, I'm gonna quickly stop you. So right now, we're just speaking towards the charges. If the hearing moves on to the second part, for the aggravating information, all of that there. So anything direct towards the charges of obstructing obedience to the law, drugs, or halfway house placement?
That is it for those charges.
Nothing towards the charges? Okay, thank you. And counsel?
Just briefly, P.O. Grant, have you been supervising Mr. Gardner on this supervision, which started on October 13th of 2023? Have you been with him since day one, or was he transferred to you as something?
I'm sorry, it's a bad connection. I didn't hear your entire question.
Have you been supervising Mr. Gardner since October 13th of 2023?
Yes. But I supervised him, I'm sorry. I supervised him when he came to Chase Halfway House April 1st, 2025.
Okay. So you have not been his parole officer since his release on October 13th of 2023. Is that correct? that correct?
No,
Okay. And according to the exhibit B, under the graduated interventions and sanctions, it appears, according to this document, there had been no issues within the past 6 months.
with, excuse me, can you repeat that? There hasn't been any issues within the past 6 months with his signed conditions? Is that what you're asking me?
Yes, I'm going by exhibit B, which is the parole violation report for the fugitive that in the page 2 on the graduated interventions and sanctions, it indicated none within the past 6 months.
No, his only charge started, well, his charges started on March 31st. He had a positive drug toxic screen, which he would have been given a misconduct for, but on April 1st, he walked out of the halfway house.
Correct. Okay.
Therefore, he wasn't able, therefore, I wasn't able to issue him a misconduct because he had absconded at that point.
Understood. Right. Mr. Gardner, this is a question for you.
Yes, sir.
Prior to April 1st, the day the allegation where you left the Chase Halfway House Center, had you been working, so from April 1st going backwards, had you been working at the same location for a while?
Yes, for almost 2 months.
Okay, and within that 2 months, the work passes from the halfway house, were they for the same hours? Did you have the same schedule for those 2 months?
Repeatedly,
okay.
Yes, repeatedly.
Okay, and what were your hours?
7 to, it started at 7 o'clock, 8 hours from then. So
Like 7 a.m. or p.m.?
Yes, so, yeah, because we got to catch the bus. I leave at 5, we go catch the bus, probably be at work by like 6:30, 7 o'clock, something like that. And we stay for 8 hours to work.
Okay, and when you were given those work passes, was it a daily pass or were you given a pass for the week? For 2 weeks? How?
The whole month, supposed to be in there the whole month. And I sat down with Mrs. Grant, the supervisor of the halfway house, on March 31st, because they kept me back already at March 30th. So March 31st, I sat down with Grant and all them, explaining the unstableness of me making it to work. You know, the passes don't be here, we put them in, they don't be on their job. So I'm trying to straighten that out with them. So now the next day, because I went out to pass that same day, the 31st, you know? So then the next day I go to work, they say, I don't got a pass. And I said, how? I just sat down and talked to them, everything should be smooth, you know? So I said, call the parole officer and say they can't do that. Call the supervisor, say they can't do that. They call on-call, they're talking about a work schedule. Y'all got a copy of the work schedule before you get a job, you gotta bring the work schedule. So that was 2 months ago, so you've been at the work schedule, it didn't change.
Understood, and that was my question. So you made an attempt, I believe you said March 30th, to try to straighten this out with the parole officer and the supervisor, correct?
Yes, yes.
Okay, and then according to the, when they contacted your employee, it looked like you had perfect attendance up until March 31st, is that correct?
Yes, March 30th, 31st, and April 1st. I called when I left out. You know, I was catching the bus up there. They said, your position had been taken. They did no more. So that's the third day I missed, you know, going to work late, whatever the case may be. So I just, I was frustrated and relapsed.
Okay, and you beat me to my next question. Is it a fair statement starting March 31st / April 1st? Well, April 1st, that morning is when you got frustrated because of the work situation, correct?
Yes, sir.
And then you relapsed.
Yes, sir.
Correct?
Yes,
All right.
sir.
And then you were picked up by the Waterbury police on September 24th of 2025, correct?
Yes, sir. Yes, sir.
Okay, in that case, those charges were nollied in court on November 6th of 2025, correct?
Yes, sir.
All right, and my last question, during that period of time from April 1st to September 24th, 2025, you were in the state of Connecticut that entire time, correct?
Whole time. In
Okay.
Waterbury.
Okay, I don't have any further questions of either of them. I just wanted to give you a little background as to what occurred. We're not disputing what Peel Grant said about my client leaving the halfway house on April 1st, but it's important to know why he left. Obviously, the relapse was one of the issues, and the other issue was it appears he had a perfect attendance according to when they called his job up until the 31st. As he indicated, he's had the same hours for the past 2 months. It's not like he worked the morning shift, afternoon shift, or overnight shift. So he was under the impression that he was good to go on April 1st. I understand the better way of handling the way he did, but I just wanted to give you a little background regarding his work schedule. I don't have any other comments regarding the first part of the hearing. I know charge number 4 on the halfway house claim, it's the same language that's used in charge number 1, so that would be my same comments for that. I don't need to repeat all those again. Thank you.
Thank you. Just want to confirm any additional comments from either side. Officer Grant, anything additional at this time? Towards the charges?
Just one comment about the passes. He's fully aware that with the halfway house, the passes for the work schedule has to be submitted each week. If they're not submitted within 3 business days prior to the beginning of the week, passes cannot be approved. So at that point, we were willing to work with him to get passes approved. Staff is responsible for providing a weekly employment verification with the job, and they cross-reference it with his schedule, with his pay stub, and then also contacting the employer to verify attendance and also the current week's schedule. I just wanted to note that.
And my just comment on that, I'm not disputing what you're saying, Peel Grant, but if that's the case, and correct me if I'm wrong here, March 31st was a Monday of 2025, so he did go to work on that date. April 1st is a Tuesday. Why would he only have a pass for Monday and not Tuesday if the pass is a weekly pass? Can you help me out with that?
I don't know if he submitted it or not.
Okay.
So he's responsible for providing his passes.
Okay, based on, I understand it's a weekly pass, but the issue I'm looking at here is the 31st is a Monday and April 1st is a Tuesday. So a little confused as to why the pass would start on the Tuesday and not on a Monday and go from Monday to Friday. That's all I'm saying. I'm not disputing your comments regarding the weekly pass, but looking at the calendar, in Monday is March 31st, Tuesday's April 1st. He was allowed to go to work on Monday with a pass, but then a new pass would start on a Tuesday. I don't have anything further to say. Thank you.
All right, I'm just gonna take a moment. I'll announce my finding. So on charge number 1, Mr. Gardner, I am making a finding that you violated the condition of absconder based on state's exhibits B, C, and G. On charge number 2, although the court did not lay that case, it doesn't negate that the behavior occurs. I'm also making a finding that you violated the condition of obedience to the law based on the evidence presented in state's exhibits B, C, and L. On charge number 3, the condition of drugs, I'm also making a finding that you violated that condition based on state's exhibits B, C, E, and F. And on charge number 4, I found that you violated the condition of halfway house placement based on the evidence presented in state's exhibits B, C, D, and G. So that does conclude the fact-finding portion of this hearing. Before I make my recommendation, the state will have an opportunity to speak to your background and history. And after the state is finished, you will have the same opportunity. The purpose of this part of the revocation hearing is to help determine what outcome I recommend. So Officer Grant, would you like to make any comments towards Mr. Gardner's background and history, please, at this time?
Yes. So Gardner it initially was discharged to special parole and on 7/18/2019 and went to Chase Halfway House. He then transferred from the halfway house to the community. Within that supervision period, he received 16 misconducts, mostly for positive drug screenings and GPS violations. He subsequently received a 3-month sanction from BOPP when he was remanded then. Being that he walked out of Chase Center Halfway House on April 1st of 2025 and admitted to using drugs, and which placed him at a high risk of overdosing and failure to contact parole to make his location known, and also failure to return back to parole supervision. I'm requesting that his special parole be revoked for a minimum of a year, with hopes that when he returns to the community, that he continues with mental health treatment, no alcohol consumption, a substance abuse treatment program, and halfway house placement if he does not have a viable sponsor.
Thank you. Counsel?
Yes, on behalf of Mr. Client, if I may address Appeal Grant's comments, I'm not disputing what she put on the record, but she previously indicated she did not start supervising my client up until this incident here. He was sanctioned to the 3 months on his previous violation. I'm not disputing that. But after that, after he was sanctioned and after he was re-paroled, he, on January 18th of 2024, which is prior to Appeal Grant supervising my client, he was transferred to the App Foundation for Inpatient Substance Abuse. And it appears, this is from the narrative that the parole officer wrote, on 2/16, he was successfully discharged from the App Foundation to the Chase Center. So he did address his issues and he did do some treatment. My client is 51 years old. He does have 3 children. He has his children, all adult children. Unfortunately, one of his sons was actually murdered in Hartford on September 14th of 2022. And while on supervision, Mr. Gardner was placed in a hotel for a period of time because the building he was living in caught on fire. So he's had some things in his life. I'm not making excuses for him. He's 51 years old. He does need to get the substance abuse issue under control, but he's on supervision until 2028. Upon his previous release, it looks like October to January, he was at the Connecticut Renaissance Halfway House in Waterbury, where he did successfully complete the App Foundation. As I indicated, then he was at the Community Solutions Halfway House in Waterbury. And then he did self-sponsor in Waterbury, as I indicated. Unfortunately, that building he was living in caught fire and he was placed in a hotel. He did graduate from high school. He's indicated to us in 2007. He did complete some sociology courses while incarcerated at Chester Correctional Institution in sociology, and also obtained various certifications from the American Job Center. Those certificates that we submitted are all dated 2024 and 2025. So they are recent certificates that Mr. Gardner was involved in numerous programs to try to increase his work background. So he has been doing numerous things, and I indicated I don't need to read all of those, but we did submit them all. He did provide them to us. He was working full-time at Global Steering, as he indicated, for approximately 2 months prior to his remand. It was a full-time job, as he indicated, and previously he did utilize Steadfast Staffing Solutions in Waterbury, and he was placed at numerous job sites around the state. Also, upon his release, it looks like in 2019, he did voluntarily attend individual therapy with Ms. Realbo, initially virtually and then via video due to the COVID-19. He did participate in a domestic violence program, did receive clinical services from Wellmore in Waterbury, and needed IOP at Connecticut Renaissance. So my client has been engaged in treatment, not disputing it. He self-admitted that he did relapse March 31st / April 1st. He is amenable. He does want to be put in a halfway house in Waterbury. I know P.O. Grant had indicated that also, unless he had a Bible sponsor, he did not provide one to us. So he's looking for a halfway house in Waterbury. And some point down the road, after he's in compliance with that, he'd like to obtain an independent residence, as he previously had indicated to us. He can return to his job at American Job Center in Waterbury. And he does want to complete requirements to become a recovery coach through Connecticut Community Addiction Recovery, CCAR. And he's amenable to any opportunities in the community, whether it's to do a treatment and or work related. He did obtain his driver's permit. He's indicated to us this first time he's had it. And he does want to obtain his active driver's license. Mr. Gardner, anything I left out about your background or what you want to do when you get out? If you want to add anything, it's not your opportunity. You can't discuss the first part of the hearings as to what you were violated for. Just about your background. Is there anything you want to add?
Yeah, I know I just thought I'd go out there get back right what I was doing, you know, and I was going through a hard time, you know, for a couple of years. So now I really cleared up a little bit. I was out. It felt like I was free from the 5 months because I was stressed out in 26 years, and I've been in halfway house for 4 years, and I was in the Chase Center before 2 years, and then they brought me back over there. Like, and see, I've been getting stuck in Chase Center. Anywhere else, I'm straight. You know what I'm saying? I can't really get a good job because I ain't gonna be able to be obligated to it because I'm gonna be missing days, you know, in the halfway house. You know, as long as if everything on the same page, everything working together, I could stay working and get my money saved up and get an apartment and get back where I was at, you know?
Thank you for coming.
Thank you. I appreciate your comment, Mr. Gardner. Any additional comments from either side?
I don't have anything else to add.
Officer Grant, any additional comments?
No.
Okay, thank you. So I'll just take a moment and announce my recommendation. Okay, so I have listened to all the testimony today. I've reviewed all the evidence presented with that. I do want to note a few things on the record. This is Mr. Gardner's second violation of special parole, as stated, and he did receive a 3-month sanction for that last one. However, he appeared to be in the community for approximately 1.5 years in between his re-release and remand. With that, the evidence does state that he had perfect attendance at his job, so he was doing, I think it sounds pretty well, leading up to the day he left the halfway house, unfortunately. And I did review all of the training certificates. So I'm impressed. You did a lot in the community, Mr. Gardner. However, you were gone and unaccounted for about 6 months. So that's just a little bit concerning. But with all those all that information, I am going to recommend your parole be revoked, Mr. Gardner, and that you serve an approximate 4-month period of confinement as a sanction. That's with the re-parole date of January 25th, 2026. I'm going to recommend this following conditions: no consumption of alcoholic beverages, behavioral management program for domestic violence, no contact with co-defendant Hassan Allen, mental health evaluation and treatment as deemed necessary, and a halfway house placement in Waterbury. So what happens next, Mr. Gardner, is my recommendation is going to go to the board next week on the 18th. On that date, the board can do a few things. That they can lessen my recommendation if they choose to do so. They can adopt it if they want to. And if for any reason they would want to see a period of confinement longer than what I'm recommending, they'll ask you to come back for another hearing to address their questions and concerns, but for anything longer is imposed. Do you have any questions right now, Mr. Gardner?
No, not right now.
Okay.
All right, so Mr. Garner, it's going to the board on the 18th. You and I will get a written report, and I believe the parole officer also about a week later with the final outcome. If they adopt the recommendation, January 25th of 26 is your release date. If they want to give you additional time with another hearing, if there's an issue with them not adopting it, I'll set up a legal call with you and I'll go over the next step with you if I need to, okay?
Okay, sir.
All right, good luck to you.
Thank you.
Thank you for your time.
This concludes the revocation hearing for Jimmy Gardner, inmate number 200386. Thank you. Good luck to you, Mr. Gardner.
Thank you. Bless. Sure.
You're all set. Take care.
You too now.
He has to go to lieutenant's office.
Thank you. We need Officer Bennick. Officer Bennick, are you with us?
I'm here.
Thank you. And just, I did see you, Officer Barrios, just to put it out there, we're running behind. We had a whole internet outage, so we're way behind at this point, unfortunately. Not way behind. We'll get to you soon, hopefully. Okay, Officer Barrios, we're gonna try to catch up, even though it won't happen, but we're gonna try. You hear? Good. All right, we're gonna get started. Okay, Mr. Brown?
Is my lawyer here?
He is.
Right here.
You see him?
I see him. All right.
All right, we're gonna get started. So good morning, I'm Parole Officer Tricello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Kenneth Brown, inmate number 326008. Today is Thursday, November 11th, 2025, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office and Cheshire Correctional Institution. Can you please state your full name and DOC inmate number for the record?
My name is Kenneth Brown, inmate number 326008.
Thank you. So this is a public hearing and public access to this hearing is available via video live stream. Present this morning is your attorney. Can you please identify yourself?
Sure. Attorney Alfonso Sorico with the Parole Revocation Unit on behalf of Mr. Brown.
Thank you. And also present is your charging officer. Can you please identify yourself for the record?
Sure, Parole Officer Bethany Bennick with the Mental Health Unit for Parole and Community Services.
Thank you. So this is a preliminary hearing which has three purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there's probable cause to believe that you violated one or more of the conditions of your parole. If I do not find probable cause, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Brown, can you please raise your right hand, and Officer Bennick as well? Thank you. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the full truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes.
Thank you. Yeah,
Yes.
just perfect. Thanks. So we're going to go over the procedure for today's hearing. So first, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state will then have an opportunity to address the issue of probable cause and the severity of the allegations. And after the state is finished, you will have the same opportunity. At the conclusion of this hearing, I will inform you of my findings, which will be based upon the available evidence. Do you have any questions about the purpose or procedure before we begin?
Yes, actually I do.
Okay.
I have I filed a suit against her, against my parole officer. And I don't even honestly, I was told that she wasn't supposed to be here. Somebody else was supposed to be taking her place. I have a pre-allegation against her. And I also have a theft case against her. So I'm not understanding why she's here. Shouldn't I have somebody else present?
Theo Trusello, I can speak to that if you want the response to that.
Sure.
Okay, I did contact the PREA unit and spoke with the captain. He said because this is in the scope of my normal jobs and what we would normally doing, I am permitted to participate in this hearing. As far as the suit with the property, I have no idea what he's talking about.
So Kenneth, as I advise you regarding the theft issue, that's something that needs to be taken care of after this hearing is resolved. But this is not part of this violation. I did advise you of that via telephone. And as far as what the other claims, she just put on the record, she was advised she can be here. If you want to do something about it after the hearing, you can. It's not part of this course of what I'm representing you on here for these alleged violations. Do you understand that?
All right.
Okay, thank you, P.O. Bennett, for clarifying that.
Thank you as well. So with that, we are going to keep moving forward with today's hearing as planned and scheduled, okay? So we're going to go over your rights now, Mr. Brown. So you do have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes, I did.
Perfect. You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand all these rights, and are you ready to move forward?
Yes, I understand.
Perfect. We are going to now review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. Officer Bennett, can you please review the charges that you have brought against Mr. Brown?
Yep. On 10/21/25, you were unsuccessfully discharged and formally banned from the Connecticut Community for Addiction Recovery Program. On 10/20/25, you assaulted another resident at Walter Brooks Halfway House. You intentionally punched the resident as well as used a chair and milk cartons as weapons, thereby recklessly creating a risk. These behaviors meet the criteria for Connecticut General Statute 53A-182 disorderly conduct. On 9/16/25, you rendered a urine specimen that was positive for phencyclidine. This specimen was sent to Redwood Toxicology Labs and returned as confirmed positive on 10/1/25. On 9/1/25, you rendered a urine specimen that was positive for THC and amphetamines. The sample was confirmed by Redwood Toxicology Labs and returned positive for THC and amphetamines on 9/10/25. On 5/8/25, you rendered a urine specimen that was positive for cocaine. The specimen was sent to Redwood Toxicology Labs and returned as confirmed positive on 5/13/25. On 10/21/25, you refused to allow your parole officer to search your phone, which was under your possession, by refusing to give her your unlock code as instructed. On 10/20/25, you assaulted another resident at Walter Brooks Halfway House. You punched the resident as well as used a chair and milk cartons as weapons. This is in violation of your signed Halfway House agreement. Specifically, I will treat others with respect and not engage in verbal or physical altercations with other offenders, staff, or third parties. On 10/19/25, you sent the program director of Walter Brooks Halfway House a harassing, vulgar, and racist text message. This is in violation of your signed Halfway House agreement. Specifically, I will treat others with respect and not engage in verbal or physical altercations with other offenders, staff, or third parties. On 9/1/25, you told Walter Brooks Halfway House that you were going to CCAR and left the house from 10 a.m. until returning at 5 p.m. When the staff called to confirm this, they learned that CCAR was closed that day, leaving you unaccounted for in the community for approximately 7 hours. This is in violation of your signed Halfway House agreement. Specifically, I will not leave the physical confines of the Halfway House unless authorized by the program staff. I will only go to locations indicated on an approved community pass unless changes have been authorized by staff. On 4/8/25, at 4:25, you requested a community pass to attend a dental appointment. When staff called to confirm the appointment, the dental group denied having any appointments for you, nor did they accept your insurance. This is in violation of your signed Halfway House agreement. Specifically, I will not leave the physical confines of the Halfway House unless authorized by the program staff or parole. I will only go to locations indicated on an approved community pass unless changes have been authorized by staff.
Thank you. And you've also submitted evidence in support of the case. Can you please identify the evidence for us?
Yep, let me just. Okay. Exhibit A, signed conditions of parole. Exhibit B, remand to actual custody order. Exhibit C, signed notice of parole violation with rights. Exhibit D, parole violation report. Exhibit E, email from Walter Brooks, House Program Director, Parks, forwarded discharge from CCAR, email dated 10/21/25. Incident report from Walter Brooks dated 10/20/25. Email from Walter Brooks, House Program Director, Parks, dated 10/20/25.
Can you
Video
just
footage
state the
from
exhibit? Sorry, can you just state the
Yep.
letter though? Like the H?
Oh,
Yeah,
I'm sorry.
and
Which
then-
one was it?
Well, you skipped a few, so let's just start where
Oh,
you
I'm
were
not
at.
seeing
So
my
let's
letter.
go with Exhibit I. It's okay. Exhibit I, residential discipline report.
Okay,
I think
Exhibit
we were
I,
there, right,
residential
Council?
discipline reports
Okay.
×5. Exhibit J, voluntary admission of positive drug test result for prohibited substance ×2. Exhibit K, Redwood Toxicology Labs reports ×3. Exhibit L, State of Connecticut PCS offender misconduct reports ×4. Exhibit M, photo of assaulted offender. Exhibit N, signed halfway house agreement. Exhibit O, State of Connecticut BOPP revocation hearing summary dated 1/21/25. Exhibit P, State of Connecticut BOPP preliminary hearing summary dated 1/9/24. Exhibit Q, CT state statute for disorderly conduct. Exhibit R, CT state police report for case number 2500373213. Please note PCS has requested police report but has not yet received it. By the filing of this violation, report will be included as an addendum if needed.
Thank you. So I do want to note a few things on the record. So Exhibit J, I'm going to modify it to state 3 voluntary admissions. I did receive 3 and not 2. As well as Exhibit L, it's going to state 2 misconduct reports. I did not receive, I don't know what that number was, 3, 4. Yeah, I only received 2. As well as I did not receive Exhibit H. And I did not receive Exhibit R, so those 2 documents will not be admitted into evidence for today.
I wanted to clarify, I was going to beat me to it. Exhibit H, which is the video footage from the Walter Brooks.
No,
You
I
don't
didn't
have that.
receive
Okay,
it.
I don't have that.
Admitting that, and I did not receive R as well, so
Okay.
we will not be
No, I
admitting
wasn't
that.
able to get it in time, so it was.
Yeah, no
kind of a little
problem. So
nutty.
we're just not going to admit them for today's hearing. Council just confirmed you did receive the parole violation.
Yes, I have everything else, but those 2, yes.
Perfect. I did not receive any exhibits from the defense at this time. Oh, wait, I'm sorry. Let's go back. Officer Bennett, you did submit an addendum, correct?
Oh, you know what? I think I read an older list of evidence.
That's okay. We have
I'm
everything
sorry,
that
that's
you
probably why
said.
it's confusing because the police
No.
report was included. Okay, sorry about that.
No, you're okay. We're all on the same page with that, but you did submit an addendum. Do you have that in front of you to read for us to?
I can get it.
Thank you.
Sorry, you want the addendum from the tickets?
Yes, please. Can you please read that for us? Actually, you know what? I'm gonna hold off on that because when did you receive? Was that after the 7 days?
The addendum
Yeah.
or the
Was it
actual
after-
behavior?
Let
The
me,
behavior
let me
was
just
on the day of his
because,
remand.
no, the addendum, if it was submitted after the 7 days, this is a preliminary hearing. It's just, it was pending a while. I just want to see what the date it came in, because if it was after the 7 days, it won't be reviewed at this point.
It was after the 7 days, the addendum. that
It
I
was, all right,
submitted.
so we're gonna actually skip that part. Council understood, exact was sent after the 7 days, so we're not gonna move forward with that information. Is that okay?
Yes, the addendum.
The addendum.
Okay, Mr. Brown, the addendum we spoke about regarding the 2 incidents is after the 7 days. That's not going to be discussed today. Okay, so
Well,
don't,
it's not gonna be the addendum submitted if it's
Correct.
brought up in testimony for
Correct.
today.
I'm not going to comment on that. Thank you.
Thank you. So we're not gonna, we're not gonna review that at this point. Now it is, we don't have witnesses at this time. I don't have anything from the defense at this time. Council, do you need to make time to submit any?
No, not at this point, not for the preliminary here.
Okay, thank you. So, it is now the state's opportunity to make a short statement, call any witnesses, and testify with respect to probable cause and the severity of the allegations. So Officer Fennick, would you like to make a statement?
I just wanted to point out, although Mr. Brown wasn't formally charged, that doesn't mean that the behavior didn't occur. And that's all.
I didn't do anything to anybody.
Kenneth, it's not your turn right now. Hold on. I just told you we have to do this.
Yes, sir.
today?
Pardon me,
All right.
ma'am.
That's all I have.
Thank you. And counsel?
Yes, just briefly, this is only a preliminary hearing, if I may. Theo Bennett, I understand what you're saying under charge number 2, under obedience to the law. The PCS and the board has a different standard in criminal court, obviously. Although it meets the conduct of the disorderly conduct as to what allegedly occurred, and obviously Exhibit H, I don't have the video footage. As far as you know, as of today, December 11th, there has been no formal, because I believe it, one of your documents indicated that you have confirmed that there were warrants coming, correct?
I believed that they were at the time. I have not seen any been signed.
Okay, and as of today, December 11th, you're not aware of any warrants being served on Mr. Brown as of today for the disorderly or for the alleged, there were some photos of some type or a text. Is that correct?
Correct. As of today, no.
All right. All right.
As far as I know.
Correct. And you did speak to my investigator at some point in the month of November, and he inquired regarding any potential warrants, or if you knew of any warrants that were forthcoming. And I believe, I don't want to put words in your mouth, but you did tell him there was nothing at this time, correct?
Correct.
Okay. And I also want to add, my investigator also reached out to the state police, and they wouldn't give us any information on warrant situation, but we've tried every avenue to see if there were any forthcoming warrants, with the understanding of how the board and PCS treats in obedience to the law charge. When there is no warrant in hand, we go forward now as we are now on a technical violation, and then if a warrant pops up down the road, it's the same facts, same day, same incident, and there's a criminal charge for that. I just want to make that part of the record. And Mr. Brown, I do not want you to comment. I'm just going to put some statements on the record. Under charge number 2, my client does admit there was a verbal dispute with the other individual. I understand some with the evidence that was presented, but I don't have the video to kind of see exactly what happened. But I did speak to my client, and my client's position is there was a verbal argument. He's not disputing that. And once again, I understand we use a different standard here, especially for a preliminary hearing. Charge 3 under the drugs, my client does admit that. He does have a substance abuse issue. He's not trying to hide that from anyone. Mr. Brown, briefly, regarding charge number 4, the issue with the telephone, your cell phone, and the search. Could you let the hearing examiner know if you recall what occurred that day? And we're not talking about the claim you made with the state police. I'm talking about what occurred on October 21st. That's all you can speak about at this hearing, okay? Regarding the search. Go ahead.
On that day, I called Mrs. Bennett. I said, Miss Bennett, listen, I'm having issues down here at this halfway house. I need help. You know, I don't want to get jammed up. I'm not trying to go back to jail. I said, listen, you know, I've been doing treatment. I've been going to the app. I haven't since I've been going to the app, I haven't had any dirty urines or anything. So she told me, she said, all right, Brown, just come on down to my office. We'll talk about it. We'll try to get you into a different place. So this way you won't get jammed up. You won't be in jail. I said, all right, well, that's fine. And the program director, he ended up getting fired for whatever reason. So he brought me down there. I'm thinking, all right, you know, she's gonna help me. This is the main reason why I called and asked for that help from her, so I wouldn't get jammed up. See, they brought me down there to her office. I go to her office. She says to me, "Hi, what's up, Brown? Hey, what's up, my favorite troublemaker?" I'm like, what are you talking about? So they call me in. They call me to the back. Next thing I know, I'm in handcuffs. She put me in cuffs. I said, yo, hey, what's going on? What is this? I called, I asked you for help. If I would have known this, I wouldn't even have called. I wouldn't even have asked for your help. They take my phone. She takes my phone. She says, "Oh, what are you doing with the phone? Blah, 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 blah." I said, "I'm not doing nothing with the phone." She says, "What's the code?" I said, "I can't give you the code. You have to hit with my thumb. There's a thumb code with my fingers." Next thing I know, I'm in jail, miss. I've been, and ever since then, I've been in here ever since.
All right, Ken, that's all I need you to say on that. My last question to you is regarding the April 8th incident with the dental appointment. I know it's just a technical and it's relatively minor in my opinion, but it's still one of the bases that you got charged with under halfway house placement. Did you go to a dental appointment on April 8th of 2025?
Yes, I did. And when I went, they told me that they do not accept my insurance. They said that due to the fact that I have Husky D insurance, I cannot and I will not be seen.
Okay, thank you. I don't have any other comments. I said this is a preliminary hearing, so kind of limited to what I can add, but I just wanted to put those things on the record. Thank you.
Officer Bennett, any additional comments?
Yes, I told him to report to the office, which is typically what we want to do if we want to have a remand that is safe for officers and public safety. He did not say he needed the thumbprint for the code. I said, "What is your code? Because I'm going to search your phone." And he said, "Nope." What else? He had positive urine since apt. I don't know where he's coming off. I don't know where that's coming from. And as far as the April 8th, I know you said it's little, but he did not have an appointment. He filled out a pass saying he had an appointment, but he did not have one. So it just shows to what he does, like his intentionally trying to get out into the community without permission and doing things that he's not supposed to be doing.
Yeah, don't say anything else, please.
So both sides are
Yes.
no additional comments. So we'll just take a moment. You're okay until I announce for me to announce that. Thanks. So I have listened to all the testimony today. I've also reviewed all the evidence, Mr. Brown. I'm going to announce my findings now. So with charge number 1, the condition of program participation, I'm making a no finding of probable cause. Based on the information reviewed, the state failed to submit sufficient evidence in support of that charge and the elements were not met. On charge number 2, the condition of obedience to the law, I am making a finding of probable cause based on the evidence submitted in states exhibits A, D, F, G, and Q. On charge number 3, the condition of drugs, I'm making a finding of probable cause based on the admission in today's hearing, as well as in states exhibits A, D, I, J, and K. On charge number 4, the condition of search, I'm going to make a finding of probable cause based on the testimony presented at today's hearing. Second. On charge number 5, the condition of halfway house placement, I am going to make a finding of probable cause based on the evidence presented in states exhibits A, D, F, G, I, L, and N. With that, Mr. Brown, I'm also finding that the acts are serious enough to warrant revocation, and I've also determined that you should be detained while you await that revocation hearing. So the facility records office will be notified of that. Officer Bennett is now aware of it. So what happens next, Mr. Brown, is that your revocation hearing will be scheduled within 60 business days of your remand to custody. At that hearing, myself or another hearing examiner will determine if you violated the conditions of your parole. And if so, they will make a recommendation regarding whether your parole should be revoked and what, if any, sanctions should be imposed. So that does conclude today's hearing. Any questions?
No, okay, once I get the date, I'll set up another call with you and go over what step 2 looks like, okay?
I have a question, man. I want to say this. I was working and I had a job. Then I worked at LAZ last and I worked at Cube Group. And then they're saying that they don't even have a warrant for this so-called assault. Why am I in jail? I don't even.
Kenneth, hold on. The background information, as I explained to you, that comes in if there's gonna be a second hearing, which there is. That comes in at that part. It's not for today, and I told you that a couple of times. And regarding that warrant, I put some things on the record, and once we get to the revocation on these charges, we'll see what comes of that, if anything, and I'll make those same arguments again, okay? Just gotta wait for that date, and as of right now, on this violation, your hearing is gonna be scheduled within 60 business days as of right now, because there are no cases pending in any court in Connecticut. Okay, I'll set up another call with you as soon as I get the date.
Theo
So if there's
Trusello,
no
can I ask a
cases-
question?
If there's no cases pending,
Because as I put on the record, it's a different standard at a preliminary hearing with the Board of Pardons and Parole than it is in court. This is an administrative hearing. It's not a criminal proceeding. I explained that to you.
Thank you, Mr. Brown.
Just hang tight.
Yeah.
Can I ask a question as far as the no finding on the program participation?
No, we cannot go through that now. Sorry, Officer Bennett.
I'll do that at the revocation hearing.
Well, I have a lot more hearings to get to, but my decisions are final with that. Yeah, it'll
Okay.
be up in the summary. If you have any additional questions, you can call my supervisor for that stuff, okay?
Okay, thank you.
All right, thank you.
All right, Kenneth, I'll talk to you
We'll see you
soon.
soon, Mr. Brown. This concludes the preliminary hearing for Kenneth Brown, inmate number 32600.
Thank you, Gil Bennett.
Thank you, Council NPO Bennett.
Thank you.
See you soon, Mr. Brown.
all right. Take care.
Alan, I just want to go.
Hi.
Hi, Officer Barris. We're gonna try.
Hi, it's Maribel.
Hi,
It's
we're gonna,
Barrios.
yeah, we're trying to connect to Hartford now. We'll get them going soon, hopefully. Alan, I just tried to contact Hartford and it says that they're offline. Do you see that as well?
Mhm. So we don't know if we're gonna see the hearing?
We don't know what's gonna happen. Just hang tight with us, Marius. We'll hopefully figure it out sooner than later.
Okay, perfect. Thank you.
Do you see that it's offline? Okay, Officer Barry, so we just contacted Hartford and they said that because it's 12 o'clock, they will not have him down for us because it count time. They asked us to do it at 1, so we're gonna try to hear him at 1 o'clock. I'm running still behind though, but we're gonna attempt to get to Hartford at 1. If you can still.
Okay, I'll try to be available, okay? Because I had some other stuff scheduled for that time. So
Okay.
I'll try to see if I can rearrange my schedule, okay, and be online for 1.
Okay, sounds good. I mean, if you do want to be present, we can see what happens around that time. If you're not able to make it, we'll see if we can try to work something else out. But let me know, okay?
Yeah, absolutely. If I'm on, I'll switch into the to the hearing. Can I disconnect now and come back in at 1?
You can, whatever works best for you. If you wanted to just turn your camera off and mute it, whatever works best for you.
Okay, thank you.
Thank you. I appreciate it.
Yeah, bye-bye.
I'm on the phone with Corrigan right now with a captain. And we're trying to get Corrigan connected.
Perfect. Thank you. Alan was just over there trying to call as well. But I guess just keep us posted.
Yes, I'm on the phone with Captain Ashkinson.
But
I can't tell. Are we trying to dial into them in here in Teams or not yet?
I've tried about 3 times.
I could do it on my end. I just don't want to do it if you're doing it.
No, well, you can do it at the same time distances, but yeah, I'll try one.
Yes.
They're on it right now. They're working on it.
Okay, so we're calling in and
Yeah, call in.
and they'll just answer. Okay, thank you.
Yep, bye.
Didn't pick up my call. Thank you. Good morning, afternoon. Good afternoon.
Hey, we made it. Who do you want first?
Mr. Contois? Did I say
Contois.
Contois? Yeah, thank you.
Constance, you can come in, brother.
Officer DeBather, I do see that you logged in with us. I just want to let you know we're running very behind at this point. We're only in Corrigan. So just.
Okay.
Yes, all right, thank you.
Any estimated time or?
I have nothing for you. I'm sorry.
Okay, no worries.
Yeah.
I'll talk to you later.
All right, thanks. Good afternoon, Mr. Contois. We're gonna get started, okay?
Yes, ma'am.
So good afternoon, I'm Parole Officer Trusello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Robert Contois, inmate number 235386. Today is Thursday, December 11, 2025, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office in Corrigan Correctional Center. Can you please state your full name and DOC inmate number for the record?
Robert J. Contois III, 122673, and inmate numbers 235386.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is this afternoon is your attorney. Can you please identify yourself for the record?
Good morning, Peter Matthews with the Public Defender's Office, Mr. Contois.
Thank you. So this is a preliminary hearing which has three purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there's probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. Mr. Contois, can you please raise your right hand? You solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury.
I do.
Thank you. So we're going to go over the procedure for today. So first, I'm going to read your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits filed for the record. The state will then, the state's not present. Sorry. Let's start again. The state is not present at today's proceedings. However, you will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I'll inform you my findings, which will be based upon the available evidence. Do you have any questions about the purpose or procedure before we begin?
No.
So you have important rights, and we're going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
I believe so.
Yes. It would have been on November 25th you signed for it, it looks like. Does that sound about right?
Yeah.
Okay. You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
All right, we're going to review the charges the charge that the state, your parole officers bring against you, and the information underlying that charge. So on charge number 1, the condition of obedience to the law, the charging officer reported that on 11/22/25 at approximately 17:31 hours, Troop D responded to a domestic disturbance in Brooklyn, Connecticut. Troopers conducted an investigation and determined that you were the primary aggressor in a disturbance and pushed the victim. Based on your actions, you were arrested by Troop D and charged with Connecticut General Statute 53A-182, disorderly conduct. This is evidenced by Exhibit B. The state has filed the following exhibits that have been marked for identification purposes as Exhibit A, the signed conditions of release, Exhibit B, the remand into custody, Exhibit C, the parole violation report, Exhibit D, the notice of parole violation / parolee rights, and Exhibit E, the state of Connecticut criminal information summary. Counsel, did you and your client receive the notice of parole violation, the parole violation report, and all the other documents identified for today?
Yes, we did.
Thank you. I did not receive any exhibits from the defense at this time. Do you need any time to submit anything, counsel?
I do not, no.
We do not have any witnesses, so now it is the defense's opportunity to respond, make a short statement, call any witnesses, and testify with respect to probable cause and the severity of the allegations. So, counsel?
Thank you. So the sole basis for the violation is that disorderly conduct arrest on November 22nd. I did take a look at the evidence, and I don't think the very brief statement provided in Exhibit E that Mr. Contoy had pushed someone is sufficient to establish probable cause. There's no statements, there's no details about what happened. The police report is insufficient to establish the most basic details about this incident. I will also note he received a non-surety bond. So I don't know for sure whether it can be established that there was a probable cause finding in court. If there's no bond, it's not necessary for a court to make a probable cause finding. And I have no evidence either way as to whether one was made here or not. So I don't think there's any evidence here that can be presented to show that there was a probable cause finding by a judicial body that they can rely upon when making a probable cause finding here. If there is a finding, maybe with regard to this charge, I would say that the incident is not serious enough to warrant revocation. He's been on parole since 2022. There's no noted prior misconducts. This appears to have been a very minor incident where he was released on a non-surety bond. He is certainly willing to continue working with parole going forward, and I would ask for him to have the opportunity to do that. Thank you.
Thank you. And announce my finding. So on the charge of obedience to the law, Mr. Contoy, I am making a finding of probable cause based on the evidence presented in states exhibits A, C, and D. With that, I'm also finding that the act is serious enough to warrant revocation, and I've also determined that you should be detained while you wait for your revocation hearing. So the records office at the facility is going to be made aware of that, as well as your parole officer. So what happens next is that once that case is disposed of in court, we'll be notified of that and bring you back in for a revocation hearing. And at that revocation hearing, myself or another hearing examiner will determine if you did violate the condition of your parole. If so, that hearing examiner will make a recommendation regarding whether your parole should be revoked and what, if any, sanctions should be imposed. So that does conclude today's hearing. Any questions, counsel?
So, Mr. Contoy, once you resolve that case, then we'll get the hearing scheduled, okay?
Okay, my thing is that I have a witness who is there. The only thing is.
Don't put it on the record now about what happened, okay? You gotta deal with that in court, okay?
Oh, okay.
All right. Thank you.
Once that's concluded, we'll bring you back in for the revocation process, okay? For a hearing, okay? Thank you, Mr. Contoy. So this concludes the preliminary hearing for Robert Contoy, inmate number 235386. All right. Hopefully we'll see you soon, okay?
Yes.
Great. Thank you, counsel. Attorney Dean, I'm just checking that you're with us. Hi.
Yes, good morning, or sorry, good afternoon, I should say.
It's afternoon. Hi, are you Mr. Maniz?
Yeah, sorry my appearance. They just ain't gave me no razors in here. They're just short-handed on razors, so I'm sorry.
Oh, no worries. No need to apologize, okay? We're gonna get started though, if that's okay.
Yes.
All right. So, good afternoon. My name is Parole Officer. I'm just making sure no one should be here. Yeah. My name is Parole Officer Trisell, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning John Maniz, inmate number 1899917. Today is Thursday, December 11th.
It's 1899919.
That's what I have written, and I didn't say that at all. I said 7, right? I said 7 like 3 times. All right, I'm going to try again. Okay. So this is a preliminary hearing concerning John. I'm sorry also. This is a preliminary hearing concerning John Maniz, inmate number 189919.
Correct.
Yeah. That's what's in front of me too. That's scary. Okay, so today is Thursday, December 11th, 2025. And this hearing is being conducted via video at the Board of Pardons and Parole Central Office and Corrigan Correctional Center. Can you please state your full name, DOC, inmate number for the record?
John Michael Moniz, my inmate number is 189919. My birthday's 2/4/1964.
No birthdays, but thank you. I appreciate that.
All right.
So this is a public hearing and public access to this hearing is available via video live stream. President, this afternoon is your attorney. Can you please identify yourself for the record?
Yes, Hannah Dean on behalf of Mr. Moniz. Good morning, or sorry, good afternoon, everyone, I should say. Sorry.
Thank you. No, that's okay. So this is a preliminary hearing, which has three purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there's probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Moniz, can you please raise your right hand? Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. So we're going to go over the procedure for today. So first, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my finding, which will be based upon the available evidence. Do you have any questions about the purpose or procedure before we begin?
No.
So do you have important rights, and we're going to review them now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes.
You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
So we're now going to review the charges that the state your parole officer is bringing against you and the information underlying each charge. So on charge number one, the condition of obedience to the law, the charging officer reported that on November 22nd, 2025, you, Mr. Moniz, were arrested by the New London Police Department and subsequently charged under Connecticut General Statute 14-227A, operating a motor vehicle under the influence of drugs and or alcohol. You were taken into custody, and while at London Police Department, you submitted a breathalyzer at 2 different times to officers at the 0229 hours. Your first breath sample was 0.0693, and at 0249 hours, your second breath sample was 0.0621. On charge number two, the condition of no consumption of alcoholic beverages, the charging officer reported that on November 22nd, 2025, you, Mr. Moniz, were arrested and charged by the New London Police Department under Connecticut General Statute 14-227A, driving under the influence. On May 23rd, 2019, you reviewed, initialed, and signed your statement of understanding and agreement conditions of parole with your supervising parole officer under the section listed of additional conditions set at hearing. Alcohol beverage consumption was reviewed. This condition specifically states throughout your period of parole, you're prohibited from the consumption of alcoholic beverages. You are required to submit random toxicology screens to monitor compliance. The state has filed the following exhibits that have been identified for today's purposes as Exhibit A, the remand to custody order, Exhibit B, the parole conditions, Exhibit C, the notice of parole violation, Exhibit D, the parole violation report, and Exhibit E, the New London Police Report 2500029722. Counsel, did you and your client receive a notice of parole violation, the parole violation report, and all the other documents identified for today?
Yes, we have.
Thank you. I did not receive any exhibits from the defense at this time. Do you need time to submit any documents?
Not at this point. Thank you very much.
So we do not have any witnesses, so it is now the defense's opportunity to respond, make a short statement, call any witnesses, and testify with respect to probable cause and the severity of the allegations. So counsel?
Yes, thank you very much. Nothing as to the charges themselves, but I did just want to put a few things on the record concerning the seriousness. My client has been on supervision since 2019 without issue. He had been doing very well in the community, so well that he had dropped down to annual reporting. My understanding is that he had no misconducts or sanctions while in the community, and he was doing a number of positive things. He reports that he'd been working full-time at CWPM in New London since he was released in October of 2019. He works there as an operator and loader, where I believe he works with heavy machinery. At that job, he found a very positive community in his supervisor, who has been a very positive support in his life. The two of them have attended 12-step meetings in the community. My client also reports attending Yale Health in New London for individual therapy. Since his remand, my client's been doing religious services, which he finds to be helpful, and he has not gotten any sort of tickets since that remand. While in the community, my client had self-sponsored his own private apartment, and right now, his biggest concern is losing his housing. If he is not able to get back into the community within the next couple of months, he will, unfortunately lose his housing. He doesn't have, the savings to sustain the apartment for that long. But I know it was quite, a process getting that housing. So that I believe is, a very big worry for him. However, he is someone who I think has shown that he is very amenable to parole supervision and does well on that type of supervision. Mr. Moniz, is there anything I left out about, your background and then the seriousness that you wish to say? I would just ask that you don't say anything about the pending case in court right now.
No, I do a lot of positive things for my mom and my sister. I get the medication for my mom. I do everything I can for family, friends. At work, I'm a chief. I'm the floor manager. I treat everybody equal eyes. Even I don't know. I've been doing good. I've been doing good. My boss right now went to lung surgery right now, and he's in a coma right now. Otherwise, he probably would have came and spoke.
Thank you very much.
I appreciate your statement, Mr. Moniz. I'm just going to take a quick second, then I will announce my findings. So on the charge number 1, the condition of obedience to the law, Mr. Moniz, I am making a finding of probable cause based on the evidence presented in States Exhibits B, D, and E. And on charge number 2, the condition of no consumption of alcoholic beverages, I'm also making a finding of probable cause based on States Exhibits B, D, and E. I'm also finding that the acts are serious enough to warrant a revocation, and I've determined you should be detained while you await that revocation hearing. So we'll notify the records office at the facility as well as your parole officer. So what happens next, Mr. Moniz, is that once that case is concluded in court, we'll be bringing you back for another hearing, a revocation hearing, to determine whether or not you have violated the conditions of your parole. At that hearing, myself or another hearing examiner will make a recommendation regarding whether your parole should be revoked and if any sanctions should be imposed. So at this time, that does conclude the preliminary hearing. Do you have any questions?
Mr. Moniz, I would just say that I will be getting in touch with you and your attorney for the criminal case. And as soon as that resolves, I will let parole know so that we can try and get in for that revocation hearing. I can set up a call with you so that we can kind of debrief everything that happened today. And that way I can answer any questions you might have about the process. Okay?
Yes, thank you.
All right. Thank you. I'll email your counselor to set something up. Thank you.
Thank you.
Thank you. Thank you both. So this does conclude the preliminary hearing for John Moniz, inmate number 189919. All right. Hopefully we'll see you soon. Okay, Mr. Moniz?
Yeah, thank you.
Thank you. Thank you, Attorney Dean.
Thank you.
Alan, so Osborne's not showing that it's offline, but when I hit to call it, it just disconnects. What am I missing? Supervisor, can you try calling Osborne on your end? Because it's not working in the room. Alan's about to go try on his end.
Yes, I could call. Do you want to try McDougal, see if they're waiting for you and go with them?
Yeah.
It's up to you.
Yeah, I will try to do all that. Oh, it's not answering. Hi, good afternoon.
Good afternoon.
All right, I just need to confirm that I have everybody here with us. No, where did she go? Okay, I'm going to, because I don't see Officer Diviler with us. Let me try to call. Oh. Oh, her screen froze. Hold on. Not her screen. I really don't see her.
Hello? Hello?
Can you hear me?
Yes.
Perfect. All right, we're gonna get started. As long as you're available. No, you're good? Everyone's here?
I'm just gonna need a minute, okay?
Yeah, absolutely. Okay, so since we're just waiting for a moment for Officer Divider, I do want to put on the record that the hearing today scheduled at 12:15 for George Figueroa, inmate number 192694, will not be moving forward as his attorney has waived today's proceedings. Thank you. Thank you. We're gonna get started. So good afternoon. I am Parole Officer Chisello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Luis Iazari, inmate number 297854. Today is Thursday, December 11th, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Osborne Correctional, no, we're not at Osborne, we're at McDougal, sorry, McDougal Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Alex Rangel Vasquez, formerly known as Luis Irizarry, inmate number 297854.
Okay, Mr. Vasquez, would you rather be addressed by Mr. Vasquez?
Please.
Okay. Sorry about that. Thank you for clarifying it.
Thank you.
So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is your attorney. This afternoon is your attorney. Can you please identify yourself for the record?
Yes, Hannah Deed on behalf of Mr. Vasquez.
Thank you. And also as your charging officer, can you please identify yourself for the record? You look frozen to me. She look frozen to anyone else?
Yes.
Darn. Let's give it a second, because Osborne just emailed that they were frozen. We were frozen.
That's unfortunate.
It's been a day, yeah.
Really.
See, I'm gonna send her a quick email and see if we can get her back in. Kicked her out and she can't get in. All right, I feel like we could probably hear you. Okay,
There we go.
perfect. All right, we're gonna get through this. I'm just giving myself the encouragement. Glad you guys are here for it. All right, so we were at where you were gonna identify yourself, Officer Diviler.
Officer DeVilder, Hartford Special Management Unit.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I'll review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence, and that is a better way to your evidence must establish that, more probably than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I'll consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to an appropriate sanction. A recommendation will then be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Vasquez and Officer Diviler, can you both please raise your right hand? Thank you. Do you solemnly swear, solemnly, sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
I do.
Officer Diviler, you were muted. Yeah.
I do.
Thank you. So we're going to go over the procedure for today. So first, I'm going to read you your rights. Then we're going to review the parole violation charges that the state your parole officer is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state will then have an opportunity to present all relevant testimony, subject to cross-examination and any relevant documents. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I will announce my findings. And if I find you have violated one or more of the conditions of your parole, the state will have an opportunity to speak towards your background and history. And after the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure before we begin? Mr. Vasquez?
Oh,
No?
no, sorry.
That's okay. So we're going to go over your rights for today. So you do have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive written notice of charges of violation. Did you receive that written notice?
Yes,
Do you also have the right to review the evidence against you before this hearing? You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
yes,
Perfect. So we are now going to review the charges that the state your parole officer is bringing against you and the information underlying the charge. So Officer Divalia, can you please review the charge for us? You're muted again.
I'm sorry about that.
That's okay. Thanks.
So under Obey All Laws, charge number 1, obedience to the law. On 11/25/2024, you sent an email to your parole officer stating, I, Alex Vasquez, formerly known as Luis Irizarry, inmate number 297854, do hereby humbly request today on November 24th, 2024, for an appeal form for my court-ordered parole stipulations. Thank you and have a wonderful day in Southington. Your statement provided reasonable suspicion that you are aware of where your supervising officer lives. On 11/27/2024, your cell phone and electronics were seized for further analysis. You conducted a search and paid for a background check on your officer on the website www.golookup.com. On 1/24/2025, you were remanded to custody for a separate issue and were found to be in possession of an unauthorized tablet. A search conducted of this tablet showed that you were in possession of photos of the parole officer's residence. You also had notes on your supervising officer's personal information to include her maiden name, family members, and their addresses as well. Due to the aforementioned, you are arrested and charged with disorderly conduct, 53A-182, threatening second, violence to terrorize, 53A 62A2A, and harassment second, 53A-183, under that docket number. Your next court date is 9/16/2025.
Thank you. You've also submitted evidence in support of the case. Can you please identify the exhibits for us?
Yes, so the evidence submitted was A, PCS conditions, B, remand to actual custody order, C, parole violation notice, D, parole violation report, E, CSP Troop H, case number 25000352238. And then we also additionally submitted F, which was PO Parole Supervisor Wilkie's letter, G, which was Parole Supervisor Plord's letter, and then H, which was the news article regarding the case.
Thank you. You also did submit addendums to the case as well. So can you please review both of them? The first one was submitted on November 24th, and then the second one on December 9th. So can you please start with the one in November?
I do not have that directly in front of me.
Okay, I have them, so I will say
Okay,
it.
thank you.
No problem. So the first one was submitted on November 24th of 2025, and it states, Irizarry was sentenced under docket ending 799S on 11/12/2025. He was found guilty of threatening second, violence to terrorize, and sentenced to 9 months jail. The charges of harassment second and disorderly conduct were thrown out. The second one that I stated was submitted on 12/9/2025 does state the additional evidence submitted as identified by Officer Divalia, which is exhibits F through H, as well as states that in addition, P.O. Brayfield will be called as a witness at the revocation hearing. Counsel, to confirm you and your client did receive the notice of parole violation, the parole violation report, and all the other documents identified for today?
We have, yes.
Thank you. So I did receive an exhibit from the defense. I have exhibit 1, a list of parole accomplishments and future plans for parole reinstatement. Counsel, do you need time to submit any other documents?
Not at this time. Thank you.
Perfect. So at this time, it is the state's opportunity to call any witnesses. present evidence and speak to any of the evidence submitted. So Officer DeViler, do you wish to call the witness today?
Yes, I would like to call the witness to speak more on the history, background, and recommendation, not the fact-finding portion.
Okay, so then we'll hold off for now. We'll revisit it if it moves on to that portion of the hearing. Makes sense? Good? Okay. Great. And then counsel, so it is also your opportunity, Officer DeViler. Do you have any statements towards the charge?
Yeah, I would just like to mention on September 11th, defense counsel did concede that probable cause existed in the preliminary hearing.
Counsel, it is now your opportunity.
Yes, thank you very much. I would note defense counsel conceded that there was probable cause. Defense counsel didn't concede that there was preponderance of the evidence for the charges, which is the standard at the current hearing. However, I don't have any comments or argument as to the actual charges themselves. I just want to note very briefly that the only conviction that was that one misdemeanor charge noted in the addendum 1 that was read. Thank you.
Thank you. Just gonna take a moment. I'll announce my finding. So on charge number 1, Mr. Iazari, I am finding that he violated the condition of obedience to the law based on that conviction of threatening second on November 12th, 2025, and he received a 9-month jail sentence. In addition, the evidence in support of the charge is states exhibits A, D, and E. So that does conclude the fact-finding portion of today's hearing. Before I make my recommendation, the state will have an opportunity to speak to your background and history, and after the state is finished, you will have the same opportunity. The purpose of this part of the revocation hearing is to help determine what outcome I would recommend. So, Officer DeViler, it is now your opportunity to speak. You would like me to swear the witness in at this time?
Yes, may you please?
So, please raise your right hand. You solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, and not be fraud upon penalty of perjury.
I do.
Thank you. Go ahead, Officer DeViler.
So I'm gonna just ask that Officer Brayfield make a statement in regard to this case.
I started supervising Luis Irizarry, aka Alex Vasquez, on 2/15/22. He is on special parole for a sex assault against a minor in which he sexually assaulted a prepubescent male that was related to him. The victim reported that he was forced by the offender to engage in penile and oral contact. The victim reported the offender also made him touch his penis with his hand. The victim reported the offender attempted penile, anal, and penetration on the victim, and that the offensive behaviors occurred on more than one occasion. He is a registered sex offender. He is not permitted to have contact with any minors, including his minor son. He disclosed during the full sexual history polygraph that he had multiple minor victims. This means, in addition to the incident offense, he has a pattern of sexually assaultive, deviant behaviors against minor victims. He has a history of repeated victimization of minor males and females related and unrelated to him, further increasing his risk to sexually reoffend. The offender's threatening and harassing behavior has increased over time. I attempted to intervene and modify his actions to get him in compliance with his parole conditions with no success. Given the offender's status as a sex offender and his documented history of violence, and considering the targeted and escalating pattern of behavior, I believe there is significant and growing risk of violence. The transition from passive searching and emailing me to active collecting personal images of my residence and researching my family and threatening to burn down my house signals a deepening obsession and disregard for legal and professional boundaries. He has proven that he has a difficulty controlling his emotions and reacts in ways that create a risk to public safety and to my personal safety, as well as my family's safety. The offender has a history and behavior and pattern of blaming those in authority for his inappropriate actions. The offender's threats and harassment have completely disrupted my life. I've had to live in constant fear, always looking over my shoulder, worried not only for my safety, but for my family's. His actions didn't just affect me, they affected the people I'm closest to. What disturbed me even more was his behavior in the courtroom. While I was testifying, he mouthed the words, "I hate you," at me twice in front of the judge. That moment showed a complete disrespect for the court and authority and made it clear that his intimidation and threat to me is ongoing. I am requesting a full revocation hearing. I do not want to be in fear, or I don't want my family to be in fear for the next 4 years. Thank you.
Thank you. Anything additional from the state?
Yeah, so I'd just like to talk a little bit about his disciplinary report. I don't believe that he's taking this period of incarceration seriously, as evidenced by the recent disciplinary reports he's received. On 10/28/2025 and 11/26/2025, he received tickets for refusing housing, and on 10/23/2025 for interfering with safety and security. These DRs illustrate someone who is continuing to defy authority, not someone who wants to be compliant in the community. And I also just want to go a little bit further on and just make a statement in regard to our recommendation and why. The offender should not be given an opportunity to be released on supervision. He should be fully revoked. Irizarry has demonstrated an extremely assaultive history in many forms, such as assault 1 convictions that include multiple stabbings, sexual assault convictions, and threatening serious bodily harm to authority. Not only does he have a history of assaulting DOC personnel, but now he is threatening even worse to his previous parole officer. He has demonstrated a lifelong history of his inability to control himself either sexually or behaviorally. Even as recently as January in 2025, he pepper sprayed his roommate, who he claimed woke up his minor son that he was not even supposed to be with. This is a spiraling and dangerous pattern of behavior and evidence of escalating threats. I'd like to mention that this is Irizarry's 3rd violation of parole and 2nd criminal violation. He was given 2.5 months sanction for failure to register and 7 months following a technical violation when he had contact with his son. He is not someone amenable to supervision, as he just continues to do what he wants to do despite his conditions. The recent DRs also illustrate his chronic pattern of refusing to comply with rules. Despite parole's attempts to modify Irizarry's non-compliant and violent behavior, he continues to engage in the same. He clearly has a negative attitude towards supervision. Even in a court of law, while he's on trial for threatening parole officer Brayfield, he continued to harass her while she is on the stand. But this isn't just about P.O. Brayfield, this is about anyone in authority. He is violent, unpredictable, and this places anyone in authority in jeopardy. We need to set a precedent here and prevent any parolee from thinking that this is acceptable behavior. Again, this is not someone that should be released. Irizarry's pattern of assault, sexual assault, and threatening conduct is not compatible with the welfare of society. Thank you.
Thank you. And counsel?
Yes, thank you very much. I would like to start by addressing the testimony put on the record by P.O. Brayfield. First, everyone in this room knows what my client is on parole for. That's not a mystery. We have his information. He wouldn't be in front of us if he wasn't on parole for something that carried a significant penalty. So I just want to put that on the record. Secondly, the polygraph results mentioned, I would ask that that not be considered. That nothing of that sort is in evidence here today. We don't have any reports from the CTPSB that allegedly conducted these results. So I do think that that's relevant to bring up. Third, I want to make it clear, my client has not at any point been arrested for a new sexual offense. My client's prior criminal remand had to do with a failure to register, but he has not been arrested since being on supervision for any new alleged sexual conduct. So I did just want to note that. Additionally, I wanted to note concerning the information put on the record by P.O. DeVolder. I did just want to note that, first of all, the pepper spray allegations were encompassed in my client's prior parole violation, which he already was sanctioned for, and that sanction has expired. So I do just want to note that he already was sanctioned for that. We, have already dealt with that. That's not currently part of the present charges that he's here for. Secondly, I want to note concerning the comments about the DRs. This is unfortunate. However, the sad reality is that individuals who are incarcerated for sex charges are oftentimes victimized by other individuals in the facility due to the nature and, kind of consensus and, public view on those specific charges. So I do just want to know, as stated, there haven't been any sort of DRs for violence. Like, I just want to note on the record, it was said that they were for refusing housing and I think the other one was tampering with safety and security. So I just wanted to make it clear concerning that. Now, as far as the conviction, I did just want to put a few more things on the record. What we're speaking about here is an A misdemeanor. The Connecticut General Assembly has made clear that the maximum appropriate penalty possible for misdemeanors is 364 days incarceration, under a year. The specific statute for that offense had to undergo the scrutiny of the legislative process, and that was codified as an A misdemeanor. If the legislature thought that it was appropriate to sentence an individual to more than a year of incarceration for that type of conduct, we would see that reflected in the statute. We don't see that. Additionally, I want to argue that the court in Hartford, after hearing the and reviewing the evidence for this case, found it appropriate to sanction my client to 9 months to serve, not even the maximum allowable under the statute. I would argue that since this was a bench trial, the court had far more information available to it about this incident than anyone in this room does. And after reviewing all of that, the court still found that 9 months was appropriate for Mr. Vasquez. For these reasons, I would argue that the state's argument that Mr. Vasquez should serve a sanction in excess of 4 years runs contrary to what the legislature clearly intended for crimes of this nature, and also runs contrary to what the court in its discretion found appropriate to impose as a sentence. As to the allegations in the submitted statements and from the two POs present today, that my client mouthed threats or obscenities to the complainant during trial, I would just note that I was able to get a copy of the transcript from that proceeding. And the only person in that transcript that I reviewed that alleged my client was mouthing anything was Ms. Brayfield. There was nothing on the transcript indicating that that was picked up by the court reporting monitor. There was also nothing on the transcript indicating that any of the various other court personnel that were present observed that occur. I would further argue that the statement that my client had plans to greatly harm his parole officer from P.O. Ploward in the letter is, I would say, a mischaracterization of the charges and the evidence in this case. Concerning my client's background and history, he successfully completed the January Center in 2020 and successfully completed the Connecticut PSB program in 2022. At the time of my client's remand, he was actually doing the program for a second time and was in phase 2. While in the community, he was working full-time at a catering company, and upon reinstatement of his special parole, he's open to being sponsored potentially by his wife or to utilize the Chrysalis Center's scattered site housing program. As an alternative, he's also open to a halfway house in the Hartford jurisdiction. Ideally, parole should help someone re-entering society, and for quite some time, my client experienced that. Prior to 2024, my client had been on supervision for several years without issue. He dropped down to, I want to say, a couple times yearly, or maybe it was just yearly reporting. And so he certainly is able to cooperate with supervision. Unfortunately, he reports sort of this period of experiencing a tumultuous situation with his assigned parole officer, and often felt that despite his best efforts, he was not being heard and not being given opportunities to see his son with parole's permission. Despite undergoing extensive treatment and having, an appropriate individual designated to be his supervisor with his son, he felt that parole was not, allowing him that opportunity, or at least even working with him to let him know what he needed to do in order to be in good standing. Today, we're asking that you consider re-paroling my client in January of 2026. That will be exactly 1 year since he entered incarceration. It is unfortunate the way that this violation was entered, especially since the warrant in the criminal case was served on my client in March of 2025. And this information was clearly known to Parole and Community Services at that time. However, the parole violation for that conduct wasn't served on my client until he timed out on his prior parole remand sanction in August of this year, which I do think deserves some consideration. Additionally, Additionally, going forward, my client is asking that he be permitted to potentially have parole consider having his wife as an approved supervisor in the visits with his son so that he can go through the right channels to reunite with his family, which he is more than willing to do. The truth of the matter is at some point, my client won't be supervised in the community and he will be off of parole. And so he's trying to make the steps now in order to reunite his family so that, he's able to build that relationship with his son. But he wants to do that the appropriate way. And obviously he knows the appropriate way to do that is with parole officer's permission and with an approved supervisor. Thank you very much.
Thank you. Any additional comments?
Yes, I would like to remark on just a couple of things. So I just want to point out that the testimony by Parole Officer Brayfield regarding the TPSB polygraph, it was actually not the polygraph results that she's talking about. They're disclosures that Mr. Irizarry made during that polygraph examination. So he admitted to those behaviors. You mentioned the pepper spray should not be considered, but I believe that it is extremely relevant to speak on that in regard to his history and background. It just shows the type of behavior that is just escalating and escalating. Parole Officer Brayfield would like to speak on one part as well, if I may call her to testify again.
Yeah. Go ahead, Officer Brayfield.
Okay, I just wanted to touch quickly on the approved supervisor process for Mr. Irizarry. It was made very clear to him, the process, in order to get that started. And he needed to be in compliance with all of his conditions. He was not in compliance with his conditions, and we were working with CTPSB treatment in order to attempt to start the approved supervisor process. We couldn't even start it because Mr. Irizarry was non-compliant. One of the non-compliance issues we had was he went to his wife's house without permission. He was told he can't go there because his son is there, and he decided to go there anyway. In addition, I explained to him that just because he wants his wife to be an approved supervisor doesn't mean that we have the meeting, she's approved, and he can have contact with his son. It may be that he is not allowed to have contact with his son throughout the time that he's on parole, depending on the collaborative model that we have. It's not just we do this meeting and then he can have contact. So, it was made very clear to him what he needed to do in order to even start the process. He decided to not do what was told of him. That's all I have.
Thank you. Counsel?
Yes, I just wanted to say something.
Sorry, go ahead.
One more thing.
Yeah, go ahead.
Sorry.
Officer
I just want to state that Attorney Dean was talking about, the legislative factor of this and sentencing guidelines around it, but this is parole hearing, and I really don't appreciate the victim blaming in this case. We need to take this more seriously in this venue because of the role the victim played in an authority position. Thank you.
Counsel?
Yes, thank you very much. First of all, for the record, I would argue I need to be able to defend my client. And my client has maintained from the very beginning that this was a wrongful arrest. And so I am, just advocating my client's wishes. In no way am I victim blaming, I am advocating. So I just want to make that very clear for the record. Secondly, I want to note, the previously, it was put on the record concerning my client having violent history. I do just want to note, I do have his criminal history printout right in front of me. And prior to that failure to register, which was back in 2024, prior to that, my client's last conviction was in, the incident date was in 2014. So 10 years prior. I think that's relevant to note here. There's no violent history within the last 10 years on his criminal history. I think that's appropriate. I understand there's the most recent conviction. We're not, going against that. But I will just note prior to that, it had been 10 years since he had had a case. In addition, I did just want to note, again, my understanding from my client, and please, Mr. Vasquez, correct me if I'm wrong, but my understanding from him is I believe he had gone through the process with his CTPSB treatment and gotten the paperwork and letters from them on, I think, a couple of different occasions that he had turned into parole. Yes. So I do think that he was, trying to take it upon himself to do the right thing, get those recommendations from his treatment provider before he, came to parole. He understood that this was a process and that it wasn't just a one day, quick check-in, we're finished. But I think that he, took upon himself and did his due diligence to, get that paperwork done and did it, a number of different times. That's, I believe he stated on the record 4 times. And then lastly, I did just additionally want to note that I understand that this is a parole hearing and ultimately parole can do what they want. They don't necessarily have to listen to what happened in court. We're not contesting that. I'm just stating that this conduct was considered by the legislature in crafting these statutes, and this is what they thought the appropriate penalty would be. Certainly, if they thought this was more appropriate of longer incarceration, we would see this as a felony charge or something of that nature. But that's not the case we have here. This is a misdemeanor charge. Thank you very much.
Thank you. Any additional comments?
Just briefly, I would like to talk about the approved supervisor packets. So he can submit the approved supervisor packets, but that doesn't mean the process starts. So he was in CTPSB sex offender treatment. However, his therapist in treatment said that he needs to be in compliance with certain other aspects of his treatment in order to even start the process. So again, I explained to him he needs to be abiding by all of his parole conditions before we can get started. So it wasn't just me, it was sex offender treatment saying we're not even going to proceed forward with even having a meeting, doing a screening call, anything like that for the approved supervisor process because Lewis was not in compliance with certain conditions. He also, I know, I just want to touch on the last conviction you mentioned was 2014. He has been incarcerated for, or I guess the last serious assaultive conviction you said was 2014. He has been incarcerated for a long period of time. Before that, he does have a very assaultive history in which he has assault first convictions. And when he was incarcerated, he continued being assaultive with getting DRs for assault on DOC. Thank you.
Yeah. Any further comments?
Just very briefly from the defense, I don't want to go back and forth.
I was going to just say, we're not going to touch upon that sex offender thing anymore. I think it's exhausted at this point.
Correct.
What's needed and what's not needed.
Correct. I don't want to go back and forth. I just wanted to note for the record that, my client, this isn't the first time he's been on parole. He was on parole beginning in 2020 and was on parole from 2020 to 2024 without issue. So it's not, I think it's being characterized that he can't comply with parole supervision when I believe that he certainly can. And I think that he's proved that for those 4 years where there weren't issues. Thank you very much.
Thank you.
May I speak?
Yes, Mr. Vasquez, I would just ask that you not speak concerning the actual charges and just speak concerning your background and history. The hearing examiner said that we had enough information. We've gone back and forth a couple times concerning the approved supervisor, but if there's something in addition that you want to put on the record, you certainly can at this point.
Because I see what's going on here and I feel like I'm being attacked personally, because of my history and they're not seeing the person that I am. What is being seen is things of my past, things that are, let's say, opinions and not facts. Now, I'm a family man. I've changed my life around. Like Hannah said, I haven't assaulted anybody in 10 years. I haven't caused anybody any physical harm, any emotional harm that I know of. Now, if I did emotionally assault somebody, then that was my intentions. I tend to speak from the mind, and sometimes yeah, my anger gets to me. You know, nobody's perfect. You're all human. You all have anger issues at times. You know, some things bother you. Now, I ask, put yourself in my shoes. If you're trying to become a new person, trying to change your life around, trying to be a parent to your child, trying to be a loving husband or wife, and somebody keeps on hindering and putting walls there, restricting you from doing that, preventing you from doing that, how would you feel? You would be angry. You would be furious, but you wouldn't act on it. Okay, sure, I got hit with threats in the 2nd degree. Okay, I understand that. But what they didn't see was that I was angry. I was very pissed off that I was incarcerated again and I couldn't be there for my family. And your microphone's off.
Thank you so much. I would just say, if I wouldn't speak concerning the actual like conduct concerning the charges here, if that makes sense.
Okay.
Thank you very much.
I'm trying to go back home to my family. My family, since I've been incarcerated, was homeless. They lost a house, and my wife had to go to a shelter with my son because I wasn't there to help my family or to provide for my family. I'm pretty sure you know, almost everybody here is a mother. You know, you would want your son to have his father in his life. Because look at the situation that I'm in. Someone like me wasn't raised with a father. I became a gang member. My history is destroyed because of the things I've done in the past. I'm trying to move forward, trying to give my son something I never had. All I ask is that have mercy on me. Let me try with a new parole officer that doesn't discriminate against me because of whatever reason. I have no idea, but I felt like I was being discriminated against. Like a keyword, felt. Let me try with this new parole officer because the new parole, the older parole officer before the one I had, right? The victim didn't have an issue with me whatsoever. Even when I was the victim's parolee, there wasn't an issue until I was taken from my family, ripped away from my family. Again, I'm asking for mercy. Let me be the father that I'm trying to be. Let me go home. Let me get my life together. Let me do what I have to do. I mean, there is a reasonable probability that I will live and remain at liberty without violating the law. My release is not incompatible with the welfare of society. Your mission is to facilitate the successful reintegration of offenders such as me into the community. Your job here is to reintegrate, help me reintegrate, not to prevent me from reintegrating. Preventing me from reintegrating is incarcerating me over, I wouldn't say petty matters because I understand this is a serious matter. But there are far more serious matters out there to be worried about. The victim is at no point in time going to be harmed whatsoever. And you have my word. God is my witness. I'm not even thinking about her every day at all. My concern is going home, doing the right thing, going home to my family. As you can see, all I'm doing is talking about my family because that's my main concern and doing the right thing. So please, I ask you again, have mercy on me. Thank you.
Thank you, Mr. Vasquez.
Thank you.
Any additional comments from either side? Anything new information?
Yes, I would like to speak to that, just his statement. These are not opinions, these are facts. A family man doesn't put your child at risk when you're pepper spraying your roommate. You're still just sitting here directing blame at authority when you are the one on parole and you're the one that has rules to follow. And you just admitted in your own words that you have anger and it continues to get to you. Even during this hearing, you're telling everybody that you plan on having contact with your minor son as a family man, but you're not allowed to. We have reintegrated and given years of opportunity to this offender, and I really believe that a precedent needs to be set today. Thank you.
Years of reintegration to my family. I don't understand. You're saying that I was given years to reintegrate to be a family man with my son and stuff. My son was just born in 2024.
And Mr. Vasquez, if I may, just very briefly, I would just note that, I don't think his statement by any means is him stating that he's going to have, unallowed contact with his son. But going forward at some point, my client won't be on parole at some point, and he's going to at some point be in his son's life. And so he is just asking for the appropriate steps to move forward in the right way. Thank you very much. Yes. If there's anything that is new, you can put it on the record at this point, Mr. Vasquez.
That situation with the roommate getting pepper sprayed was situated by the police officers at the scene. Police officers checked my hands with their body cams on, by the way, checked with the cameras, and even checked my room. There was no way, shape, or form that there was any chemical agent used by me. There was no way to prove that it was me that sprayed the individual.
Thank you, Mr. Vasquez.
Thank you.
I don't know where they went, so I guess I'm just gonna take a quick moment and then I'm gonna announce my findings at this point. Yeah, I'm gonna just take a few moments. I just want to review everything again before I do make that recommendation. So I'm gonna go off the record. Just want to let everybody know that we are live streamed. So just be mindful of that. So I am back on the record. I have reviewed all the evidence submitted. I've also read statements. I've listened to the testimony today. And I am going to just note some things for the record before I do make that recommendation. So this is a serious offense. Not minimizing it at all. The courts did sentence Mr. Vasquez to 9 months for the threatening second. As stated throughout this hearing today, this is his third violation. The first was a failure to register. He received a 2.5 month sanction for that. The last one was a technical violation, which was the one that expired. I think it was August 25th, 2025. So he received that sanction for that behavior as well. There is a long noted, as stated by counsel, a long noted history of compliance on supervision, as he was released in 2020 to special parole, and his first violation with just that just that, but with the criminal violation, with the failure to appear happened, I think it looks like 4 years later. Again, I did listen to everything, but with that, Mr. Vasquez, I am going to recommend your parole be revoked and that you serve an approximate 1-year period of confinement as a sanction. That's with the re-parole date of August 25th, 2026. And I'm going to recommend the following conditions: behavioral management program for anger management, no contact with co-defendant Terrence Ortiz or Lester Quinteros, no contact with victim MJ and LJ, no contact with minors, a problem sexual behavior treatment and mental health evaluation and treatment as deemed necessary, and halfway house placement with the Hartford location, I think I read listed. And that is my finding and recommendation. So what happens next is that my recommendation is going to go to the board next week on December 18th. On that date, the board can do 3 things. They can adopt that recommendation if they choose to do so. They can lessen it if they choose to do so. And if for any reason they would want to see a period of incarceration longer than what I recommended, they will bring you back for a 3rd hearing to address any questions, concerns that they may have in order to justify or to set a a sanction longer than what has been recommended at today's hearing. So that does conclude the revocation hearing. Any questions?
Mr. Vasquez, I'll set up a legal call with you so that we can kind of debrief everything. And I can also reach out to Jenny as well, just to give her an update on what happened today.
Thank you so much, Attorney Hannah.
Thank you.
So this does conclude the revocation hearing for, sorry, I missed your first name. So Mr. Vasquez, inmate number 297854. All right, thank you, everybody. Good luck to you, Mr. Vasquez.
Thank you so much. Have a wonderful day and have a happy Christmas.
Thank you.
Thank you, everyone.
Thank you, Officer Devine.
Thank you. Bye-bye.
You're all set, Mr. Vasquez. You can go up the CO now.
Okay, thank you.
Thank you.
Wait this morning.
Hello, thank you all for your patience today. I really do appreciate it.
You're welcome.
Thank you. You're Mr. Williams, correct?
Yes.
Great. I think your attorney is here with us, correct, Jones? Yeah, she is. All right, so we're gonna get started.
Good afternoon. And I just, before we get started, you know, I know you have to put some things on the record, but I was able to talk to my client for the first time today. Unfortunately, I'd been trying to speak with him since December 1st. He was moving facilities. Every call I had was canceled. But I was able to speak with him today, and we discussed waiving the preliminary hearing, understanding we would have to do it on the record because of the timing. But I just wanted to place that on the record before you went too far into the hearing.
I appreciate it. Thank you for your guys' patience with me. So yeah, I'm just gonna state that this is a preliminary hearing. Sorry, let's start again. This is a preliminary hearing concerning Javon, did I say that right?
Yes.
Yeah, all right, Javon Williams, inmate number 394033. Today is Thursday, December 11th, 2025. I do just want to accept the waiver by counsel on the record. Conceding to probable cause. With that, the finding will be made based on that waiver, and you will be that is serious enough to further incarceration. So what happens next then, Mr. Williams? I'm sure your counsel explained it to you, but we will wait until those pending charges are disposed of in court and then get you back in for a revocation hearing, okay?
Yes.
Sorry to make you wait all day. Do you have any questions?
No.
All right, thank you, counsel. I appreciate you. So this does conclude the preliminary hearing for Javon Williams, inmate number 394033. Thank you both.
Yeah, thank you. And Mr. Williams, I will be back in touch with you like we talked about on the phone. We will go over in a little bit more detail some of the things that we talked about in preparation for the revocation hearing, okay? Okay,
Thank you. Good luck to you, Mr. Williams.
thank you.
Thank you.
So,
Okay, so I just attempted to call Hartford and it went off the screen again. Alan, I know you just came in about Hartford. Be out in a moment to see.
I will give them a call.
Thank you. Oh, hi.
Hello.
Oh, perfect. So we normally call video one, but it's offline. Are you guys having issues in the video
I don't
one?
know what's going on with it. The screen is completely blank, so.
Okay, I'm so glad I took it then.
All right, so
Perfect.
I'm gonna put him in the room and,
Perfect.
all righty, one sec.
Thank you so much. I appreciate
You're
it.
welcome. No problem.
Officer Barrios, are you able to connect in when he gets in? Are you here still? I know it's been a long day for being connected.
Yeah. This one, first, open your hands. Yep.
This one right here.
Yep, just go in, have a seat right there. All right, and so when you're done, just knock on the door.
All right, thank you.
You're welcome.
Hi, Mr. Briett. How are you?
Good, how are you?
Good. So your officer wants to be present today. She did log in when it was your scheduled hearing time. She said she's gonna try to come back. She's still logged in. I'm just trying to get in touch with her to see if she wants to, if she's around to be able to come in quickly. So just give me a moment and we'll get started, okay?
Okay, no problem.
Thanks.
So I guess they were trying to call that on the first conference room, but that's pretty like. You call on the second, so I'm just letting you know what, here right now. I don't know, do I need to put in a work order for that person? Or? Yeah. No problem.
I'm gonna try to call her. Officer Barrios, are you with us?
Just spoke to Officer Barrios. She's gonna come right in.
Thank you so much. I appreciate it.
Hi, give me a minute, please. I'm getting the paperwork.
Absolutely. Let me know when you're ready.
I'm almost got it here. Hold on.
That's a nice pen. All right. Purple and right to.
All
right. Have a good one.
Okay.
Ready? All right, we are gonna get started then. Thank you. I want to just thank you both for your patience with me today. We were very behind. We're gonna get through this. So good afternoon. I am Parole Officer Trisella, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Millie Briette, inmate number 371781. Today is Thursday, December 11, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Hartford Correctional Center. Can you please state your full name and DOC inmate number for the record?
My name is Willie Briette, inmate number 371781.
Thank you. So this is a public hearing and public access to this hearing is available via video live stream. Present this afternoon is your charging officer. Can you please identify yourself for the record? Yeah, Officer Barros. And you all.
I'm sorry. I'm sorry. I had to close the door.
Oh, that's
for the
okay.
office. I'm sorry.
No, you're okay. Can you just please identify yourself for the record?
Parole Officer Barrios.
Thank you. So this is a preliminary hearing which has three purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show there's probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. I do want to let you know, Mr. Briette, that you also have the option to waive today's preliminary hearing, conceding to probable cause due to having new criminal charges that are pending. What that means is that today's hearing will be concluded, and once the pending charges are settled in court, we will be notified by Parole and Community Services, and a revocation hearing will be scheduled. If you do choose to waive today's hearing, we will review all the rights that you are waiving before we conclude today's hearing. So at this time, Mr. Briette, would you like to move forward with today's hearing?
Yes, I would. Just certain things I won't answer because of, certain things.
Absolutely.
But-
We'll get to that part. Definitely. Then just I'll be reminding you that you have in any case. Okay. All right.
Okay.
So then we're going to go over. So you should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Briette and Officer Barrios, can you both please raise your right hands? Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you. So we're going to go over the procedure for today. So first, I'm going to read your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state will then have an opportunity to address the issue of probable cause and the severity of the allegations. And after the state is finished, you will have the same opportunity. At the conclusion of this hearing, I will inform you of my findings, which will be based upon the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, I do not.
Did you have important rights at today's hearing? So the first is you have the right to be represented by an attorney. You may hire your own attorney, and if you cannot afford an attorney, you may qualify for an appointed attorney to represent you. So Ms. Briette, were you informed that an attorney could represent you at today's hearing?
I was told that I would be able to have, but I'm just, like I said, there's certain things I'll answer and certain things I won't for now,
So you're willing to move forward without legal representation?
Yes, that's fine.
You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
From Ms. Barrios, right, the paper?
Yes.
Yes,
Yep.
I received that.
Yep. You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, I do.
So we're now going to review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. So Officer Barrios, can you please start with charge number 1, the condition of obedience to the law, and then read the violation details? Oh, you're muted.
I always forget. Mute, unmute, mute.
Me too. No problem. Go ahead.
Okay, obedience of the law. On November 21st, 2025, parole conducted a routine home visit at your approved parole resident, 50 Coolidge Street, New Britain, Connecticut. During the home visit, parole officers searched the basement and located a large black bag with presumed narcotics such as cocaine and marijuana in a pink safe that was locked. You admitted that and took responsibility for the black bag and the pink safe. Parole officer also searched your bedroom and a loaded firearm and narcotic items were located in a dresser. The firearm was a high point CF 388 CP serial number P6169425, which you admitted and took responsibility for the firearm in your dresser and narcotic items located on top of the dresser. New Britain PD responded to the scene and a search and seize warrant was issued for 50 Coolidge Street, New Britain, Connecticut, for firearm and narcotic-related items and was granted. Upon the execution of the search warrant at 50 Coolidge Street, New Britain, Connecticut, a large quantity of illicit narcotics and controlled substance were located inside the home, which includes marijuana, 1935 kilograms, aggravated weight, cocaine, 118.6 grams, meth 67.1 grams, heroin 3.7 grams, methamphetamine 16 pills, MDMA 2 pills, ecstasy 1 pill, benzo 12.5 pills, cash 1421 USD, narcotics proceeds, and a scale. The narcotics were field tested and yield a positive presumption confirmation of illegal controlled substance. You were placed under arrest for violation of Connecticut General State 53-217C, criminal possession of a firearm, 21A-279A1, possession of controlled substance, 21A-277. C, operating of a drug factory, 21A-277A, 1B plus possession with intent to sell hallucinogen, 2127A1AI, possession with intent to sell greater, and 21A27AB, 1D, possession with intent to sell 1 kilo or more of cannabis. And based on your behavior, you are in violation of parole condition, obey or loss, obedience of the law. Charge number 2, drugs on 11/21/25. Parole concluded a routine home visit at your home. Parole resident, 50 Coolidge Street, New Britain, Connecticut. During the home visit, parole officers searched the basement and located a large black bag with presumed narcotics such as cocaine and marijuana and a pink safe that was locked. You admitted and took responsibility for the black bag and the pink safe. Parole officer also searched your bedroom and narcotic items were found on top of the dresser. You admitted and took responsibility for the narcotic items located on top of the dresser. New Britain PD responded to the scene and a search warrant, seize warrant was issued for 50 Coolidge Street, New Britain, Connecticut, for firearm and narcotics related items and was granted. Upon the execution of the search warrant at 50 Coolidge Street, New Britain, Connecticut, a large quantity of illicit narcotics and controlled substance were located inside the home, which included marijuana, 1935 grams substance were located inside the home, which include, I'm sorry, I read that already. Aggravated weight, cocaine, 118.6 grams, meth, 67.1 gram, heroin, 3.7 grams, methamphetamine, 16 pills, MDMA, 2 pills, ecstasy, 1 pill, benzo, 12.5 pills, cash 1421 USD, narcotic proceeds, and a scale. The narcotics were field tested and yield positive for presumed confirmation of illegal controlled substance. You were placed under arrest for violation of Connecticut General Statutes 21A-279A, possession of controlled substance, 21A-277C, operating a drug factory, 21A-277AB, 1B, plus possession with intent to sell hallucinant, 21A278, A1A II, possession with intent to sell greater than 1 ounce of cocaine. 21A277, A1A, possession, intent to sell narcotics, and 21A278, B1G, possession with intent to sell 1 kilo or more of cannabis. Based on your behavior, you are in violation of your parole condition or bail laws, drugs. Charge number 3, weapons. On 11/21/25, parole conducted a routine home visit at your approved parole resident, 50 College Street, New Britain, Connecticut. During the search, parole officer searched your bedroom and located a firearm. Loaded firearm was found in your dresser. The firearm was a High Point CF 388 CP, serial number P at 6169425, which you admitted and took responsibility for the firearm. New Britain PD responded to the scene and a search warrant was issued for 50 College Street, New Britain, Connecticut, for firearm and narcotics related items and was reviewed and granted. You were placed under arrest for the violation of General Statute 53A217C, criminal possession of a firearm. Per your parole conditions, you are not allowed to have in your possession or control any firearm, ammunition, or any other weapons. Also, you are registered on the Connecticut Daily Weapon Offender Registry, which prohibits you from possessing or being in the vicinity of any type of firearm or ammunition. Based on your behavior, you are in violation of your parole condition or bail laws, weapons.
Thank you. You've also submitted evidence in support of the case. Can you please identify the evidence for us? Yeah, going back to
You want me to review the evidence?
Yeah, can you please read off the evidence that you've submitted?
Okay, Exhibit A, condition of special parole. Exhibit B, remand of custody. Exhibit C, parole violation report. Exhibit D, notice of parole violation. Exhibit E, New Britain police report, case number 25000-76330. And Exhibit F, 7 photo.
Thank you. Mr. Bria, just to confirm, you did receive the notice of parole violation, the parole violation report, and all the other documents identified for today?
Yes, I did.
And you were able to review all of that information?
Yep. Yes, I was.
We did not receive any exhibits from you at this time. Do you need any time to submit any evidence for your own behalf?
As of right now, no, just the opportunity to just, say there was just one thing in the report that just wasn't mentioned, and that was the one thing that I just wanted to state.
No problem. So we're gonna move on to that then. At first, the state is gonna go first because they have to state the case. So at this time, it is Officer Barrios's opportunity to make a short statement, calling witnesses to testify with respect to probable cause and the severity of the allegations. After she's concluded, you'll have your opportunity, okay?
Okay, thank you.
Thanks. Go, Officer Barrios, would you like to make any statements towards the case?
Really not much, but the charges are clear of what was found that day at the home, and from the search that the police officers render for the warrant, specified more in detail of what was found at his residence, knowing that he is not to be around or in possession of any of these items.
Thank you. And now, Mr. Bria, you're all set, Officer Barrios, sorry.
Yes, yes,
Okay,
I
thank
am.
you. It is now your opportunity to respond to the violation charges against you. Remember, you do have the right to remain silent if you choose to do so. And just, I know you're aware of it, you said what you said, but just remember everything is live streamed, video recorded, and you have pending charges, so just be mindful, okay? So would you like to make a statement at this time?
Yes, the only thing that was in the parole, I guess the violation report that Mrs. Barrios had submitted to me was that when they had searched, they had found everything. I had clearly stated that all of it was not mine. I took responsibility for it because they had put my wife in custody. My 16-year-old son watched, both of his parents get arrested. I made it clear that everything that was down in my basement It was not mine. I had made that clear. I said I took responsibility for it. As Ms. Barrios knows, I said I took responsibility for it, but it did not belong to me. And that's the one thing that I want to be on the record, that I had no idea what was in the pink safe. I couldn't open the pink safe. I didn't have the key to the pink safe. There was no combination to the pink safe. The pink safe had belonged to a deceased friend of mine, which I planned on getting rid of, and it should have not been in my house. And, you know, unfortunately, everything else just, it happened the way it happened.
Okay. Thank you. I do appreciate your statement.
Thank you.
Thank you. Anything further from either side before I do announce my findings?
I just want to clarify, that he did make those statements, but because they're in his residence and we don't have proof of who they are, we have to proceed it that he is responsible for, those items.
Not monitor. The monitor itself is no problem.
Thank you. Mr. Briette, I saw you.
Yeah, the one thing I did want to state is Mrs. Barrios can confirm this. The entire time that I was on parole, I had followed every rule, every order down to a T. I was working. I ended up hurting my back. I was on workers' comp. I provided proof of that I've had back surgery. I've had needles in my spine. Everything that led up to the events, I was in compliance with the entire time. She's never gotten a dirty urine for marijuana, for cocaine. She's never gotten a dirty urine from me at all. She's never had an issue with me reporting or showing up late. I follow parole to a T. This is just an unfortunate circumstance that just should never have happened.
Anything further from either side?
No, I'm set. Thank you.
And we'll just take a quick moment, then I'll announce my findings. So.
Nothing? Damn.
So on charge number 1, Mr. Bria, I am making a finding of probable cause based on the evidence submitted by states exhibits A, C, and E. I'm also making a finding of probable cause for charge number 2, the condition of drugs based on states exhibits A, C, and E, as well as charge number 3, the condition of weapons based on states exhibits A, C, and E. I'm also finding that the acts are serious enough to warrant revocation, and I've also determined that you should be detained while you await your revocation hearing. So we'll notify the records office at the facility. Your parole officer is aware of it now. So what happens next, Mr. Bria, is that once that case is concluded in court, we will be notified by Officer Barrios of the disposition of it and bring you back in for a revocation hearing. At that revocation hearing, myself or another hearing examiner will determine whether you have violated the conditions of your parole. And if so, if it is determined that you did, that hearing examiner will recommend sanction. Will recommend whether your parole should be revoked and if or what any sanction should be imposed at that point in time. Okay. Do you have any questions for either of us at this time or me?
No, just a statement to Ms. Barrios. So I apologize for messing up. This is just a mistake, you know, like I apologize for you going through all this. You know, I was doing good. I appreciate everything you did for me and my family. I do.
Thank you, Brennan. Thank you.
Thank you. All right, so this does conclude the preliminary hearing for Willie Briette, number 371781. Good luck to you, Ms. Briette, and we'll see you once that case is done in court, okay?
All right, thank you.
All right, take care. Thank you, Officer Barrios.
Okay, thank you.
Go on.
I have a question.
Hold on, Alan.
I'm going to go ahead and end.
Thanks.